Welcome to the second hearing of the Portfolio Committee Number 5, Justice and Communities, for the additional round of inquiry into budget estimates 2024-25. I acknowledge the Gadigal people of the Eora Nation, the traditional custodians of the lands on which we are meeting today. I pay my respects to elders past and present and celebrate the diversity of Aboriginal peoples and their ongoing cultures and connections to the lands and waters of New South Wales. I also acknowledge and pay my respects to any Aboriginal and Torres Strait Islander people joining us today. My name is Robert Borsak and I am the Chair of the Committee. I welcome the Attorney-General Daley and accompanying officials to this hearing. Today the Committee will examine the proposed expenditure for the portfolio of the Attorney-General. I also ask everyone in the room to please turn their mobile phones to silent. Parliamentary privilege applies to witnesses in relation to the evidence they give today. However, it does not apply to what witnesses say outside of the hearing. I urge witnesses to be careful about making comments to the media or to others after completing their evidence. In addition, the Legislative Council has adopted rules to provide procedural fairness for inquiry participants. I encourage committee members and witnesses to be mindful of these procedures. Welcome and thank you all for coming and giving us your time today to give evidence. Attorney-General, I remind you that you do not need to be sworn, as you have already sworn an oath to your office as a Member of Parliament. All other witnesses, I also remind that you have already also been sworn before this committee during this inquiry and therefore do not need to be sworn again. Today's hearing will be conducted from 9:15am to 5:30pm. We are joined by the Attorney-General for the morning session from 9:15 till 1pm with a 15-minute break at 11am. In the afternoon, we will hear from the departmental witnesses from 2pm till 5:30 with a 15-minute break at 3:30pm. During these sessions, there will be questions from the opposition and crossbench members, and then 15 minutes allocated for government questions at 10:45am, 12:45pm and 5:15pm. We'll begin now with questions from the opposition.
Thank you. Good morning, Mr Attorney-General.
Good morning, Ms Carter.
You would recall that I think just over a week ago, you, as part of your government's response to youth crime, you extended the bail laws for another 12 months, and they address car theft and serious break and enter and designed to act as a deterrent. Sadly, this morning, we hear about 4 teenagers who stole a car outside of Narromine, have been chased. 17-year-old boy is now dead, and 3 other teenagers are injured. So are your bail laws actually acting as a deterrent for youth crime?
Well, I don't know the circumstances of any of the young people involved in that horrendous event this morning. I just want to extend my sympathies both to the young person who passed away and to his friends and family, but I think that the way you frame that question requires me to be able to say whether, in the context of 22C and reoffending and bail, whether any of those young people had committed serious motor vehicle theft or serious break and enter offences that 22C applies to. So I can't answer that question in the way that you've put it to me, Ms Carter.
Mr Daley, we have a teenager who has died this morning. Youth crime is now having fatal consequences. What are you doing to protect these teenagers from themselves, and what are you doing to protect the community from the outbreak of this youth crime?
Well, that's a different question now to the one you've asked me originally.
I think with respect it's the same, because your government's response was to say we will deter youth crime by increasing the bail laws.
That was one of
You've done that, you've extended it.
That was
and is it working?
That was one of the motivations for 22C, to deter people. The other motivation was to see that recidivist young offenders were not simply put back on the street, that if they had committed one of those serious offences while they were on bail, then they wouldn't be out to do it again. Look, Ms Carter, the issue of youth crime is hugely complex. There are no quick fixes to it. Simply making bail laws tougher won't fix it. Simply making penalties tougher won't fix it. It's very complex. There are many causes for young people who are misbehaving. And I just want to take you to a really helpful article in the Sydney Morning Herald in 2014 by...
Oh, look, thank you, Mr. Daley. We can read the newspaper in our own time.
It's actually quite helpful.
No, thank you. What I want to know,
from people at Moree.
The help that we are looking for is, what are you doing to address the problem of youth crime? What are you doing to stop teenagers dying in the early hours of this morning in stolen cars?
Well, one of the things we're doing is rebuilding the police force that your previous government left hugely under strength.
And
Firstly,
what do you say to the police
let me, you've
who've
asked
had
me a
to
question.
attend an
You've asked me a
accident
question.
scene this morning with dead teenagers?
You've asked me a question, and I'll answer it. And please don't put to me these hypothetical, what do you say to? If I want to say something to someone in the community, I'll say it in my own words and in my own venue and on my own time, and not prompted by you in an estimates hearing. So let's just
This is not a hypothetical. This is a dead
What do you say?
17-year-old.
What do you say to people? That is
There's
hugely
been a point of order
hypothetical.
called.
Now, the first thing we've done in relation to all crime and
Attorney
youth crime...
General, there's been a point of order called.
Thank you, Chair. I understand that passions are running high on this issue, and that's fair enough, but that is not a reason to override the procedural fairness requirements around courtesy. I just ask that you uphold those requirements.
Yeah, no, I do. I uphold the objection. Please, Ms. Carter, allow the Attorney General to speak. Give his answer before you interject.
So,
Thank you, Chair.
the first thing we've done is to commence rebuilding the police force, because I've said before in this venue and in other venues, the surest way to see an increase in the crime rate in New South Wales is to let police numbers run down. That's what happened on your watch. We're rebuilding the police force now. The police force in regional New South Wales, where there has been a shift in the nature of offending en masse. Operation Regional Mongoose is a huge undertaking, and I know that, crime statistics aside, if people feel unsafe in their community, then that's something you have to address, whatever the statistics say. So we have strengthened bail laws. The bail laws, I can tell you, since they've come into effect in December 24, between April and December in 2024, there are 195 first bail appearances under 22C that resulted in a bail refusal rate that's up near 80%.
Sorry, could you just repeat that?
Sorry. Between April, when the new law came into effect, and December 2024, there were 195 first bail appearances when Section 22C applied, and of those, 145 resulted in bail being refused, which is a bail refusal rate of 74%, which means that those young people that were on bail for serious motor vehicle offences who had committed another one were remanded. So they're not on the street committing those crimes. That's the first thing. The second thing is we have embarked upon a range of spending initiatives that you saw in Moree, including a bail accommodation service that will come online soon. There have been more programs like the Safe Action Youth Program that have been wound out across regional New South Wales. So there's a raft of measures that we have implemented in relation to youth crime, but I have to tell you, any talk that one single legislative measure can fix this deep-seated and complex problem is unfortunately not going to be the case.
Thank you for those statistics, and we will come back to explore those later. It is just very unfortunate that those statistics do not address the death of a 17-year-old boy, and this is an issue that I'm sure the whole community wants your government to take very seriously.
Well, we do take it very seriously.
If we could turn to another issue, Minister, are you familiar with the decision in Crown and Halleck?
Sorry?
Crown and Halleck?
No, just refresh me on that.
I've got copies of it here if that would be of assistance.
Sure.
It was a district court matter last year before, before Justice Colfax.
How do you spell that?
Hallak.
Hallak.
Thank you. It was a matter in relation to a cost certificate, and at paragraph 25 of that judgment, the following exchange is provided, and I'm abbreviating but without changing the sense of it. The Crown Prosecutor is recorded as saying, the Crown's case is that the Crown can't prove beyond a reasonable doubt, and later in the same paragraph, the following exchange where His Honour says, then how do you win? Why are we here? And the Crown Prosecutor says, that is a very good question, Your Honour. Look, on behalf of the taxpayers of New South Wales, are we running cases which the barristers admit to the judge have no prospect of success? And if so, why?
Are we running cases?
Well,
I'm
Crown
not
and
sure.
Halleck would appear to be a case where the barrister, the Crown Prosecutor says to the judge,
I'm
we have
not
no
going to
prospects
get,
of success
I'm not
in
going to
this
get into a
case.
commentary on what occurred in that case. It's there for everyone to see in black and white. You're asking me a question about the prosecution of criminal matters. You could put that question to the DPP now or later if you like. I'm not going to get into a running
I might do that this
commentary.
afternoon.
But I do note that the DPP did embark upon a comprehensive review of sexual assault cases, for example, and I was pleased to see media reports that showed a positive impact, a positive result of that examination.
This was not a sexual assault case. Does this matter suggest that we actually need a broader review of all cases where cost certificates have been ordered?
Have you got more than one case? If there was a litany of them, I might agree with you.
With respect, it's not my role to do the audit of these cases, Attorney General. I would have thought you would have had a watching brief on these things.
Okay, then let me say to you...
It's your courts.
Okay, fine, then let me answer directly. There's nothing that's been brought to my attention that would suggest we need that at all.
Okay. Isn't it important for the administration of justice that we are looking at cases in which cost certificates are awarded, and isn't it important for the administration of justice that we maintain public confidence in the administration of justice?
Of course it is.
Well, this case, and if there are others like it, goes to issues of public confidence. If we are wasting taxpayers' money by bringing the wrong cases with no prospect of success, then the public lose confidence in the system, and that's very dangerous for the rule of law, you'd agree.
If that was the case, yes.
Okay, and have you made any inquiries to determine if this is a one-off, or in fact, if there are other matters like this? Should we have an audit of all of these cases?
I've just answered that question. There's been nothing that's been brought to my attention to suggest that's the case.
Have you looked, though, Attorney General?
Yes, I have regular meetings with the DPP, and
So you're aware of all matters in which cost certificates have been ordered?
that's a ridiculous question.
With respect, Minister, it is not a ridiculous question.
Ridiculous question.
It goes to whether we need an audit or
No,
not,
it doesn't. Sometimes prosecutions are successful and sometimes prosecutions aren't, and sometimes when they're not successful, court will award costs.
This is not a question of whether the matter was won or lost. It was a matter of whether there was a reasonable prospect of success, which I understand is one of the key determinants in the prosecution guidelines.
So what's the question?
Well, the question is, if that was one of the reasons that there was an audit of sex assault cases, shouldn't that now also be an indication that we need an audit of cost certificate cases?
I don't believe so, but you can put that question to the Director of Public Prosecutions either now or later. If you're asking me whether I have confidence in the Director of Public Prosecutions, the answer is yes.
Thank you.
Absolutely.
Does this case disclose an issue that indicates that there's a structural problem with the way that the whole ODP is structured? Because there appears to be, if you look at the case, the judge essentially says to the Crown Prosecutor, you need to get ethical advice, and that's exactly what happened. So there appears to be a conflict between the duties of a barrister to only run a case where they believe there is a reasonable prospect of success, and the situation where we have employed barristers who need to accept the instructions of their employer. Is this a structural issue that we need to address?
You've just slipped that decision under my nose now. I haven't had time to look at it. Again, if you want a sensible and informed answer to that question, you can ask the Director of Public Prosecutions, or give me time to have a look at that, talk to the Director of Public Prosecutions and write to me, or we can meet and you can ask me that question at a time where I'm able
I'd be
to
very
more
happy to
informed.
follow up on that, but with respect, that matter was October last year, so I am a bit surprised that it's fresh to you at the end of February 2025.
Are you
but
really,
we
are
can
you
move
really
on.
suggesting that any Attorney General gets informed about the outcomes of every case before the district, local and Supreme Courts? That's ridiculous.
No, but I am expecting that an Attorney General is briefed regularly on matters of concern.
Well,
and this case indicates a matter of concern.
Well, it might not, and the level of concern might vary. So,
thank you, Attorney. Perhaps we can turn to the DV reform.
Could you just inform me about when that was published? That case?
Well, it's dated. The date of the decision is the 11th of October 2024.
No, it doesn't mean it was published then.
I don't know when it was published, but you would be in a better position than me to find out. I can't imagine there'd be a significant delay.
No, I wouldn't be. Yes, there can be a significant delay.
Well,
it might well be that it was only published this week.
but perhaps during the break we can both make efforts to determine that.
Sure. No, I don't think that we need to do that. I think you can ask the Director of Public Prosecutions all
Okay,
about
then
this.
I'm unclear why you're raising this as an issue, but let's move on to something else. The package of domestic violence reforms that you introduced included a commitment that bail decisions would be made by magistrates rather than registrars. Is that in place now?
Yes.
How many magistrates have been employed for this purpose?
So on the weekend, there are, Mr Death can help me out with this, there's 6 acting magistrates in Parramatta on the weekend to hear weekend bail cases, and Mr Death can fill me in on the rare weekday occasions where...
That's right. So the magistrates are now making substantive bail decisions. Authorised justices are still making...
Sorry, it's a bit hard to hear you, Mr Dave. Perhaps you could pull the
Apologies.
microphone closer.
The weekend bail decisions were being made by magistrates prior to the changes, but in regional areas, authorised justices were making bail decisions. As the Attorney just indicated, the authorised justices will be making no bail decisions going forward as of Monday. They're between November and today's date. They've been making very minor items. Bail not applied for or refused where status unchanged, orders where there's no objection, bail continued varied in a call-over environment, and Section 52 variations where there's no objection. Magistrates are making all substantive bail decisions and have been doing so since the end of the year.
And have any additional magistrates been employed for that purpose?
The government, I believe, there was 10 additional magistrates, and I think 6 of those were relating to the domestic violence package from last year as well.
So the Attorney General said that there were 6 acting magistrates on a weekend doing bail decisions operating out of Parramatta, is that right?
That's correct.
And are they part of the total of 10 who are employed?
No, the new magistrates that were employed are in addition to the number of magistrates in total in the local court.
So we have 10 additional magistrates employed plus a further 6 acting magistrates who only work on weekends, is that right?
There were already some acting magistrates operating on the weekend bail courts, and they are continuing.
And so I think the Attorney General, you said that these acting magistrates are operating out of Parramatta, is that right?
Yes.
And so are all bail decisions now being heard through Parramatta?
All weekend bail decisions have been heard through Parramatta.
Okay. So
yes.
all weekend decisions through Parramatta and other decisions being during the week through magistrates. And so the acting magistrates who are employed for the weekend, are they new magistrates or are they people who are formerly magistrates who've come back in an acting capacity?
I'd have to take that on notice. The placement of those magistrates is a matter for the Chief Magistrate, not for me.
Okay. And have they received, if they're new magistrates, what training have they received before they start making bail decisions?
That's a matter for the Judicial Commission and for the Chief Magistrate, but I'll take that on notice.
Thank you. I would appreciate that. And so there's the Parramatta Bail Court that's being established. Is that funded out of the $230 million domestic violence package?
I believe so.
Okay.
There's the 45.
There's a 45 from as part of the Moree-based response from April last year.
So the bail court is the Moree response, not the DV response. Is that right? That funding?
Yeah, it's part of the DV. Yeah.
Sorry, which one? Is
Sorry.
it the $230 million domestic violence package?
Yeah, it's $44 million for justice responses out of the DV package. It was out of the
Okay.
236.
And so
wasn't it?
the centralised bail court, we're assuming
So
is going to cost
245
$45
total,
million?
and a portion of that was for the bail.
Okay, and what's the estimated cost of the bail court?
I have to take that on notice.
Okay, that would be great. Thank you very much. And do we now have AVL links to support remote bail hearings throughout New South Wales?
Ms Carter, we, working with the police and the courts, worked right across the state. That work was completed by the end of December, and I can advise the committee that, yes, that is the case.
Great. Thank you very much. What feedback have you had about the success of the program?
I haven't heard it, that there have been any problems with it.
So the answer to that would be we will monitor. I meet regularly as is the attorney with heads of jurisdiction. I also speak with the police commissioner, and we have an ongoing dialogue. I've heard nothing to the effect that it's not working at this point.
Okay,
Yeah. And I met with the Chief Magistrate earlier this week, and he said it was working well. So,
good.
and he's the one that's responsible, along with Mr. Death, of course,
Yes.
court services, for making sure that
Um,
it's all working properly.
So you may be familiar with the reporting in the Sunday Telegraph on the 22nd of February that there are serious backlogs in bail, which is causing problems for police having to retain offenders in custody for periods as long as 60 hours in one case, when that person subsequently actually received bail. And allegation that bail courts are only allowing a 3-hour window because of a lack of magistrates. What do you say to those allegations?
I think I can help in so much as
Yes.
the police commissioner has talked to me about that issue of queuing.
Yes.
It's a matter which the police commissioner and the acting corrective services commissioner have met to discuss, and there'll be further discussions with the commencement of the new corrective services commissioner this week. It's actually about coordination, and we are working together to resolve it.
As I understand it, though, there are two issues. One goes to the ability of the remand centre to intake, and the other goes to the wait times to get in front of a bail magistrate. So what's happening about that?
I am aware of the first issue only.
And the third issue that we're looking into as well, Ms Carter, and the Chief Magistrate will be talking to the Police Commissioner, is the rate of police bail refusal. We want to see if there's been a change in bail refusal practices. If there is, for example, a reason, if there is, for example, a spike in the bail refusal rate by police that might be putting additional pressure on that system, we want to work out, one, if there has been, and two, if there has been, why.
Okay, thank you.
Mr.
Ms.
Chair.
Mihailuk.
Thank you. Mr Attorney General, good morning.
Good morning, Tanya.
Can I just ask you right from the get-go, the ODPP sexual assault review report was released a couple of days ago. You've read that?
No, I haven't read it. No, I haven't had a
You
chance.
haven't read it?
No, not yet.
Mr Attorney General, were you briefed on this report prior to its release?
I have had monthly meetings, or close to monthly meetings, with the Director of Public Prosecutions. She didn't brief me on what was in the report before she released it. She released it publicly. It's not a report for government.
I know,
it's a
but I would have
report.
thought as the first officer of the state, you would have got a specific briefing
No,
prior to the release.
I didn't request one. I didn't need one.
You didn't request one.
No.
You didn't request a briefing on this sexual assault review report
No,
that
it was.
that we've been waiting for 12
It
months.
was for public consumption, and I have every confidence that the Director
When-
of Public
when do you plan
Prosecution
to
knows
read
what
it,
she's doing.
Mr Attorney General,
get a
when do you
minute.
plan to read the report? It's 40 pages.
When I get
The
a minute.
substance of it's probably about 20. When do you plan to read it?
When I get it around to it in my.
Okay, well, you've come to budget estimates, and I would have thought you might have read the report, so I've got to ask you some questions about it.
Sorry to disappoint you.
Well, you're disappointing the whole state, actually,
No,
Mr
I'm
Attorney
not.
General, because this is a report that we've discussed this issue twice, I think, now, in the course of the last 12 months, the budget estimates. Everybody was waiting for this report to come out. It's been reported in the Herald and in the Australian, so you've got journalists that are reading it, and I'm sure other committee members have read it here, including the coalition colleagues, but I'm surprised you haven't.
It's
All right.
days old, and it was
Okay.
reported. It was released publicly.
Okay,
And
will
and
you
guess
ask
what?
Ms.
Guess
Dowling
what?
for a briefing on
Guess
it?
what?
so
The
you can get
Director
your
of
head around
Public
it?
Prosecutions who owns the report is here, and you can ask her
I
all the
will
questions
absolutely
you
be
want
doing
to.
that, Mr. Attorney General, after 1 o'clock, okay? At 2 o'clock,
Good.
right? At this point, you're here, so I'm asking you the questions. All right, well, let's ask something you might know about then, okay? I'll ask you a little bit about the inciting hatred legislation that passed Parliament the other day. Did you organise a briefing for the Faith Council, Mr. Attorney General?
I'd have to take that on notice, sort of a raft of...
Did anyone from your
three-
office organise a briefing
Well,
for
just
the
let
Faith
me
Council?
answer the question. 3 bills with various groups being consulted on over the weeks that preceded those going into the House, and I'll take that on notice about who was consulted.
Okay, you'll
I
take
think
that on
I
notice.
think
Can you
I-
come, can you
in
come back in
relation
the
to the- in
afternoon with that
relation-
information?
In relation to the hate speech legislation, I think I wrote to the Faith Council, but I don't think that we did face-to-face consultation on that.
Okay. All
But
right,
if
well,
that's wrong, I'll correct it later on in the day.
okay, well, the question was put to Mr. Joseph Laposta the other day of the Multicultural New South Wales, and he advised the budget estimates hearing with Minister Camper that, in fact, there were staff from the AGO and Department of Communities and Justice, and that there was a request from your department and your office to meet with Faith Council. So there was one. I don't know whether members of your staff, though, attended, your direct office, ministerial office, but certainly there were apparently experts from the Department of Communities and Justice. So you're not aware of that? I was going to ask you.
I just said I'll
who
take that on
attended. You'll
notice,
take
but it
that on
might well
notice.
be that there were, as I said, there were 3 bills being worked on
Yes.
at the same time, and
I
various
understand they
matters
had
were
one
discussed.
briefing. I understand they had one briefing.
Yep.
Mr. Attorney General, and I wanted to know what type of briefing that was and whether there were lawyers present giving them a good understanding of what the inciting hatred
I'll
legislation would
just,
mean.
for the sake of accuracy, I'll take that on notice and let you know
Okay.
who was there.
I want to just also put to you, with the 3 pieces of legislation, did the Premier rely on you specifically for legal advice on any of this legislation?
Yeah.
Did he seek, ask you to seek?
Who did he
some-
rely on? You'd have to ask him who he relied on.
Okay, all right. Well, did you meet with the Premier directly over this legislation?
There were meetings with all sorts of stakeholders, and if I did meet the Premier, the contents of that meeting would be necessarily confidential. But we do have many discussions about these bills. Yes.
Okay. I want to put to you, Mr. Attorney General, that the Law Reform Commission did recommended no change to Section 93Z. Why did the government proceed?
We've
such?
been over this issue in many press conferences. It was discussed
I'm not
in
at those
Parliament.
press conferences.
It was
and this
discussed in
estimate,
Parliament.
so
I'm
I'll
not
ask
going to
you.
go over this ground in any great detail again. It was in my second reading speech. Why we did it, it was a great matter of urgency. That's why we did it.
Okay.
And we couldn't wait for
You couldn't wait for the law.
couldn't wait for months of consultation before we
Okay.
amended these laws.
Right.
Anti-Semitism is, and the violence that we were seeing, particularly in Sydney, is something that we had to act quickly on. The Premier's made that very clear, in and out of the House, and we had to act on it urgently.
Mr. Attorney General, the Law Reform Commission's report stated that there would be, and I quote, difficulty in defining hatred. There are, and I quote, differences of opinion in the community about what hatred means. As several submissions observe, this ambiguity makes hatred an inappropriate standard for the criminal law. So how would you define hatred in a way
So-
that is appropriate for criminal law, Mr. Attorney General?
Well, the short answer is, according to the ordinary English meaning of the word, which is why we didn't define it in the legislation. But look, in relation to the Law Reform Commission report into Section 93Z and the legislation that came before the House, I thank Tom Bathurst for the work that he did. He's a great man and he's an eminent jurist, and we're lucky to have him, and we value the work
But you
that he
disregarded
does.
it all.
But his work and the consultation on that work was done before we saw these outbreaks of anti-Semitism, and it's always open to the legislature, and Mr Bathurst understands that, to legislate as it sees fit.
Okay. Well, We'll wait when the Law Reform Commission completes its review into the ADA Act, whether there's a similar attitude for the government to perhaps disregard some of that as well. All right. Mr Attorney General, you're responsible for 18 acts that relate to church trusts and church property. Would you agree that quoting, referencing and discussing religious texts occurs on church property?
Would I agree that it occurs on church property? Broadly speaking, I suppose so, yes.
Yes. And regarding the inciting hatred bill, considering many discussions of religious texts take place on church property, did you discuss the ramifications the bill would have on religious freedom with any of the leaders of these churches whose properties you are responsible for?
Yes,
prior to making that amendment?
I'll stand corrected. I'll correct it if I'm wrong, but I do believe in the consultations that were had prior to the formulation of the bill, that of course those issues were discussed.
With the eight, so you because you preside and you have carriage over 18 church property trusts acts in New South Wales, and are you saying that you had discussions, or your office had discussions with the leaders of all of these dioceses?
No, I didn't say that,
some?
and I don't understand how the acts that relate to trust property has any relation.
Because you worded up an exemption in inciting hatred in relation to religious texts. Well, someone worded it.
You're referencing the answer to the fact that I'm responsible for trust property. I don't understand. So how's the operation of trust got to do with hate speech and?
Well, it's about church property. It's about church property, and I'm asking you a question about. People are discussing religious texts, religious teaching, and they do so on church property. So
those acts are irrelevant in relation to the discussions.
Well, they're not irrelevant
within a place of worship.
They are stakeholders that fall within your realm of your responsibilities.
Yeah.
And I need to know whether, I think the public need to know whether you actually had discussions with any of these people prior to the inciting hatred bill being put forward at the cabinet table.
Yeah, there was consultation about all three bills. They had nothing to do with trusts or church property, and I've already said to you I'll take on notice the...
Who came up with the exemption? The wording?
The government came up with the exemption.
Government. We're not clear on who specifically?
The government's responsible for bills that are brought before the House.
Okay.
Based on advice.
Well, can I ask you to take on notice that meeting that you had with the Faith Council? Apparently there were, as it was mentioned in the estimates the other day, are divergent views coming from the Faith Council about this legislation. Was that minuted, that meeting? Could you find out if it was?
I'll take that on notice.
And if it was minuted, can that be made publicly available?
Probably not, because those discussions with the Faith Council and other stakeholders behind closed doors are confidential unless the stakeholders agree they're not. So many stakeholders will consult with government but don't necessarily want their views being aired publicly. So the starting point for me is that they're confidential.
Well, one of them went to the newspaper, so they were happy to air it publicly.
That's a matter for them, not me.
Thank you. Good morning, Attorney.
Ms. Higginson.
I'm just curious, have you ever seen any evidence that shows that increasing a prison population or an incarceration rate actually reduces crime?
Yes.
You have? Could you share that?
No, I can't.
evidence?
It was when I was the Minister for Police, and we were which was a few years ago now, and I was looking at graphs between the prison population and the correlation between rising prison population and decrease in crime.
I'd be very interested to see that. Is that something that is available?
I don't remember the exact advice that would have been given to me by one of the commissioners or deputy commissioners as when I was Minister for Police, but that's going back, so I don't know what study that would have been. But I'm sure there are many studies about those.
Do you recall what crime it was in relation to?
Crime in general.
In general?
Yes.
Okay, I'd be really interested if there is any way you can inform this committee as to...
No, you asked me if I'd ever seen, and the answer is yes, but it was a while ago.
And do you think it was a well researched, or it was? I'm genuinely
Don't know.
really want to know. 'Cause
Don't know. I'm honestly answering your question. You asked
Okay.
me if I'd ever seen it, and the answer is yes, I have. I
Okay.
don't know.
Do you
it's-
know of any other published material, any reliable sources that we can refer to or find? Because I've looked, and so have many other people, and we're just not really seeing it anywhere available. So the fact that you have seen some is very enlightening, and I would love for this committee to have the benefit of seeing that material as well.
Sure.
You think you would be able to provide that to the committee?
Provide what? I don't.
Whatever it was that you saw.
No, I told you it was back in 2009 or 2010, so or around about that time. There's no way I could reference that now.
Okay, so it wasn't something that anybody else was looking at the time, or that any other
It was a briefing I was given as Minister for Police.
Okay, and so that material that you saw, did that at all inform your views in relation to the introduction of the youth bail laws that you have introduced in New South Wales?
No.
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 Okay, so perhaps then could I ask you if there was any material, reliable material that you had before you to justify the youth bail laws that were introduced 12 months ago? In terms of their effect of reducing crime.
My main concern was driven by reports, discussions, consultation with police and other stakeholders, community stakeholders that I had met, that the Premier had met, that the Minister for Youth Justice had met, and as a collective, we were concerned that there were too many young people who were committing certain types of offences over and over again, and those offences were serious motor vehicle theft offences, serious break and enter offences, and also an emergence of a new crime, which was posting and boasting. So what we were concerned was that there were young people who were committing those crimes, being granted bail, and then doing them quickly again within days or weeks of having been granted bail.
And so to this point, have you noticed a decrease in those offences based on the increased refusals of bail?
I'd have to have a look at the latest Boxar stats if they are available. But as I said when I
it doesn't appear that correlation is happening now. It really doesn't.
As I said when I introduced this legislation, doing studies over very short periods of time aren't necessarily very informative. Boxar often offers the opinion
but Attorney,
that
with
it
respect,
takes,
doesn't the
that
same
it takes a while
but doesn't
to
the
get
same
empirical
view,
studies
but
done.
doesn't the same view and the same logic factor in the rush nature of introducing such laws? I'm not cavilling with your perhaps good intentions of what you were seeking to achieve, but what I think many in the justice system cavil with is the hastiness in the face of all the evidence that incarceration is criminogenic, even in the shortest period stint for a young person, and the likelihood and the very strong evidence that you've now, because of what you have done, over time you will actually have increased crime rates in New South Wales because you have directly impacted that criminogenic factor on all of those young people that would otherwise not be in prisons right now, and particularly the First Nations kids.
Yeah.
Do you accept that?
We've been over this ground, Ms Higginson, both in estimates and in other discussions. Well, we have a choice between allowing those kids to continue to run around in their community with the terrible lives that they have and to keep committing those crimes, and to keep allowing community members to suffer at the hands of those young people who are doing these increasingly violent things, or to incarcerate them and remand them and give them some treatment and to take them off the streets so that at least while they're on remand and until we can deal with them properly, they're not re-offending.
I accept your answer.
It's a stark choice.
I accept your answer.
And there's no easy fix here.
All experts, attorney, as you know, who are on the front line, would say to you that false dichotomy is just untrue, it's dangerous, it's criminogenic, and that there are many things that can be happening. We don't need to lock kids up to feed them, we don't need to lock them up to educate them, we don't need to lock them up to provide them other opportunities.
No.
And I strongly
But
think
when
you would
know,
agree with that.
When you know, or when you have a serious apprehension that if you don't lock them up, they're going to break into someone's house,
not with
violently.
proper diversionary and intervention.
Well, there aren't
and I
those,
think you know that.
They aren't. Those programs aren't in place. That's the problem. And we've spoken about that in this room on 2 or 3 occasions now in the context of raising the age. That's the challenge for all governments, to get diversionary programs
So
in
do you
place.
accept then that because you don't have those programs, or because you're not investing enough in those programs, that said, that those programs do exist, they need accelerating and amping up, and we all know that, and that the efforts now locking these kids up is going to undermine every dollar you invest in those programs. But do you accept at this point that there are some serious voices who are having to deal with these laws, who are making some really serious statements about them? And you would know I'm referring to Justice Lonergan, Justice Rothman, and judges of the District Court, and their comments about these laws. So youth bail laws as a ham-fisted attempt to deal with a political difficulty, and warned that they create significant problems for the administration of justice. Does that concern you?
What concerns me is that if these children are committing increasingly violent offences, and that the people of the communities in which they live deserve protection.
So, Attorney, I accept
that's
that.
The number
I
one.
accept what you're
Community
saying.
safety
How do you
is our
justify
paramount
then?
concern.
How do you justify extending
sorry,
them now?
can you let me answer the question? I'm not going to fluff and waste your time. You know that. So community safety has to be our number one concern.
Mm-hmm.
That's the driver of these.
So how are
these
you
law
achieving
changes.
that? Is the question I've been asking.
Well, we are firstly by making sure that they're not on the street to re-offend, by the initiatives that we announced last year, the $12.9 million of, for example, of expansion of the youth action meetings across the state, expansion of the SAVE programs that I've already referred to, the Safe Aboriginal Youth Patrols, the rolling out of justice reinvestment grants.
Do you accept that it undermines all of these programs when you lock the kids up?
We're presented with no other choice at this time.
Well, that's not what the experts on the front line are saying. Can I just ask, Attorney?
I'd love one of the experts to walk in my door and show me a diversionary program that was left to us in Moree or anywhere else in regional New South Wales by the previous government that can deal with these kids. Because if you find me one, I'll put them there instead of remanding them in custody.
Can I ask
that might be a task for you and all of these so-called experts.
Can I ask which juvenile justice centre you last visited?
Right, juvenile justice centres are the preserve of Minister Dibb.
Can I ask which one you visited?
I haven't visited one.
You haven't visited one?
I haven't visited a youth justice.
So you and the Premier haven't visited one together with Minister Dibb?
No, I haven't.
Have you ever been into a juvenile justice
I have when
centre?
I was Minister for Police, yes.
All those years ago?
Yes.
And you haven't been to one since you've introduced these laws, and you're sitting here talking about all those increased kids?
I don't need to have done that
to
know what's happening on the streets in Moree and to know that the community deserves
And it doesn't
protection.
concern you where you are sending all these young people right now, making them more criminal?
Order.
I trust that Minister Dibb and the department run those facilities in the best way they can.
Opposition?
Thank you. Mr. Daley, I understand that you haven't had a chance to read the audit of the sexual assault cases that's been released by the ODPP.
I'll be reading it over the weekend.
Yeah, no, I understand you've told us that. But I understand that you would have had discussions with various people about matters in relation to that. Do you have
I
any...
was getting reports from the Director of Public Prosecutions along the way about how the report was panning out. So I'm not completely in the dark about what it was doing. I just haven't had a chance to read it yet.
Yeah,
But
no.
I will in the coming days.
Okay, no, understood. Do you have any concerns arising out of anything that you've heard of in relation to the audit?
No.
Do you have any concerns arising out of issues maybe to do with victims whose cases were discontinued as a result of the audit?
Well, do you have any concerns is a pretty loose sort of question. I mean, what I've said before is that it's always a concern when victims and witnesses and people and families who are dragged into the criminal justice system by events beyond their control are disappointed by the outcomes. That's always a concern. But that's a different concern to what I think you're getting at, is do I have any concerns that there are, problems within the office of the DPP?
No, that wasn't my question,
That there's
Minister. That
a
wasn't my
structural
question.
issue that needs
That was
addressing.
not my question. That was not my question.
Well,
did it surprise you that there was at least one case discontinued that had been preparation for years, was charged certified, and was only weeks away from the hearing date at the time it was
it
discontinued?
would depend on what the circumstances of the discontinuance were. If it was,
What do you think the effect on the victim of that discontinuance was?
Oh, that's a different question. That's a different
That's why I'm
question.
asking you. That's the question I'm now asking you.
Well, I don't know what the effects on that victim was, because I don't know what case you're referring to, but generally speaking, if you're a victim and you fervently believe in, your cause, if I can put it that way, and you want justice for what has happened to you or believe has happened to you, and then the matter is discontinued, no doubt you'd be greatly disappointed and distressed.
And so...
And I speak to those people.
I know you do, Minister. I understand that you do. And so you would accept
And
that
I
some of those
speak
victims...
to the DPP about them as well.
That's great. That's very good to know. You would understand that they feel traumatised by this process.
They can, some of them that I've spoken to, in fact many of them that I've spoken to, some are traumatised, some are greatly upset, some are merely disappointed. There's a range of human emotions, but they are often unhappy about what's happened. And I've said on the floor of Parliament in question time, in relation to the Greta bus crash, that it's a disappointment to me when people go through the criminal justice system and they don't get the outcome they want, and no one wants to see that. But we do our best to make sure that they are served.
Are you looking at any changes to the treatment of victims and the information and support that is given to them as a result of conversations you've had around this process?
Yes, I'm talking to the DPP and the department regularly about what supports we can give the DPP in that regard. But I have to say that in my experience, the DPP and her staff are greatly sensitive to the needs of victims. Sometimes, for example, there are quite a number of victims out of the one incident, and not all of their interests align. So it's a difficult juggling act from time to time.
And are you...
We're mindful to try and make it as good as we can for the victims.
No, I share your concern. And are you satisfied that every one of the victims whose matters was discontinued has received a statement of facts from the ODPP explaining why the matter was discontinued?
I don't know if that's the case, but I can take that on notice.
Thank you very much.
That's not something that I would supervise on a day-to-day basis.
I just thought there may have been some people who had drawn that matter to your attention, and I was going to ask a follow-up question on their behalf.
There has been. I think I know who you're referring to, and I've undertaken to that person to find that out. But you have to understand as well, the DPP is an independent statutory office holder, and I don't have any supervision over that office.
Yes.
Thank you, Attorney, and everyone else for being here. I want to turn back to bail laws and young offenders. Now, the bail laws introduced last year, you recently extended those, I think it was last week?
Yep.
Yep. Is there a time limit on that extension?
3 years.
3 years. And in making that decision, did you look at any data around whether those laws were working successfully?
I think I've already answered that. I think I said I'd take those statistics on notice. If I haven't, I will. We're informed by a range of things and a range of discussions, principally by discussions with the police as well, who have reported to us that it's still a battle for them in regional New South Wales in relation to these kids, and we haven't seen any reason at the moment to not discontinue, to let them sunset. In fact, there are good reasons, as I've just explained, to keep them going.
And in that, you said, I think it was 74% have been on refused bail?
Bail refused,
yeah. And that's only for the serious crimes.
Yeah, so the average bail refusal rate, correct me if I'm wrong here, is about 45%, I think, for young people, and the bail refusal rate was whatever figure I gave you before. 74%.
Okay. Attorney, I've got concerns that we have obviously the case this morning with a 14-year-old who was driving. Apparently there's a 13-year-old child in critical condition in a hospital. There's reports last month of allegedly another 14-year-old driving a stolen vehicle, apparently had been breached bail on a number of occasions, killed a man in Moree. Are these bail laws actually working?
I think that's a question that was directly asked by Ms Carter, and I said I'd get you some statistics and show.
I'm not asking for statistics, I'm asking what more can you do?
Well, that's a different question to are they working? So which one do you want me to answer?
Well, clearly it's not working, so I'm asking what more can you do?
How do you know it's not working?
Because you have serious crimes still being committed. You have young people who are allegedly on bail that are committing crimes, whether it's break and enter, stolen vehicles.
Well, let's just
clearly
say,
it's not working.
Let's just say hypothetically that the 80 or 90 kids that have been refused bail now haven't had the opportunity to go out and do those very things. So in respect of those kids that have been refused bail and are on remand and are not on the street and can't avail themselves of keys and cars and machetes to break into houses, they haven't been able to do it. So in respect of those kids, it is working, isn't it?
But only 44% are being held or not given bail. So the remainder
there's 80 or 90 children who were refused bail, who are on remand now and not on the street. So in respect of every single one of those children, the bail laws are working. If you're trying to put to me the proposition that 22C is going to lead to the evaporation of those crimes that are the subject of it, I think you know the answer to that. I think the causation of criminal behaviour is very deep-seated and complex, and no one single legislative or other program is going to reduce that to nil, if that's what you're trying to suggest.
But the Attorney General, my concern goes back to, and I know that there is quite often very complex issues, which is why I'm asking you, what more can you do to protect the community, to support these young people that are out that are getting bail?
Well, I've just read some of the measures that we've put in place.
But you've put in place, but they're clearly not working.
Well, what's your measure of not working?
The crime's going up. People are dying.
Zero crime?
Well, that would be great.
Don't try and suggest
but
this is a simple
I'm
fix.
just saying you've got people who are...
No, I really do object to the way that question's been phrased. It's not working suggests that a single measure that can be put in place to stop crime from occurring. That's never happened in the history of mankind.
I'm not saying a single measure. I'm saying quite often you do need a suite of measures. And that's why I'm asking you, what more can you do?
You're trying to simplify it too much, with respect, and this will take a long time to address. One of the things that can be done is to get diversionary programs in place for these young people, drug and alcohol measures and things like that. I went out in the first weeks of my tenure as Attorney General and opened the Youth Curie Court in Dubbo. And when I was there, I asked people to show me and take me to visit the drug and alcohol programs that were in place for young people that might work in concert with the Youth Curie Court. And you know what the answer was? And I've been Attorney General for a matter of weeks. None. There were none.
And how many are there now, Minister?
I don't know the answer to that question.
Well, Minister,
so-
if this is an issue that you're addressing, where are the drug and alcohol programs that you said need to happen?
That's what we are working on, Ms.
Where
Carter.
are they? You've been in office for 2 years,
Yeah, and
Attorney
you were in
General.
power
Where
for
are
12
those
years and there
programs?
weren't any. So
Where are your
so
programs,
don't come,
Attorney General?
Don't come that with me.
You indicated that this was a long-term problem. Why then were your bail laws only introduced for a 12-month period?
Because we wanted to see what the effect of that temporary bail measure might have been.
And what
at the
effect
end-
did you
and at the
assess
end of-
them as
I've
having?
just answered the question before, if you're listening. I've said we came to the conclusion upon the approach of the 12-month anniversary that we needed to continue them because there were still too many young people committing repeat offences of the kind that are subject to 22C.
Attorney General, you'd be aware of the increase in sexual assaults in Moree, 112% over the last 2 years. Why is it that sexual assault is seen as a lesser crime than motor vehicle thefts?
By whom?
They're not subject to your bail laws.
Sorry, I don't understand the nature of your question.
The question is, sexual assaults are not included in as a serious offence when it comes to the youth bail laws.
That's correct, yeah, I don't understand
And
that.
my question is, we've seen over the last 2 years a increase in sexual assaults in Moree alone, 112%. Why is that not being considered
Because
in the new...
Because it was the nature of the repeat offending of the young people who were committing serious motor vehicle theft offences and serious break and enter offences that had changed and had spiked rapidly, and that was causing particular consternation in the community. That was an issue that needed quick addressing.
Will you consider expanding to include sexual assault?
I've said from day one that all of the many acts that I'm responsible for can consider themselves, if I can personify them, to be in a constant state of review. So if there's evidence before me that a simple legislative measure like 22C will assist in that regard, sure, we'll look at it.
But 112% increase, that's pretty significant.
Most sexual assaults not committed by young people, so that's why it wasn't
Have you looked at the
considered as part
detail of
22C.
what the increase is for young people?
No, I haven't. Well,
Across
it's part of
this-
the Boxar statistics, so I've read those reports and some recent ones have come out this week.
And you'd see that across the state there's been a close to 16% increase alone in domestic violence assaults on young people.
And assaults on young people or
Yes.
by young people?
By young people.
So where's the question?
My question is, we're seeing an increase in assaults by young people, on young people. What is being done? And will you consider looking at further reforms?
We're always looking at further reforms where there's a need to. So yes.
Just moving to the new bail accommodation. Now, I understand you have now got a tender, or someone is actually...
That's a question that's for Minister Dibb and not for me. So
Okay.
I'm not responsible for that facility.
Are you, do you know where young people are currently staying whilst accommodation is being built, or is that not your area?
That's not my area.
Okay. In relation to the posting and boasting offences, which you touched on before, I'm interested to see whether or not you intend to extend that to cover violent assaults, or is it only going to be limited to cars and...
At the moment, the specific measure of, it's 54K, I think it is, that is limited to where it is presently.
So there's no interest to make any changes?
Not at this time, but as I said before, if evidence comes before us that we would need to extend it to other crimes, I'd be open to that. But at the moment, it's not the case.
Okay.
Thank you. If we can turn Minister, to the statutory review of Section 93Z of the Crimes Act that was due on the 1st of January this year. When can we expect to receive that?
The government's response?
No, the report, the review.
When the government's finished considering it.
Well, it was due the 1st of January. It was in legislation that it be provided on the 1st of January. What's the reason for the delay?
It'll be done when the government's finished considering it.
So this was a legislative requirement, and are you saying that the government doesn't treat legislative requirements seriously?
A bit like your statutory review of the Anti-Discrimination Act, which was 12 years late.
Minister, if I said to a policeman who pulled me over because I was going 80 in a 60 zone, I'll drive 60 when I feel like it, he'd say you're breaking the law. Why aren't you in breach of the law? Because this review is 2 months late.
It'll be done when the government's finished considering it, and it won't be too far down the track.
But you were able to introduce amendments to 93Z without actually having completed this statutory review first?
I've already answered why we did that.
Budget estimates last year, Deputy Commissioner Malcolm Lanyon gave evidence that the reason no arrests were made at the Opera House protests over a year ago was because there was no specific individual to whom possible offences could be attributed. You would agree with Deputy Commissioner Lanyon that it's critical for police to make arrests and to deter anti-Semitic speech, that they can identify if people in a public assembly are inciting violence on the grounds of race or inciting racial hatred?
I don't understand the nature of your question.
Police have to be able to identify offenders before they can be arrested. You would agree?
Oh, that's a bit axiomatic, yeah.
So would any of the changes that you have made to 93Z address the issue of the fact that police could not identify the offenders at the Opera House?
I think if you ever look at the legislation, you'll know the answer to that question.
I'd like to hear it from you, Attorney.
That question goes to the physical circumstances around events that might be subject to any laws. And how can...
the question goes to enforcement, and the question
no, it doesn't
is,
go to enforcement.
why
It
are
goes
you
to,
passing
no, it
laws
doesn't go
that
to
you know
enforcement.
cannot
It goes
be
to
enforced?
the evidence that's available to the police to be able to charge someone.
So you don't want to review 93Z, and you don't want to pass laws that will allow your new laws to actually be enforced? Is that what we are hearing?
I don't know what you're talking about. I really don't understand the nature of that question.
I'll restate, Minister.
Great.
The police have said the reason they could not arrest anybody for anti-Semitic hate speech at the Opera House protest back in October 2023 was they couldn't identify anybody. Will your new laws allow police to identify offenders so that they can be enforced?
So how would the police on the steps of the Opera House ordinarily identify offenders, Ms Carter?
If they didn't have masks on their face, why would you not support legislation that would facilitate the enforcement of these laws?
It might well be that no offences were committed, so they couldn't be identified as having been committed in the first place.
Is that your understanding of the police reports from
No, but
the
I
Opera
believe
House?
I believe there's been plenty of public commentary and other commentary and estimates by the police about what happened on the steps of the Opera House, and I'm not the Minister for Police.
And I will take you back to the evidence given by Deputy Commissioner Lanyon, that the reason that no arrests were made at the Opera House protests over a year ago was because there was no specific individual to whom the possible offences could be attributed. What have you done to address
for
that
example,
problem?
because there was a crowd of people shouting and the police didn't actually hear or weren't able to hear, or that they couldn't see with CCTV cameras close enough to see whether people were committing offences.
They couldn't see because faces were masked. People were wearing scarves of various kinds to cover their features.
I'm not sure that's what Deputy Commissioner Lanyon was getting at, but you should perhaps
then
take that up.
What
You should perhaps
discussions
take that
have
up
you
with
done
him.
to make sure these laws will actually work and we can adequately address outbreaks of anti-Semitic hate speech in our community?
Well, we put 3 bills through the House while you were running around the UK listening to right-wing commentators,
point of order.
and you weren't there.
That's
So
inappropriate.
if you were in the House,
Point of order.
you would have heard the many, many hours of discussion about it, and I'll refer you to those discussions.
I repeat my question. What have you done to ensure that protesters can, who are yelling out vile anti-Semitic phrases can be identified and can then feel the force of your laws?
My
Because
job,
otherwise-
my job is
Sorry,
We've only
Chair.
got 1 second.
The Attorney General is being asked a question at such a level of generality that no reasonable
being
person can actually answer that question, and I just suggest it's not reasonable or courteous under the procedural fairness
To that
resolution.
point of order, what have you done is hardly a question at a high level of generality.
Such a
but-
hypothetical question.
All right.
Order. Minister can answer the question any way he likes or not.
The time has
The
expired.
question doesn't make sense. My responsibility is
Okay,
to...
Mr. Attorney General, don't worry about it that way. Okay,
No, thank you.
You.
Thanks for rescuing
So,
me from...
Yes,
You don't
I
need- you
have
don't need
rescued you many
rescuing.
times,
Tanya's got your
Okay.
back.
Can I just go back to this sexual assault review report that you haven't read and that you haven't had a briefing on? But I will ask you, there was an article yesterday.
I will be getting a briefing on it when
You will?
when I next meet the
When you
Director of
next
Public
meet, do you know when that will
Prosecution.
be?
Who knows?
You don't
I
know
have a
yet.
regular
It's
meeting,
not up to
but
you,
when
is it?
I read
Is it up to
when I
Ms.
read the
Daley?
report and I have any questions on it, I'll pick up the phone to the
You'll pick up the
DPP as
phone?
I do now.
Yes.
If I need to have a briefing on it, and call
I would
the
have thought you'd
DPP
already
and have a
asked for a
discussion.
briefing on this. Mr. Attorney
I've
General,
already
I'll leave it,
I've
but
had
I mean,
briefings.
I'm
I've already had many
stunned.
briefings
Okay.
along the way.
Yes, okay. All right, well, were you briefed on the fact that Ms. Dowling sought the services of Sir Max Hill and Professor Julia Coulter to independently review this report?
You can ask the DPP.
Were you briefed,
those,
I'm asking?
You can ask
I'm
the
asking
DPP
whether you were briefed. Were
about
you
those
told
questions.
that they were going to do independently review the draft report?
The DPP had the freedom to do a report into her own organisation as she saw fit and to brief who she saw fit. She doesn't need permission from me. And
I didn't say that she had to acquire permission from you. I'm asking whether you were told that Ms. Dowling would seek the services
I'd have to go back and have a look at the minutes
of
our
the
our
former
most.
DPP of England and Wales, Sir Max Hill, who now works
I'll
for a
take
private
that
law
on
firm.
notice. It might well be that that will appear in the minutes of our meeting, so I don't want to be giving you an inaccurate
You'll take it on
answer.
notice whether you perhaps were notified of that?
Yes.
Okay. Do you know whether he was paid a stipend or fee for his services?
You can ask the DPP. That's not my report.
Which is right there. Can you
That's right.
answer it?
I'm sure.
Ms. Dowling?
Yes, he was paid for his time.
What was he paid, Ms. Dowling?
I'd have to check that.
Can you provide that by this afternoon?
Probably.
You can? What he was paid? Yeah. Was he flown out to Australia, given he
No.
resides in London?
No.
No. Okay, so he undertook the review in London by whatever documentation you provided him?
Correct.
Okay. Did he meet with anyone over Zoom meetings?
No, it was
There was
by
no
way of
face-to-face?
email, I believe.
It was just by way of email. So he conducted the review of this draft report by way of email?
Correct.
Okay. All right. And conducted no meetings?
Correct.
Okay. All right. What about, I might quickly just ask you about Professor Julia Quilter. Did she meet with anybody over the draft
She met with me and the senior solicitor who was administering the review.
Okay. And she was also paid a stipend, if you can also provide what that was, what
Correct.
that fee was? Okay. Thank you. And you'll provide that in the afternoon? That's great. Thank you. Back to you, Mr. Attorney General. Just a couple of quick questions. I want to back to our beloved review of the Anti-Discrimination Act. And again, I've asked you so many questions, and you know that on notice. And I'm wondering where this consultation paper is up to. So, have you been told by Mr. Bathurst, been indicated any kind of date when the consultation paper for the ADA review will be publicly available?
It's not the nature of the Law Reform Commission to give final dates. It's an independent organisation. I don't want to
Yes.
hurry him. I want him to do the job properly, which of course he
Well,
will.
you've given me an answer that it's early 2025, so you've got a note now, so you can refer to that. You've
I don't
told
need
me
to refer to a note.
early
It's up to
2025.
It's up to
It's
Mr.
not.
Bathurst.
You've commissioned the review. It's actually up to you to give the time frame. You've
No.
asked for the review. He
No,
didn't
no,
ask to do this.
I haven't asked for a time frame. I didn't, and you wouldn't do that to the Law Reform
Well,
Commission
you would give
anyway.
some indication. You've given me the date that early 2025. I'm asking, is there anything more specific than that? I've already got that.
No, there's not. No, there's not.
There's nothing more specific than that.
No.
Will you ask for it to be briefed before it is made publicly available? Do you seek a meeting with Mr. Bathurst? As the first legal officer of our state?
If he thinks that I would require a briefing, it might be up to him to come and pre-brief me. Otherwise, happy to just to wait for the report to arrive. That's the nature of what.
But don't you want to be briefed, Mr. Attorney General? Don't you want to be, reading the report before the journalists do and everybody else?
Pre-knowledge of it? Not
Yes.
necessarily. It's the nature of the work.
Why would you not take an
Because
interest?
it's the nature of the work. Don't put words into my mouth,
But you've
please.
just said to me that you don't want to have a report, not necessarily.
Sometimes I
Point of
might,
order.
sometimes I might not. So if,
What's the,
it's the report is an expert.
When's the last time you
Don't just let me answer a question, okay?
You just
the report
mocked
is an
the
expert.
Liberals.
The report is an
Yes.
expert report,
Yes.
and it's not necessary.
That your government
that
asked for.
It's
That your
not
government asked
necessary
for.
that
Sorry,
I
I'm gonna
have
take a
prior
point of
knowledge
order.
of what's in it.
Order,
It's
order.
the contents of the report that I'm waiting for, and its recommendations, and its findings, and its learning. That's the
hear the-
important
I hear
thing.
the point
Not
of
whether
order.
I know about it before any other member of the public
the,
knows about
Attorney
it.
General
That's not
stops talking.
necessary.
My point of order only goes to courtesy. It's just not courteous to the AG or to Hansard, frankly, to have people talking over the top
I
of each
hold
other.
point of order.
Okay, thank you. Mr. Attorney General, can I just also then ask you, you said that there hasn't been a review in the AD Act for 12 years, right?
I think the statutory review is something like 11 or 12 years late.
Right, okay. So this is
Is that
essentially
right?
the
Am I right then?
review.
Not misleading the committee? Okay.
You could take that on notice. I don't and provide proper information on that. What I'm asking is, there hasn't been a review of the AD Act, obviously, for many years. Your government has decided to take it on. I'd like to know that you would take an interest in it, Mr. Attorney General, because and be briefed on it prior to it being publicly released. The consultation paper, I think, is definitely a document that many religious groups, for example, are waiting for a copy of. There are people that have put submissions. Have you read some of the submissions
Yes,
that are
I
now
have.
publicly
Yes.
available? Okay, well that's good, because there are people that and groups that are very interested to see where the government's going to proceed in this. You proceeded already with some changes from the Equality Bill, as you know. You decided not to proceed. You took sections and chunks out of the Equality Bill because you wanted to. You said that you were waiting for a review. And I think people are very concerned. So I'm just asking
Ms.
for a
Mahalik,
public
the way-
commitment
the
that
way-
you'll get
the
on
way
top of
these-
it. That's what I want. I just want you to
Well,
be
I
on
wouldn't
top
have
of it.
referred it if I didn't intend to get on top of it, but the way
Well, you
these
just
things
told
work,
me a couple of minutes ago you may or may not get a briefing on it.
I don't think I need to have a briefing on it before it's delivered. The way these things work, the reports are delivered, they're then tabled in Parliament, and the government issues a response. There's plenty of time for proper consideration. I don't need to know prior to the report being published what's in it. There's plenty of time
Okay.
for consideration, proper consideration.
There's not much that you can say to that, Mr. Attorney General, because I would have thought you'd take a
Well, when
big
you
interest
become the
in this.
Attorney General, you
Well,
can do whatever you want. I'm being open and
Let
transparent
me
with
know
the
when
people
you
of New
become the
South
Attorney
Wales.
General, okay? All right? At this point, you're still a member for Maroubra and behaving in the same way.
Well, you
All right.
were a member for One Nation and now you're not, so I'll stack
Order,
my
order,
credentials up
order.
against yours any day.
Insults are disorderly at all times.
Okay, well then I'll ask you a
Ms.
couple
Mahalik
other
thrives
questions.
on them,
No,
Mr. Chairman.
I'll
Her
ask you a
skin
couple
is
other questions.
10 times tougher than mine.
Order.
Minister, you obviously saw your colleague, your former colleague, Minister Halen, admit to using the driver's car inappropriately, and she obviously took a trip to the wineries. Have you used your driver for any holidays or any
I've
trips
complied with all of the
around New
rules
South
and
Wales?
codes, but I've complied with all the rules they were when they were in place. I'm not going down that rabbit hole today.
You're not going down that road?
No.
Well, I can ask you any kind of question I want
You can.
to.
Order.
I can take them on notice.
I'm sure the AG can answer it, but just a procedural matter. This is a matter for Premier and Cabinet budget estimates inquiry, not for the Attorney General. The opportunity was there to ask the Premier a couple of days ago and it wasn't taken.
To that point of order, this is a question in relation to how the Minister discharges ministerial duties. The Premier surely isn't responsible for how each Minister discharges their ministerial duties. This is entirely appropriate question for AG's estimates.
Yes, of course.
Further to the point of order, this goes to the estimates of expenditure from the consolidated fund
They're reading
in
it
the
two
Minister's
Huh?
They're
portfolio
reading it two times,
responsibilities,
so-
and that is
Oh.
not it.
Right, that was added a
In
sum of
short
nothing
answer to
to
your
all
question, have I
knowledge.
used the driver to go on holidays and things like that? The answer is
Yeah.
no.
Okay, that's good.
Okay. More
He only
questions?
goes to
could've just
Maroubra
let him-
Hotel anyway.
Let him answer it.
Sorry?
I'll leave it.
Have you another
Yeah,
question? You're
I'll
finished?
come back later, yes.
Okay, thank you.
Thank you.
Ms. Higginson?
Attorney, can I just take you to the Community Justice Centre's decision and the decision to close those down? I sent some questions to you on notice, and I have to admit I was very disappointed in the answer. I'm not sure if you're aware of them, but I just asked you basically about
Did sign off on them.
about the reasons and what the plan was for them. It was on the 8th of November. I put 10 questions about the discontinuation of them. What stakeholders were consulted prior to the decision being made, what alternative arrangements are being prepared to fulfil the role, how the closure will impact the workload of the courts and the tribunals, the police force and local councils. And I received a really vague kind of response. It was very disappointing. So, just firstly, were you aware of my question? Did you sign that off?
I've signed them all off.
So you would have been aware of it. Why didn't you give me a proper answer? I just thought it was such a really straightforward set of questions, and I just didn't get an answer to any of
But
it.
the practice of those answers is that I sign the answers that the department has prepared for me.
Literally, the answer: the government remains committed to ensuring that New South Wales community has access. Like, the DCJ will establish an in-house mediation service. This is great, but it basically said for legislatively mandated referrals. Like, I don't know. I'm still none the wiser about what's actually going to happen and what will happen to all of those people who will no longer be serviced, and what will actually happen in the community for,
So under the Crimes, Domestic and Personal Violence Act 2007, there are some, correct me if I'm wrong, Mr. Tibble, but court-ordered mediations, and they'll continue to be done by DCJ.
Yes.
Yep.
And what about all the others? I mean, I've sat in local courts a lot going, oh, there is a CJC we can help you with, more so than people know. I mean, there's thousands and thousands of people that deal with the CJC.
I think Mr. Tibble just wants to list
I,
that.
on notice, could give you the number of matters settled, but over the last 20 years, the demand and the usage has come right off, and there is a question, I think, about the fitness of the model for purpose. And the figure had fallen down to, in full year 24, to 730 mediations. So in terms of the number of matters settled and the outcomes, the model had really was looking, quite frankly, tired, and there is a need for matters to be settled, but the numbers, they simply were not being used nearly as much as they had been historically.
So is the plan then? So is the plan for anyone sitting in a local court who's about to go into a small claims dispute, DCJ will have the same commensurate access to a mediation service? Because I just don't think
Not
that's
for
going to
small
happen,
claims
is it?
dispute, no, only for ones under the Crimes, Domestic and Personal
That's
Violence
right.
Act. That's right.
So we just don't, so then what will happen to all of those? Do we
Well,
not think that they will actually, I mean, we're talking literally about a really important social cohesion mechanism that we have throughout all of New South Wales that sits on the doorstep of where adversary proceedings become painful, bad and expensive. So what is the...
I think we would absolutely accept that those matters, particularly for people who are seeking access to justice and who are economically disadvantaged, that proceedings can be expensive and they can be stressful. What has happened over the 20 years to which I just referred is law access plays in that space, and there are the rest of the infrastructure around disputes with NCAT and a range of other private mediation services. We will have ongoing discussion with the legal professional bodies, with the profession, about how those services may evolve. But I think there is a need for something which is, the need is acknowledged. What we need is something that is accessible and contemporary.
So is there some kind of assurance from you, Attorney General, that I mean, it's quite harsh to hear that the cost benefit analysis or means therefore it's no longer particularly important.
No one said it wasn't important. It's just all about spending taxpayers' money in the best and most effective way.
Okay,
and when you've got a structure of mediators in place with a certain cost, and the number of the demand for their services is shrinking, it becomes mathematically the fact that the cost per mediation increases and they're no longer value for money.
I'm sorry, Attorney General. Access to justice looked through a no longer value for money is a dreadful analysis to be making. We're talking about access to justice, and we're talking about disputes that can.
Well, it's not about access to justice. It's about mediation of.
Sorry, so
disputes,
the community justice
okay?
centres is not about access to justice.
Not always, but arguments between neighbours over trees. It's not about access to justice. It's about trying to find mutual outcomes, and that's not access to justice.
No, normally when we are talking about dispute and we haven't resolved it, we are beyond the issue. We're at actual adversarial disputes within the community.
Sometimes you're not.
No, this is the role of the Community Justice Centre. This is why you cannot measure its value through a dollar matrix or lens. The Community Justice Centres have been around since the 80s, doing some of the most incredible work to divert problems in communities. Like more so than a number on a paper can describe to you. And unless you've sat in the courts as a lawyer or as a legal aid duty lawyer day in, day out, and known that the CJC is there for you, then I don't think you completely comprehend the meaning of access to justice. Those centres are incredibly valuable. So what I would like to know, and I really appreciate the Secretary's comments around there will be a DCJ service for some of those legislative required processes for disputes. But what about the others? Are you suggesting that now they will just have to go and pay for something that they clearly can't afford?
So less than 9% of matters proceed to mediation, and the information I've got is that they are now costing the government about $4,000 per mediation. So that is not value for money. And
so how do you think? How do you propose?
Communities will evolve and find other avenues.
Communities will evolve to find other avenues.
For example, local councils play a valuable role in disputes
okay, so
between
I'm
neighbours over
literally,
trees.
I've got my neighbour who is threatening to kill me over the tree I haven't removed.
Right, well, that's not a
and nor
CJC
should
issue. That's a police issue.
Is making serious threats to me. Okay, so I go to the police. Is
Yes.
that your answer?
Someone threatens you threatens you. Yeah, you go to the police. That's what you do.
Have you ever lived anywhere where you have these kind of neighbourhood disputes?
We're all peaceful in Maroubra, so no, I can't say that.
Throwing rubbish over the fence.
Lives in God's country.
Seriously, Attorney General, it's a bit shocking. So can we just get further to it? So are we suggesting that it will either be a police matter, or those people are going to have to find thousands of dollars to get a private mediator or ring their council? What? I'm going to ring the council and say I've got a problem with my neighbour.
It just depends.
Have you ever tried that one?
Yeah, I've been a councilor. I've sat and...
I'll ring you.
I've personally...
They should ring you.
I've ring my councilor.
Point of order.
Darling, this is a multi-question contribution. It's quite unusual, and I'm enjoying it, but I think it is best to be done in the way of one question, one answer.
Okay,
just to
so
help
point of order, can I just confirm then? So, Attorney General, right now it is the New South Wales government's agenda to now impose more cost shifting to the public and to local government because you're devaluing the public services and demand that the community centres of New South Wales pick up, and you're saying you just can't afford them anymore. Is that right?
No, that's your words.
Okay,
That's your words.
correct the bits. Which bits
that's
did I
your words.
misunderstand?
That's your words. I don't need your words. I've got plenty. Use your words. I've got plenty of my own.
Okay, so So who did you consult with? Just going back to the question I did put on notice months ago that you didn't tell me. Who did you consult with about this?
I'll take that question on notice.
Okay.
No one.
And it was purely a cost benefit. Can I just ask finally, in my last second, will you be, and when will you be, if the answer is yes, following recommendation 2 to repeal the inoperative provisions of Section 214A of the Crimes Act?
That would probably be done by
A MISC bill?
MISC bill or something like that.
A MISC bill? Can I expect a MISC bill soon?
Well, they're regular beasts, I think.
They're very regular, Attorney General,
times a
very
year.
regular. And all your
Perhaps.
people behind you are laughing right now.
They
a
are
very
regular.
nice, yeah, very nice. So very soon.
Two out
It
of
was
four
the
are
answer. Sorry. Was the answer soon?
When I get the advice from DCJ that we need to act, we will.
Thank you.
Okay. Opposition?
Yeah, I just actually want to carry on from the CGC questions my colleague asked. Firstly, what is the
notes then.
current cost of the CJCs?
I can get you that info. I don't have it before me. I can get it for you.
Yeah, if you could take that on notice. And I'm interested also in when the decision that you've made, and they close the 30th of June this year, what is the problem that you want to solve? Like, what was the reason for closing them?
Cost.
But you don't know the cost.
No, it happened in the first of our budgets 2 years ago, when we were having a comprehensive expenditure review, and that savings needed to be identified, and that's where it came about. So
2 years ago, you knew these were closing.
no, 2 years ago we had started having a discussion about expenditure review.
So when did you make the decision to close them?
I'll take that on notice.
And can I ask why you haven't told anyone? Like, you didn't put out a press release, you didn't notify organisations, you haven't notified councils.
We're going back in time now, so I'll need to have a look. I'll take on notice what the communications were that we made.
Okay, and whether or not you actually notified any
I
organisations.
think we notified.
On the communication went out on the 17th of October 2024 to all those organisations.
Saying they'd be closed down in July.
To mediators, but not to...
But that's my question, is about organisations, so particularly volunteer organisations. So you've got your men's sheds, community groups, various others that actually do rely on that service
Well, I don't know
for
that
internal dispute
they
resolution.
can still do those things. No one's stopping volunteer organisations from doing that. It's just
So
the community justice centres and the paid
But-
the mediators that are paid by the government.
So
that-
who would, let's just say a men's shed has an internal dispute,
A dispute.
and who would they go to?
Ms.
Is it an
McLaren-Jones,
internal-
A dispute involving an association would be part of the new service which will be established within DCJ effective July the 1st this year.
Thank you. Attorney, you can see my concern and that of particularly volunteer organisations, and we struggle across the country, we struggle to get volunteers. There's been no communication with these associations. It is clear that you don't know the cost, you don't know the detail.
I do know the costs, I just don't have it in front of me.
But you haven't communicated with these associations that are going to be impacted, and they've got concerns.
Well, I don't accept that. You just heard from Mr. Deeth that that's not the case.
When did you write to them?
Mr. Deeth just told you that they were notified in October.
But was that correspondence to all the associations that would be impacted?
Well, the associations will not be impacted because they'll continue to be serviced under the new service from the 1st of July.
I understand that, and was that communicated to organisations, or what? When you notified them that CJCs will close on the 30th of June, this is what will occur, the detail. Has that actually been communicated, the detail of the next steps?
So just to be clear, I wasn't saying I had the communication went to all those associations. The communication went to the stakeholders that would be impacted by the decision of the government.
And you're saying, Attorney, that volunteer organisations, these associations that do rely on CJCs, will not be impacted?
So I misunderstood the nature of your question.
My question, Attorney, is, first of all, do you actually know what you've shut down and the impact it will have on volunteer associations?
Well, give me an example.
I just gave you an example. You have organisations that rely on CJCs for internal mediation.
Yeah.
And you're now saying that they will need to go through DCJ to resolve those issues. Now, we've just been established they have not, these organisations have not been specifically told of these steps
They
before
will,
that announcement was made.
I'm not sure what the communication was that went out.
There will be. If I can just supplement my earlier evidence, there will be a communications plan by well ahead of the 1st of July to explain for those associations particularly where matters can be referred to the new service to be accommodated within the department. That will certainly be communicated. There has been conversation and discussion with the Law Society, and there'll be ongoing discussion with the legal profession up to July the 1st.
Will any of the associations need to look at changing their constitutions if they rely on
The model constitution, fair trading.
yeah, some of the fair trading?
I do not know the answer to that. I would need to take that on notice.
And finally, Attorney General, my concern is you are the Attorney General, you signed off on these changes, but had no plan of how you would communicate this.
I reject that. I reject that.
Well, you guys
Yes,
can
I
ask
realise that,
it.
but I'll give the 15 minutes to the
Why
government.
don't you guys ask it?
We're now on government time.
Not at this stage.
We are more than satisfied. We have all sorts
I'm
of
banking my
from the
questions. I'm banking my questions. Thank you, Chair. Thank you, Chair.
Mr. Nanva,
No questions from me.
no questions? Thank you. All right, we'll now break for, we'll break now and come back at 11:15.
11:15.
Go online, thank you. We'll resume government questioning, thank you.
Thank you. Thank you, Chair. Welcome back, Minister. If I can just take you back to the issue we were discussing in the first session in relation to what's been called cell ramping, with inmates spending extended times in police custody, awaiting either transfer to remand or awaiting an appearance before a bail magistrate. And Minister, you indicated that you saw that there was a third cause of that, which was what might be perceived as a change in the rates that police were giving bail at, and that you had an intention to talk with the Commissioner about that. Could you explain exactly?
I didn't say either of those things.
Sorry?
I didn't say either of those things.
Well, then could you please tell us exactly what you did say?
I said that a third reason could be that there's been an increase in, as a matter of physics, that there's been a change in or an increase in police bail refusing. I don't know if there is or if there isn't. So I didn't say there was. It could be.
My memory is that you indicated an intention to explore that issue with the Commissioner.
No, I think I said that the Chief Magistrate was going to talk to the Police Commissioner about the possibility that that's occurred and explore as part of solutions to this cell ramping of whether there has been...
So you've had discussions with the Chief Magistrate about this problem?
Yes.
And is the Chief Magistrate concerned that about delays in
If you want to know if he's
magistrate?
concerned, you can ask him.
Well, I don't know that there's a facility for me to ask
Well,
him.
don't ask me what's in the mind of the Chief Magistrate.
I'm asking you about the discussions you've had which led you to make that statement in estimates that there was going to be discussions with the Police Commissioner about the way in which police were exercising their obligations with respect to bail.
Yep. So this is a relationship between the court system, police, corrections. So the heads of all three of those, or senior people in all three of those bodies, are going to talk to each other and see if they can find out what the solution is.
You're coordinating or facilitating that to ensure that this problem is addressed?
I'm not coordinating or facilitating. It's happening on its own anyway, but Mr Tidball might be able to help me out with some discussions about...
I'm happy to ask Mr Tidball detail
They
of
don't
his
need the
questions
Attorney
later.
General to facilitate those discussions.
No,
They
but
happen.
you were the one who drew it to our attention.
Yeah.
My question is, I suppose, what is the purpose of having discussions with the Commissioner of Police about police awarding bail?
Well, as I said, one of the possibilities could be that there's been a change in police practices for some reason, or not, and if there has been a change and they are refusing bail at first instance at a higher rate than they might have been, that would cause more people to be held on remand and would, as a matter of mathematics, be one of the reasons that possibly for the increased number of people. And
No,
I
entirely
don't know if
accept
there is
that
or if there
analysis.
isn't, but the bodies have got to work together to see what the cause of this is.
The question remains, what would the point be of discussing police grant of bail with the Commissioner of Police?
To see if there has been a change in police
And if there
bail.
was, what would the purpose of that communication
to
be?
work out perhaps what the reason for the change was and whether it was justified. But I'm getting
Justified in what way, Minister?
Well, I'm getting into hypotheticals here, but if there
I'm
was,
just following up on information
Yeah,
you
sure.
provided us.
and I've been totally honest with you that those discussions were going to go ahead as you would expect that they should.
You understand that the Bail Act sets out a set of objective criteria which need to be satisfied?
Yes.
And would it be appropriate for anybody to seek to influence the police in the exercise of their duties, whether or not accused meet those objective criteria?
No, it wouldn't. No.
So what is the point of discussing this with the Police Commissioner? Because if you find that there is an elevated rate of police bail refusal, what would you expect the Commissioner to be able to do about it?
Just to see whether there was some misunderstanding on behalf of the police or some misapplication of the Bail Act or some other factor that was, or a change in the...
So you're suggesting that
I'm not
police aren't
suggesting anything.
appropriately educated?
I'm telling you that there could be a third cause for the possible numbers being ramped.
And the concern I'm raising with you is that it would be improper for anybody to seek to influence the police in the exercise of their duty under the Act to determine whether or not objective criteria had been met.
Where was the suggestion that someone was going to improperly
This is why I'm
influence the
asking
police?
what is the purpose of the conversations with the Commissioner if it
Because
is not to seek to change what might be an elevated rate of bail
It
refusal.
might be to seek an understanding of whether there had been a change or not in the first place.
Thank you, Minister.
Do you want to... Mr Tibbles wants to add to that.
Perhaps this afternoon, Mr Tipple.
Thank you very much. Attorney, when did you first become aware of concerns regarding the purchase of electric buses from China and the concerns around modern slavery in the supply chain?
Oh, I don't know when or from whom, but I can't answer that question accurately. I don't know where I got the information from.
Okay. Now, Minister, are you aware that there was a report in 2023? It was done by a Swedish research organisation, Global Works, that said that there's a very high risk of the use of forced labour in China for the production of the batteries. Now, these batteries are used by the two companies that will be supplying electric buses here in New South Wales. Are you concerned that there's been a failure in the adequacy to screen for risks of modern slavery?
Well, that question is probably best directed to the Modern Slavery Commissioner.
Minister, you said that you were aware of the concerns. You're not sure when you were advised about these concerns. Have you referred those concerns to the Modern Slavery?
No, my understanding from discussions with the Modern Slavery Commissioner is that he's already looking into it, and that so are other ministers such as Minister Housos, because the Modern Slavery Act imposes procurement obligations upon government departments.
And will you be, have you asked for a report to be given to you following that review as to if there are...
No, I haven't, because, as I said, the Act places obligations on departments and therefore their respective ministers in relation to procurement, and I don't have anything to do with government procurement.
Okay, thank you.
Thank you.
But the Modern Slavery Commissioner is looking at it and doesn't need the government to refer any of these matters to him, unless I'm mistaken. He has under the Act powers to act on his own accord.
And have you received a briefing or held any meetings in regards to this matter?
No, because as I said, government procurement is not within my purview.
That's fine. Thank you.
Thank you. Minister, in your second reading speech on the equality legislation LGBTIQA+ bill, you said, quote, "The amendments will also create a pathway for parenting orders to be made for children born of international commercial surrogacy arrangements when in the best interests of the child with appropriate safeguards," end quote. Where is the legislation introducing appropriate safeguards from slavery for overseas commercial surrogates?
Yeah, I'm not sure when that actually commences. I think it commences on 1st of July 25. I could be wrong.
Yeah, no, I wasn't asking about the commencement of the legislation. Where are the safeguards against slavery for overseas commercial surrogates who will be used by Australian families?
Sorry, I don't understand the nature of your question.
Well, Minister, you would be aware, because I know the Anti-Slavery Commissioner brought it to your attention and to the attention of everybody else in Parliament, that commercial surrogacy clinics overseas carry a major risk of slavery. He informed us of one clinic alone used by New South Wales families where 97 women were found to have been trafficked into surrogacy slavery. When you introduced this legislation, you indicated it would have appropriate safeguards. Where are the safeguards to make sure that overseas women are not being used as slaves for New South Wales families?
The safeguards are inherent in the Surrogacy Act.
Minister, with respect, the Surrogacy Act was drawn up with respect to altruistic surrogacy. What changes are being made to that Act to safeguard commercial overseas surrogates who are a known slavery risk?
Well, commercial surrogacy is prohibited under the Act.
Yet it is no longer a mandatory condition for the grant of a parentage order for the surrogacy to be altruistic, so it facilitates commercial surrogacy. Where are the protections for women to make sure that they are not being used as slaves to produce children for New South Wales families?
Just have regard to the provisions of the Act. That's where the.
Can you draw me to which provision in the Act prohibits a grant of a parentage order if a woman is a slave?
I don't have the Act in front of me, so I can't.
Can you take
go
that
into
on notice,
discussion.
Minister?
Sure. Happy to.
With respect to that, have you met with the Anti-Slavery Commissioner to discuss appropriate safeguards?
I have meetings with the Anti-Slavery Commissioner. What we've discussed, I'd have to go back and have a look at.
If you could take that on notice, I'd be very
sure.
grateful. Given that New South Wales is now out of step with every other state and the Commonwealth regulations on this issue, have you raised this at meetings of SCAG?
No, I haven't. No, I'm satisfied with the position that we came to under the Equality Act.
With respect to the appropriate safeguards, will these include appropriate safeguards for the child who is to be born as a result of the commercial surrogacy arrangement?
I'll take that on notice. It's all in the Act.
Sorry, what's in the Act?
I'll take that on notice. That's my answer.
Well, when you're taking that on notice, can you also perhaps draw our attention to safeguards, if they exist, to ensure that New South Wales commissioning parents are not convicted sex offenders?
Sure.
Thank you. You understand the risk you understand the history of that risk?
I'll take that on notice.
Thank you. What safeguards are there for spare embryos of New South Wales couples that they will not be sold to the highest bidder?
I'm not sure. I'd have to take that on notice.
Thank you. And how will these laws be enforced in overseas jurisdictions?
I'll take that on notice, and the Act is currently under review as well, so all of these issues will be raised by the department and looked at.
So these protections are in place, or these protections will be put into place?
I said I'll take it on notice,
okay,
but reminded you that the Act is under review as well.
Thank you. Section 17 of the Surrogacy Act requires that an application for a parentage order must be supported by a report prepared by an independent counsellor, and the report must address matters including whether any consent given by the birth parent is informed consent freely and voluntarily given. When an overseas commercial surrogate is the birth parent, how is an Australian counsellor to assess the consent of the birth mother?
I'll take that on notice.
Thank you. If an overseas counsellor is to be used, what's the mechanism in place to ensure that the counsellor is independent as required by the Surrogacy Act?
Take that on notice.
Thank you. Clause 7 of the Surrogacy Regulation sets out the requirements for a qualified counsellor under the Act. Only those registered in Australia or New Zealand are recognised. Are you proposing to change that regulation?
I'll have to take that on notice.
Thank you. Have you been in discussions with AHPRA, RANZCP or the Australian Association of Social Workers about potential changes to that regulation?
I haven't. My department may have, so I'll take that on notice.
Thank you. If you could provide details of that. If the birth mother has not given consent freely and voluntarily, for example, because she's been trafficked into surrogacy slavery, what happens to the child who is born as a result of that commercial and exploitative relationship?
Again, I'll take it on notice.
The equality legislation passed last October considered the law governing prostitution as contained in the Summary Offences Act, and one change was made to this law. Has your department now established an inquiry to consider further changes to this law, which we considered only 4 months ago?
Yes, there's a review of the those provisions underway now.
Why did you decide that this was a priority policy area?
Who said it was a priority?
Well, you've established a review. There's all sorts of things we could review. Why this is a priority for review?
Because during discussions on the Equality Bill, we discussed with Alex Greenwich, who was the sponsor of that bill, if I can put it that way, about the best ways to achieve the objectives that he was seeking, and rather than us agreeing to or disagreeing with the provisions that he put forward, we thought it might be better to sit down with stakeholders and him, and to have a considered review of those provisions, and that's what we're doing now.
What are the terms of reference of the inquiry, and where can the public find them?
I'll take that on notice.
Thank you. When was the inquiry established?
I'll take that on notice.
Is the consultation open to the public, or is it by invitation to selected stakeholders?
I'll take that on notice as well.
Thank you. Is this an area of law reform about which you are interested in hearing from the public?
Of course.
And so this will be open to the public to make
I just
submissions?
said I'll take that on notice.
Right, thank you very much. Can I ask you about when the new funding arrangements for CLCs will be announced?
Pretty soon. So I've written to all CLCs a matter of, correct me if I'm wrong here, weeks ago, to seek their views on how some of the uplift funds offered by the Commonwealth in relation to the new NJAP agreement should be spent. I don't want to make a decision about their welfare without seeking their views. So I've asked them to come back to me by the 10th of March, I think, or thereabouts, with their views on how that uplift should be spent. And when I get their views, we'll make a decision in concert with them. And pretty soon thereafter, certainly I think by the end of March, that funding will be made certain to them.
Thank you.
Mr Attorney General, I'd like to now refer you to the situation around Kathleen Folbig.
Yeah.
I'm sure you're familiar with the situation, but for anyone in the room, Ms Folbig was wrongly convicted of murdering her children and spent 20 years in prison. The Premier recommended a full pardon after evidence proved her innocence. The last time we spoke about this was Wednesday the 28th of August last year at budget estimates, and it was with the Premier then. Yet Ms Folbig is still yet to receive any compensation. Mr Attorney General, can you please explain why it's 7 months on from our last discussion and yet Ms Folbig has not been compensated?
Yeah, it's not with the Premier with respect, Mr Chairman, it's with me. The application for an ex gratia payment is initially my decision. And so this is a complex and in some ways unprecedented matter for me to consider. Very important considerations both for Ms Folbig, for the expenditure of public money, and for the precedent value that the government's decision at the end of the day in relation to quantum will create. The material that Ms Folbig tendered in support of her application was absolutely voluminous. There have also been, correct me if I'm wrong, Mr Tidball, occasions where the department has asked Ms Folbig's team for more information, and they've asked for it and sought it. And in addition to that, I have sought and have obtained and am in the process of considering serious advice on the matters that an Attorney General recommending to the government to pay or not pay an ex gratia payment in these circumstances ought reasonably to consider. I'm pretty close to finalising, to getting through that advice, but I take this matter hugely seriously for all the reasons that I should correct myself, it's not compensation, it's an ex gratia payment, sorry. All the reasons that I've just enumerated, need to make sure I get this right, but it won't be too much longer.
Well, can we have some transparency on the process?
There's not usually transparency when it comes to the applications for ex gratia payments, no.
Can you give us a firm date on when you're likely to make a decision?
No, I can't. No, but it'll be weeks rather than months, I would hope. That would be my expectation.
Yeah, it's been indicated to me that the family and Ms Folbig have been told that it will probably be by the end of March.
I don't know who would have told them that.
Well, that's what they've told me. That's has been indicated
I
to them.
I haven't given any expectations to anybody other than the words I've just expressed to you about time frame.
Okay,
so
thank you.
I don't know, and I apologise if they've been led to believe something that's not the case. It's not my intention to do that.
All right. Well, anything you can do to expedite the process would, I'm sure, be much appreciated by Ms Folbig.
I understand that, but it's a serious matter, and I'm giving it
I understand the serious
due
nature
weight.
of it. Just on another matter, are you aware that of the practice of the New South Wales Civil and Administrative Tribunal of publishing the intimate details of persons' mental health history when disseminating copies of decisions on case law in New South Wales?
Not specifically, no.
Yeah.
You mean publishing as part of their judgments or publishing to parties in the proceedings?
It's out of step with the rest of Australia, actually.
Well, do you want to come and see me about that?
Yeah, I'm happy to.
Okay.
I'll just run through the rest of the questions just to give it a bit more background. And there's case law to support it as well. I can give you that as well.
Sure, I appreciate that.
And then do you consider that it's appropriate, given the proceedings are only an administrative review and they're not a court, not before a court? That's the second part of the question, and I guess you've answered that already.
Yeah, I wouldn't like to comment out without having regard to the specifics of each situation.
And just to, I will come and see you about it, but just to give you a bit more background, and I've got it broken down here. Queensland, South Australia, Victoria, WA and ACT do not publish any of that sort of information in relation to mental health issues on the NCAP decision.
On its face, given what you've told me, that's a concern. So yeah, I'd appreciate you coming to see me, and we'll sort that out.
Okay, I will. Thanks very much. You want to head off? Yeah, you can finish off my time if you want.
Oh, right.
You want to go, Tanya?
Yes,
Sorry.
yes, that'd be great. Thank you.
Thank
I'll
you.
never refuse to ask questions. Mr. Attorney General, I just wanted to very quickly ask you also about reportable donations to the Labor Party, and specifically ones that relate to law firms. And is there a policy directive that you have in relation to ensuring that if law firms have been giving money to Sussex Street, that does the AG ensure that they are aware of those donations and making sure that no work specifically is being redirected to those law firms, or if they are, that they're declared? Do you have a policy to that extent?
You've wrapped three questions into one there, so
Well,
let's...
It's not complicated. So if you
No, but
make
it's
sure that as the
hypothetical,
Attorney
so-
General that
so-
you're aware of the reportable donations. So there are donations that are made from law firms to the Labor Party, and there were in the 22-23 financial period during the election. What my concern is there some type of document before your office ensuring that if that you're made aware, that the department is made aware, particularly given there may be some grants or work being redirected to particular law firms, or law firms are used for the purposes of delivering some of the work that's required in your office or across the department. Is there something that you can, a governance structure around that?
Yes.
It's been a widely established practice of the Legislative Council and to not have questions that pertain to matters of internal political party affairs. I would ask you to request that the honourable member rephrases her question or changes it in some way, perhaps directs it to the Electoral Commissioner, which matters regarding political donations would be more appropriate directed towards.
I'm asking him whether he has a policy document before him, okay, in the Attorney General in relation to how they manage the matters where law firms provide money to the Labor Party, but may in effect also be getting some work indirectly through the Attorney General Department. That's a policy question. It's a
how does this
policy
relate to
question.
an examination of the Attorney General's budget?
Well, it relates to the fact that I'm asking whether he has a policy document before him about how he manages that. That's what I'm asking. Is there a governance structure? Is there something before him on how he manages that?
But that
So it's not specifically...
I think that question's out of order.
Well,
I mean...
I don't see how it can be, because I'm asking him about what policies, how his office manages it, how the department manages it. There must be something. I asked a very similar question the other day of Camper and I got an answer, so that's absurd.
Are you dissenting from the ruling, or...?
Interest protocol, just to keep it...
Sorry?
Perhaps the member could just ask if there's a conflict of interest protocol.
Yeah.
Full stop.
Yeah.
Like, I think that's a fair question. But
Yeah.
Cover up.
Okay.
Is
It's
there
a cover-up, but yes. Is there a conflict of interest protocol? How about that? An easier question for you, Mr. Attorney General.
It's a bit vague, so I'll take it on notice.
I wish you'd have said that
Are you
earlier.
aware, Mr. Attorney General, of, have you made yourself, are you aware of the donations that have been made from law firms specifically? Like,
Directly to the Labor Party?
yes, are you aware of it or not?
No.
Okay.
No, they're all they're published on the
You've
website.
ruled on this.
So-
Like, it's
a
relating to
different
matters
question.
of a political party's affairs. It's completely out of order.
Your budget
in terms of how
estimates.
in terms of how
I think, Tanya...
Thousands of dollars have come
wide
from law
latitude
firms
is
to the Labor
given
Party.
in
I
terms of
think
budget
Attorney General
estimates
should know.
questions, yes, but the rules of the House do still apply to an extent.
Oof,
Right,
very
not in
sensitive
budget
there.
estimates.
They do.
Next to the
No,
former
no.
General Secretary of
No.
the
You
LP,
need
they're
to
very
they're not
sensitive.
strict. They're not...
Order.
Not out the door.
Actually, I'm happy to take this one up. They do. They're not strictly applied, but they're relevant.
They are.
They're not prohibited at all.
Order. I think you should
Protection racket.
Yeah.
try and make your questioning more relevant to the
Yeah.
examination of the budget of the Attorney
2024,
General.
2025.
I did try to ask
expenditure.
some questions previously from Mr Attorney General, and everything was taken on notice, or he hadn't read the reports and so forth. So I thought he might be aware of the fact that you've had dozens of law firms provide thousands of dollars to the Labor Party. I mean, there's some huge amounts of money here. Lee Legal, $4,000. Morris Blackburn, $7,000. I mean, Goodwin co-lawyers,
Point of order, point of order.
$4,700.
Point of order.
$3,300 to
Order,
Jason
order.
Lee. I mean, it's a bonanza.
Would you like to table that document?
Yeah, actually,
You
I
don't
will.
need to. It's on the Electric
I will.
Commission's
I'm
website.
tabling the document.
It's on the
I'll
Electric
table it.
Commission's
Zero.
website. I imagine.
Zero.
Order, order.
I'll table it.
I'd like my pay to get some of that. Order.
I'd love to table it. I was wondering
Considering the number of times shooters get into trouble.
Get back any money to the Labor Party.
Crossbench time now.
Yes, it is. It is.
Ms. Boyd.
Ms. Boyd.
Thank you. Good morning, Attorney General.
Good morning,
Just a
Ms.
couple
Boyd.
of quick ones from me. The first one, the Independent Victim Services Commissioner I've been asking about for a little while in estimates. I understand a discussion paper has gone out, but it's not public. Can you give us an update on where this is up to?
Mr McKnight might be able to give us an update on that, or Mr Tickle.
Yeah, we are currently undertaking consultation. Let me see if I can get you dates.
On the model of what the new Independent Victims Commissioner might look like. We've asked groups to give us their views on what the model of the new commissioner should look like.
So a discussion paper
here we go.
was distributed to stakeholders in January this year.
13th of January.
Okay.
And it seeks submissions by the 21st of February, so last week. And it goes to the model of the commissioner structure.
Okay.
Yeah.
I'm glad to see that this commitment progressing. When will that discussion paper be made public, or when will there be some public consultation as opposed to just select stakeholders?
I'll need to take on notice the detail of the process.
Yeah, that would be really helpful. I think there's a great number of people very interested in having a say.
Yes.
I'd hate to get to the position where we have a bill in front of us and it's not widely accepted at that point. Let's consult beforehand. Thank you. The other one was just...
Could I just say, you might be interested to know, our intention is to introduce legislation to cement that position, create that position in this session of Parliament.
Oh,
So
excellent.
before 30th.
Excellent.
Yeah.
As I say, I'm very happy to see it progressing.
Yeah.
It would just be nice to get a little bit of a briefing beforehand or some sort of public
Just come
understanding
to
of it.
my office and we'll give you whatever you need to know.
Thank you. So, yeah, the other one was in relation to industrial manslaughter. During debate on the bill that brought in the industrial manslaughter offence, assurances were provided that the Office of the Director of Public Prosecutions would establish a separate identifiable team with specialist expertise in that area. What is the progress of establishing that specialised unit?
You might want to ask the Director herself, if you like, but I understand that's been given consideration.
Ms. Daley?
We are still sorting out the funding for that, and we are working out the terms of the Memorandum of Understanding with Safe Work in terms of what the brief will look like when it comes to our office.
Okay. Is there a time frame for when that will be in place? I'm worried we're going to get a prosecution and not have the specialist expertise in place by then.
It's well underway. I'll have to revert to you on
notice.
On the time.
Yeah, that would be great. Any details you can give me on notice would be great.
Sure.
I will hand back to my colleague.
Thank you. Attorney General, I just want to go back to the questions the Chair asked briefly about Kathleen Folby and the submission there. When you say it's very voluminous, so like how much are you talking? How big are you talking the submission?
I didn't count the pages, but there's a lot of material there.
All right, and you're personally reading that? You're going through it? Because my understanding is it's not that big, but anyway, I've been informed that it's probably really only about 300 or so pages long with some appendices.
I didn't count the material.
All right.
Count the numbers.
But so you absolutely commit and guarantee that that's in your hands. You're reading that.
Yes.
Personally.
Yes.
And are your concern? Do you have concern that you may be setting some kind of precedent over what you're doing in relation to that?
Not in terms of a legal precedent or laying down a guide or a rule book that people might follow, or that judges might, in terms of the common law, set down the rule for attorneys general in future to follow. But it's a unique situation.
Well, that's the point. It is very unique.
And so I can tell you, had regard to other circumstances, and there are none that are directly analogous to this. So yes, there will be some precedent value, if I can put it that way, for the future, whichever way I decide.
And your guarantee is that it'll be very soon. I'm watching on the ABC TV at the moment during the news breaks that people have released books about the scenario and the situation, and Kathleen still hasn't. People are writing about this as if it's some historic thing, and it's not. She's obviously living every single day without that level of justice being afforded to her.
And there is considerable public interest in this, and I've absolutely not tried to delay this at all.
Thank you. I just want to go back to the CJCs very quickly. The cost-benefit analysis that you've undertaken, is that something that you would provide to the public? Is that something that can be made available?
I'll take that on notice and see what the status of that is.
Thank you. And what I'm concerned about, or what I'd be interested in, is, how has that cost-benefit analysis really factored in the actual benefits, non-cost benefits that you could tangibly put on a balance sheet that the CJC services provide? Because we, as I explained, I know firsthand, but the real costs is the empowerment that these services provide every single time they operate or have a touch point, and the exponential benefits that provides through building skills in the people they interact with, the way that they are undertaking preliminary interactions, not just the actual mediations that take place. And Attorney, I'm just going to put it to you and ask you, would you consider a different course of action? Because it does seem, when you look at this through a proper lens, not just a rough cost-benefit analysis lens, in the one that I suspect is in front of you, would you take a different course of action? Can you be convinced?
No, I don't want to mislead you in any way. I certainly don't want to downgrade the work that the mediators do. There'll be no change. This is a government decision. There'll be no change to this.
So when you say it's a government decision, how has that happened? It's
part of a budget.
But you are the Attorney General. You can submit to Cabinet and others that we may have made a wrong decision, that this service is actually fundamental and we would like to continue it. And after proper review and consultation around it, because it appears that there has been none.
I don't want to mislead you, that's not going to happen.
Because you won't do that?
Yes.
Why won't you do that if a case is made to you that you're making a bad decision?
Because the government's already made the decision and it won't be revisited.
So governments are just happy to cop bad decisions?
Well, that's your view.
If the evidence
We've got to
suggests,
make sure that we spend taxpayers' dollars in the best way we can.
But if the evidence could be presented to you, if this had been done with more consultation and the case could have been made more clear to you about what we are actually going to lose and the higher costs that we'll experience because of the loss of that.
I'd never say no to someone who wants to try and talk me out of something. So if you or others want to try and do that, I would never say no, but I'm just being honest with you. The likelihood of this decision being reversed is pretty close to nil.
But you're open?
Always open.
And
Mr. Tidball might have some figures that you might be interested in too. We've had a sort during the break, if you would like him to.
Sure, yep.
Just, Ms Higginson, very briefly, I spoke about not so much the cost, but the number of matters. So in 2005, which was on the advice I have, was the peak of the utilisation, the number of mediations arranged was 3,259. In 2024, that number had fallen to 796.
Yep.
In 2005, the number of mediations held was 2,812, and last year was 728.
But so in terms of those numbers in that matrix, though, are they mediations completed? Are they intakes? Like, I understand what picture can be painted with those numbers, but I'm curious
I
as
can,
to the inputs to those numbers.
So I think what I can provide to you is the number of from mediations held, inquiry to mediation held. Look, I do actually have percentages of of resolution which I can provide on notice.
Do you want to get that on notice? And we'll
I
give
think
some
that would be
detail
helpful.
breakdown?
I am just going to put this to all of you. I think that this is just something that has happened, and we understand how these things happen through all sorts of good intentions to streamline, to get efficiencies, to cut costs. But I think that what is quite clear is there's a case to be made that this is not a good decision, and that the government should seriously consider reconsidering this decision, even deferring this decision for a period of time.
Happy to receive any representations from you or other people in that regard.
Thank you.
But I don't want to mislead you.
Thank you.
Hopefully
Thank you, Mr. Daley. Just wanted to follow up in relation to what's happening about the electronic monitoring of alleged DV offenders. That is operating now?
Yes, it is.
It is. And with respect to the funding for that program, is there a capped number of offenders who can be monitored electronically?
No.
So it's completely open-ended funding?
Yes.
And is demand tracking as you had expected, exceeding, not meeting?
I don't think we had any expectations about it. So
Okay, so you didn't factor
There's
something in for funding?
There was a box projection that was undertaken, and as I understand it, we're tracking within that projection.
Thank you. What number of serious DV offenders given bail are currently being monitored electronically?
88.
88, thank you. And is the electronic monitoring equipment available in regional centres and in the city?
I believe so, yes.
Okay, so there's no sort of black holes where it's not possible to be monitored? Happy for you to take that on notice?
No, the answer to that question is it is intended to be state-wide, but I'm always very reluctant with questions about technology to
Oh no, look, I understand the
underwrite
intention. This was
the
not a
reception.
gotcha. This
Yep,
was
yep.
I just wanted to understand what's happening, and happy for you to take that on notice, because I think it is an important question to understand exactly what the coverage is. How many alleged serious DV offenders have been retained in custody on remand, and is that an increase on previous figures, decrease, stable?
I don't have those figures.
I may have that. Can you just give me a second?
Certainly.
The rate of court bail refusal for adults charged with DV offences rose markedly from 4.2 percentage points to 21.7% in the second quarter of 2024, so between April and June, compared with 17.5% in Q1.
And that's all attributable to DV?
Yes.
Great, thank you very much. The implementation task force, I understand, is not still meeting, so who's responsible for monitoring the ongoing operation and success or failure problems, or who troubleshoots now?
It's in the hands of corrections.
It's in the hands of corrections. However, I am working closely with corrections, and given the role I have bridging across the certain oversight functions of corrections in a relationship with DCJ, I'm also briefed regularly.
Great, thank you very much. If I can take you to another topic, Minister, I understand that you have recognised the increasing volume of work and the increasing complexity of the work that's undertaken in the local court, and so the intention is to amend the Local Court Act to introduce the title of Judge of the Local Court. What other changes are you making to support the work of judicial officers in the local court?
In what respect?
Well, will each judge receive a dedicated tip staff like some of their district court and Supreme Court colleagues?
No, they won't.
Even though you've acknowledged the volume and the complexity of work has increased markedly?
Yes.
Will each judge receive a dedicated research officer or associate?
I can cut this line of questioning really short. The only change in entitlements will be the change of name. There'll be no other change to any other entitlements, if I can put them that way, or remuneration or support at this stage for magistrates in the local court. That was intended to be a standalone change, which they've been pushing strongly for quite a number of years. And I explained to the association and others that did not mean that we were necessarily, as part of that decision, going to automatically start to look at other entitlements or remuneration or package, if I can loosely call it that.
Well, with respect, how is simply changing a name actually recognising the, and to quote you, seriousness, volume and complexity of work in this jurisdiction if it's not accompanied by other necessary workplace support?
Well, because the magistrates asked for it. That's why they really wanted the change. They asked previous attorneys general for it and were refused. It's important to them.
So if they asked for tip staves and for associates, they would also be given?
No, no.
Well, sorry, with respect, your reasoning was they asked for it, they got it. If they asked for other workplace supports, would they receive those?
If you hadn't interrupted me, I was in the process of saying that I view the title of magistrate to be anachronistic. It's also a problem, not a problem, but we had feedback from people in non-English speaking background.
I don't think we have any dispute about this. I'm simply looking at whether they are being adequately recognised in other ways. Perhaps we could move on to BA and the King. I know you'll be familiar with this. I think this is at least maybe the fourth estimates at which we've asked you questions about this.
Third, I think.
Last time you told us that you would be introducing a draft bill into this Parliament in early 2025. It's now early 2025. Where are we at?
Yes, so this is a complex area of the law, and
as you indicated last time.
It needs careful analysis.
As you indicated last time.
What I asked, nothing's changed in that regard, has it?
That's distressing, though, isn't it? Because it should change. This is a May 2023 decision, Minister.
Well, if you stop interrupting me, I might take you through it. So what I did was ask the department not only to look at the specific provision that was the subject of BA and the King, but look at the whole division of the Act that it lived in, because it was quite old and had not, for the present purposes, been reviewed for a very long time.
As the High Court indicated.
What happened during the course of the consultation was that domestic violence groups were particularly concerned that changes, such as those embodied in the Shadow Attorney's Bill, and in some of the possible remedies, if I can put it that way, to the problem outlined in BA, was that it might lead to an inadvertent victimisation of women who were the victims of domestic violence, who were trying to return to their own homes. And they impressed upon us that they were very, very concerned about that and cautioned us to keep talking to them about that, and that's one of the reasons it's taken so long. So we're still considering it.
Still considering. You would be aware, because I'm sure you've had an opportunity to read that judgment by now, that, as the High Court indicated, the ACT, Tasmania, Victoria, South Australia, the Northern Territory and Western Australia have all managed to amend their criminal law and bring it into the 21st century. Why is this such a difficult problem for New South Wales?
No, I don't think I can add anything usefully to my earlier answer,
right, thank
Ms. Carter.
Just following on from that, do you have a time frame?
No.
But will it be this year or
I don't have a
before the
time
next
frame.
election?
Means I don't have a time frame. Sorry.
Can I move to the use and carrying of knives in public spaces and schools, and in particular sections 93 IB and 93 IC? What has the impact of these changes made
I'd have to take that on notice. I suppose I take it that you are referring to the crime stats.
Yeah.
I'll take that on notice. These are all set out in Boxar reports that are publicly available.
And that, I've got to say, is a concern that you've got an Attorney General, those latest figures came out over a week ago and you haven't even cast your eye over them.
Who said I haven't cast my eye over them?
Well, because every time I ask a question in relation to any figures around Boxer, you basically
Okay,
have
then
no
do
answer.
you want to sit here and wait while I turn around and get a note?
I'm
It'll
happy
take me
to,
5
happy
minutes.
to tell you,
No,
because
no,
I've
we'll
got a
do
copy
that.
here.
Let's go.
They
How are we
haven't
going with
changed.
that note?
You've got a police conviction.
Attorney General,
Right.
I can
No,
let you know it
fine,
hasn't
good.
changed.
It's not a memory test.
No,
I'll take
no,
it
it's
on
not a
notice.
memory test.
Thank you.
But I'll just let you know they haven't changed. So my question is...
And nor do I want to walk in here with 10 feet of reports to the sky and have to sit down and wade through them every time you ask me a question.
I'm not
It's
asking
publicly
for
available.
specifics. It's just basics around the legislations that you've introduced, whether or not
Sure.
you're seeing things work. And that's the simple question in relation to 93
Okay.
I, B and C. So, Attorney General, are you monitoring whether or not the changes you brought in have been effective in any way?
Boxar publishes those statistics, and we look at those statistics. We also talk to the police about what their anecdotal experience is on the street. But I just got to say to you, the statistics only tell a part of the story, particularly in relation to things like knife crime, drug possession, sexual assault, because there are other factors that can affect and skew the results. For example, if the police, as they often do, run big operations that target hotspots in Sydney and go looking for people with knives, that will skew the result. So it's very hard in a short snapshot of time to get a picture of how the change in legislation might be working, if you want to put it that way. In the same way as increased drug operations lead to Boxar statistics getting skewed. In terms of public awareness campaigns for the unfortunate victims of sexual assault and encouraging them to report, it leads to a higher incidence of those being reported. So it's, statistics tell a part of the story, but not the full part.
So, Attorney General, if you're not confident with the statistics...
I didn't say I wasn't confident with them. I say you need a good time frame to have a look at the trends and to take them into context with other factors as well.
So when will you be doing, I suppose, an evaluation?
But the conviction rate's up.
Yeah, okay. Attorney General, is it true that by doubling the penalties from 2 years imprisonment to 4 years, you were exceeding the jurisdictional limit of the local court, and that these matters would need to proceed by way of indictment to the district court before any penalty could be imposed?
Well, often they're charged with other offences, which means that you can take them to the district court, but I think they're table offences too, aren't they, Sally?
Yeah.
The table offences and off, so there can be an election to take it to the district court by the prosecution.
As of September last year, the Office of the DPP has declined to elect to prosecute 96 of 141 election referrals from police, which is about 2/3 of referrals. Is this an indication that your laws are not working?
No, you'd have to probably look at the circumstances of each and every one of those cases and the reasons for election or non-election to be able to make proper sense of that question.
And have you done that?
No.
Why not?
Because that is, unless someone indicates to me, unless the DPP was to indicate to me, as she does from time to time, that there's a shortcoming with the legislation, then I'll act if I get that advice, and if not, we keep going and review these issues from time to time.
But if the Office of DPP chooses not to notify you of the fact that 2/3 are not being referred, have you got another mechanism to monitor that yourself, to be able to raise it directly?
No.
Is your office looking at any of those issues?
We look at Boxar statistics and things like that periodically, but your question goes specifically to whether or not the prosecutor decided to make the election, and that would depend on a case-by-case basis.
And you're not looking at any of that?
No, I'm not, unless the DPP comes to me and says there's a problem with the legislation. I won't look at that.
Attorney General, how many people have received a jail term in excess of 2 years for custody of knife either under Section 91 IB or IC of the Crimes Act?
Unless someone's got that at their fingertips, I'll take that on. In fact, I'll just take it on notice.
Okay. Attorney General, have you seen the Sentencing Council report on firearms, knives and other weapon offences?
Yes.
And you would recall that in your second reading speech, and I quote, these reforms will be complemented by any recommendations or findings arising out of the Sentencing Council review. When will you be responding to that report?
In due course. I
Do you
don't
have a
time frame on that, no.
That seems to be a pattern. Either you don't look at reports or you've got reports, but you won't give us time frames.
Who said I don't look at reports?
Okay. Too many questions.
Which report did I say I didn't look at?
I've got one CLC. If I can just jump back to CLC funding, you would be aware from correspondence that the CLCs are anticipating a major increase in demand in work with the closure of the CJCs. Are you going to provide additional funding for them to cope with the additional work they'll be receiving when the CJCs close?
Well, I indicated to you that I have written to the CLCs and asked them for their indication as to how the Commonwealth Uplift Funds, if I call them that, might best be distributed across their number of officers, and I expect that if that's an issue, they'll be bringing that to my attention.
And local councils have also indicated that they expect a significant increase in the volume of work. Will they be being compensated for the closure of the CJCs?
No.
The local courts will have a significant increase in the volume of work. Will they be compensated
So
for
what were the
closure?
numbers for 728 last year, mediations?
Yes.
Okay, that's the number we're dealing with.
728 is significant if it lands into an already significant workload of another body. I don't actually understand the point you're making, Attorney. Are you saying that's insignificant?
A portion of them will be dealt with by DCJ.
And that will be at no cost to the applicant?
Correct. Yeah. Correct.
Yes.
Yep.
Thank you.
Attorney General, is it appropriate for members of the legal profession to engage in political protest while in the courtroom?
Give me some context.
Happy to. Are you aware of a story from the middle of last year? A solicitor, Seth Harlan, represented the Law Society, and he wore the Palestinian scarf in his admissions ceremony as an act of political protest.
Yeah, that's what happens in a courtroom is a matter for the judicial officer in the courtroom, and also, generally speaking, the Chief Justice will take a view on that as well, which I believe he has.
So you have no opinion or view?
Yeah, courtrooms are no place for protests. That's a simple proposition.
Mm-hmm. Thank you.
In that particular case, the Chief Justice did take a view, as did the President of the Law Society.
That's right.
And Mr Harlan chose to disregard the views that have been strongly expressed to him and post on social media footage of his protest. Given the current climate of anti-Semitism, do you have any comment about the appropriateness of Mr Harlan's actions?
I've just told you courtrooms are no place for protests.
What about social media?
Depends on the context of it.
Thank you. So if we can just go back to the appointment of magistrates as judges, I just want to confirm that that was done in response to requests from the magistrates themselves?
Partly, yes, and from the Australian Judicial Officers Association, they made representations to me.
Mm-hmm.
Yes.
Sorry, the Australian Judicial Officers Association, is that
AJOA.
separate from them? Yeah, no, but is that separate from the magistrates, or is that composed of the magistrates?
It's an association that represents all judicial officers in New South Wales.
And have they also made representations to you about increased workplace support?
I'd have to go back and have a look at the minutes of my meetings with them.
Okay, Thank you. How often do you meet with them, Minister?
Fairly regularly when I was new to the role. Irregularly now, I probably meet with Arjoa and the Magistrates Association, I don't know, once every 2 months, I think. Unless they request a meeting, and my door's always open if they do, if there's a problem.
And have you had any issues brought to your attention about...
But also, sorry, Ms. Carr, I should say, I'm down at the local court often. I swear in, unlike my predecessors, almost every judicial officer that I appoint. So I'm always in discussions with individual magistrates and the Chief Magistrate often.
Okay,
so
thank you.
really good and productive discourse.
Thank you.
Just following on from the CJC discussion earlier this morning, you indicated that discussions commenced approximately two years ago, I assume through ERC, in relation to potential cuts.
Yep.
Savings, cuts, whichever way you'd like to look at it. Are there any other savings/cuts anticipated in this budget? In your portfolio that you've put forward?
You know you're going to get them a boring historical answer of all time. Immutably delivered by every minister, always.
So you won't rule it out?
You'll have to wait for the budget.
That's right, you won't rule it out. We've already got 20 seconds.
Sorry, just channeling my inner Daniel Mookie, sorry.
Always blame the Treasurer.
Yeah, always, because they're always to blame. Can we strike that from the record?
No.
At least you're not blaming the Premier. All right.
Got one sledge in.
Over to Dr.
Sledge him in his absence, yes. Ms. Conn.
Thank you, Chair. Good morning, Attorney
Morning,
General.
Ms. Conn.
I'd like to ask about the need for specialist LGBTQIA plus legal services in New South Wales. As you would know, the National Access to Justice Partnership commencing on 1 July will include the LGBTQIA plus community as a priority population for the first time. I understand that's something you supported and I thank you for that. But will you follow that up with funding for specialist services in New South Wales?
Sure. So I don't know if you heard my earlier answer, but we wrote to all the CJCs, and one of the options that I have given them in relation to, I call them surplus accounts, the rollover accounts, was options are to limited tenders to achieve specific outcomes or priority, which could include, and I took the time to spell out, statewide specialist LGBTQIA plus legal services. So I've drawn their attention to that as a possibility that might be funded under the uplift funding.
Excellent. And I assume you're aware of the service that exists in Victoria, the Q Plus legal service?
Generally speaking, yeah.
Okay. Could you outline the process that you've advised the CJCs if they want to go forward and apply for this? Is it something that you put out a tender for?
That would be one of the options, yes, if we decided to go down that way, yes.
Are you anticipating...
Unless someone can convince me there's a better way of allocating the funds than a tender. But tender, or I might be hamstrung by that.
I'm not, to be clear, I'm not raising an objection to a tender process,
Yeah.
but what I'm interested in is understanding if those funds are actually earmarked for a specialist service. So
Not
my
at the
understanding
moment.
is there is a real need
there's
for that.
There's a body of funding which is not surplus, but it's an uplift from the last year's funding, and it's up to me to determine how best that should be spent. I could give it all to legal aid, and Monique's. No, I can't. I can't do that. There are various things I can do. No, it's for CJCs. Sorry. There are various ways I can distribute that to the CJC family. I've asked CLC family, and I've asked them to give me some guidance on how they think it might best help them in what they do.
Okay. And you're open to that funding being allocated to a specialist
I'm open
LGBTQI plus service?
Yeah, of course. I wouldn't have put it in the letter specifically if I wasn't.
Okay. And have you done any work to look at the implication or the increased need for services arising from law changes that have been made in the last year, and noting again that the Greens supported those, but particularly things like birth, deaths and marriages where there's going to be an increased number of people seeking legal support?
Well, that'll form part of the feedback we get in relation to that extra funding.
Okay.
But they've also had an uplift under the NAJP agreement for employee-related expenses and things like that, isn't there?
Yeah, so there's the NAJP funding, there's the baseline funding that represents what the CLCs were allocated under the last agreement. There's escalation in that, and then there's the money allocated to CLCs for pay parity to enable them to increase wages to their staff. And on top of that, there is an uplift amount that is approximately 3 to 3.5 million per annum, and it's that 3 to 3.5 million per annum that we are currently consulting the CJCs on as to how they see the priority should be for that amount of money. So there's a two-stage process, if you like. There's a consultation with the CLC sector about what they think about how that money should be allocated. Following that, once decisions have been made, there would be an allocation process.
Okay, thank you for
that might include a tender process.
Okay, thank you. I'll pass back to my colleague so he can see you.
I think you'll get whole number 5 still. So you continue on. Yeah, okay. Thank you. Attorney, I just wanted to briefly touch on the coronial system, if I could. I've seen some materials that suggest that the coronial system in New South Wales, whilst obviously every person in there is doing incredible work, is a system under radical strain, and that there has been recommendations that that there be changes to that system, including the establishment of a specialist singular court. Obviously, this is a budgetary issue as well, but again, looking at how we can look through cost-benefit analyses, I'm just curious, is there work happening within AG's department about what we can do? Dylan's passing you something as well, sorry. About the state of the New South Wales coronial system, and I'm referring to it in terms of, not just the outcomes that we could achieve, but also, the fact that we know how sensitive the coronial work is, and also through a First Nations justice lens there as well when we're dealing with deaths in custody, deaths, historic deaths and coronials and so on. I'm just curious about what your concerns are, if you have any, and what work you're doing.
So we meet with the heads of jurisdictions regularly, and as part of budget bids, DCJ, that's responsible for all of those courts and tribunals, sit down with the relevant staff and secure budget bids, if I can call it that, from them, and they form part of the normal budget bids that all courts, tribunals, bodies, departments put in for funding each year. So they're all subject to funding. You'd love to do all of these all at once, but you can't. But from time to time, when issues arise, we do assist each of these bodies. For example, in November 2024, funding was made available for 2 non-magistrate coroners to assist in the caseload. So they'll be specialist solicitors who do a lot of the behind-the-scenes, time-consuming work to make things easier for the coroners. And the chief coroner specifically asked for a couple of those extra positions, and we're funding those.
So do you think, because at the moment I understand there's a backlog of between 131 and 140 of the inquests, and at the moment with an estimated total of only 100 inquests being able to be carried out per annum, I'm not hearing that those extra measures are going to be able to catch up in earnest in any real time.
They'll go some way.
I agree. Sorry, I'm not criticising that move.
That was an ask of the deputy of the chief coroner, but the chief magistrate, who effectively presides over the coroner's court, is also having regular meetings and conversations with, and cast a supervisory eye as well over the operations of the Coroner's Division, and so we'll continue to keep talking about that.
I mean, and recognising that I think...
I should also say,
Yeah.
shortage of forensic pathologists is a real issue as well.
Yep.
In the Coroner's Court, that does hold up a number of matters. Some of those can take a year because there's a state nationwide shortage of forensic pathologists. So that's something that...
Is that something you're communicating with your health minister about?
They know that well. It's just there just aren't enough people graduating and making themselves available for in that field of endeavour.
I think it's also just really important from a justice perspective that, the work of the coronial system is, and we sometimes forget this, it's not just inquiring about what did happen, it's actually about preventing future wrongful death.
It is, but it's also largely about giving families comfort as well in the most difficult times that they'll ever face. I know I've been through that myself.
So in terms of what you think, what measures you're looking at, so clearly that's a good initiative to be able to respond to that request to have some more capacity of those officers who can oversee the coronial system. Are there any other measures that you have considered or that you would be opening to receiving, or is there a process to kind of work out how we do better?
No, it's really about headcount, isn't it? More than anything else. And we, as I said, there's pressure from all aspects of government for additional employees. So, as important as it is, it still has to take its role in the normal budgetary processes.
Is it something though that the government would respond to in time about a structural change to the way the coronial system works, like a standalone specialist?
Well, I've been completely honest with all stakeholders from day one about that. That is completely subject to funding. That's a very expensive measure.
And so there needs to be, I think we just keep rolling, I think it's still right.
Yeah.
Isn't it? Yeah, thank you. So it's something that, so what needs to happen? More reports, more recommendations, or are you convinced the case is there to have systemic structural reform, but we just can't afford it? Is that what you're saying?
I'm saying that one of the fundamental recommendations of the Select Committee and all the reviews that have been undertaken is for a standalone coroner's court, and it's just I've been honest with all stakeholders. It's just subject to funding.
So I
don't know. I just can't expand on that answer, Ms. Higginson.
Okay, Attorney, when we were talking about youth crime and what I refer to as the over-incarceration of young people, you were pointing to my colleagues here an article from the SMH from 2014. Could you tell me what that is?
Yeah.
They didn't let you, but I'm really interested.
So I'm happy to give you a copy of it when I leave here, if you like.
Thank you.
It's called New South Wales New Crime Capital, Moree, by Rachel Olding on the 4th of September 2014. And I'm not bringing this up to show that this was on the Coalition's watch. What I am bringing it, what I found useful about it was the really objective considerations by elected representatives in Moree about the problem. So it goes on to say, country towns in northern New South Wales are in the midst of a tsunami of crime. Quarterly statistics released on Thursday show all 17 major offences are either stable or falling across New South Wales for the first time in 25 years. However, Don Weatherburn, who was head of Boxar, said there was an absolute failure in rural areas to capitalise on the trend. And then Rachel Olding has gone on to interview some of the leaders in Moree. And she says community leaders in Moree have spoken out about the despair that a severe underclass being entrenched in the Broadacre farming region's town of 10,000 people. And the mayor, John Tranby, said at the time, we're not experiencing a crime surge, more like a tsunami. He said it's not and this is the valuable part of the article, it's not a consequence of any single thing. It's an accumulation. There's less and less employment since the weed industry and the wool industry became very mechanised, and the drugs that used to only be a problem in the big cities have now made their way out here. It said even then, Coonamble, Burke, Brewarrina have persistently high crime rates. Camilla Royal, Donoli and Briggs-Smith said the collapse of the cotton industry in Moree has fueled a cycle of welfare dependency that's filtered through generations, particularly as alcohol, drugs and drought have taken hold. She said boredom among young people fueled the mostly opportunistic crimes such as setting vacant homes alight, stealing cars, breaking into homes for alcohol. She said she recently caught 3 7-year-old children smashing their way into her garage looking for spray paint.
So, Attorney, can I just interrupt you there? What was your point? What was the point?
The point is that these people were objectively pointing to the multifaceted causes of the crime out there, and that it's going to take more than a legislative change or tougher penalties to address these long-term and deep-seated problems.
Can I ask you whether you have, whether you're familiar with an article that was published, I think just only on the 28th of January 2025 in the New York Times magazine. Now, I'm not expecting you to have read the New York Times.
No, I am not.
No, okay. This one is, the title of it is What Happened When America Emptied Its Youth Prisons. And it talks about lessons from a radical 20-year experiment and a quiet triumph of public policy. And are you happy if I send you a copy of this?
Sure.
Will you commit to reading it?
100%.
Promise?
I can tell you hand on heart that this issue consumes more of my concern and attention than any other issue
it keeps all of us
in
awake.
my portfolio.
It keeps all of us awake.
100%.
It's a horror show.
Yeah.
And this article, in no uncertain terms, is an incredible case as to why every time we lock a kid up, even for a short period of time, we're doing the wrong thing, both for rates of crime, for community safety, and this is just not one case it speaks to. It's actually a dive into public policy.
So we agree. We agree. We need more diversion services.
We absolutely.
But in the absence of them.
No. The absence of them is just what overwhelmingly we know is every moment of incarceration is criminogenic.
Well, we have to address that issue as well. But in the absence of those programs, leaving a child on the street who's very young, liable to be led astray by a ringleader, if I can put it that way, and leaving them on the street with the predispositions that you know they have, and you know in your heart they are, in a matter of days or weeks, going to perform some violent act upon themselves or others, leaving them on the street is absolutely unacceptable for a government as well.
A government that has all the capacity to assist that young person, to feed them, to help their family, to do all things, but you choose to lock them up.
They're much easier said than done, those things, Ms Higginson.
In terms of the extension of 3 years that you're now seeking through the Parliament, why 3 years? You say you need 3 years. Why do you need 3 more years to keep kids in prisons?
Well, because that was the figure that we arrived at after discussing with our advisors. One more year wouldn't be enough.
So which advisors? Who said to you 3 years is it, Attorney? Let's do that.
We tossed that around. Policy review group within DCJ has opinions. We tossed those around and we come to a figure.
What were you told then the 3 years will achieve? Those extra...
we don't want to have to come back.
Those extra 145 kids that are now in prison, most of those who are First Nations kids, that what will happen in 3 years with those 145 kids, plus, if we're going to go on the same trajectory, the next 145 kids in the next short period of time. And then, if we're going over a 3-year period, so what? We're going to end up with 645 kids refuse bail in remand behind bars in 3 years' time, say.
Not necessarily, but can I put the question to the other way? What would have happened to those kids?
No,
and
Attorney,
members of
with the greatest
if we
respect,
hadn't-
I'm the
if
one
we-
that's asking the
I know.
questions, really, with the greatest
Okay,
respect.
okay, well then-
What were you advised
Point of order.
will happen in those 3
Point of order.
years?
Point of order.
The attorney was answering the question.
With a
And just-
question.
and well,
Order.
being
order.
cut down. He's entitled to complete his answer.
I think the attorney's doing fine, Chair.
So-
I really do.
I think he's handling you quite well.
It'll give us
Verbally,
the
that is.
time to evaluate the effects of the operation of 22C in a proper way, but it'll also give us the time to do all of those other things that we are working on that I spelt out before. For example, $66.9 million in the budget over the 4 years for youth diversionary responses such as Youth on Track, the Bail and Accommodation Support Service, the Broadmeadow Children's Court
Can I
Project.
just ask you about the Maurice facility that you're planning? I was speaking with the Premier about it. He said you would know more about it. When will there's a commitment that it will come online? But what is the plan at the moment? It's no longer to build a new premise, is that right? It will be a already built premise?
Mr Tidball can tell you all about that.
Yeah, thanks, Ms Higginson. It's not the intention to build. There was one, and we are working in lockstep with community. We are being Aboriginal-led in the way we are seeking to go about this, because to make this work, we actually need buy-in, and we need to have something which is appropriate as an environment. A group has been commissioned to run the facility. The search for appropriate premises that we can lease is the focus at the moment.
Can we talk about this a little bit more after
Of
lunch?
course.
Is that okay? Attorney, are the 145 bail refused that you referred to under Section 22C, are they all in Moree?
No.
No, of course
some
they're
of them,
not.
Some of them
So
in
where-
West Sydney, some of them in southern New South Wales.
That's right. So how does so where does this, how do all the kids in the other where is the interception with all these other measures? Because as far as the lay eye can see, we're just putting more kids behind bars, Attorney. That's what we're doing.
No, there are efforts, particularly in the area of justice reinvestment and things like that, to partner with organisations to provide diversionary services for those kids. And the federal government is also spending quite a deal of money on justice reinvestment as well.
Thank you very much. Attorney General, at the last estimates, I asked or raised concerns regarding that victims and perpetrators were having to share bathrooms, and this was in the afternoon session, so I'm mindful that you won't. But I was advised at the time, it was taken on notice, and the response was, and I quote, process is in place to provide segregation from different stakeholders where possible. Now, we've also heard reports that there is limited space in the foyer. I'm interested to know what your response is in relation to that.
I'll refer that question to Mr. Deeth. He was the one. You asked him that question previously in estimates.
And I'm interested in your view in relation to particularly where possible, stakeholders are separated. Now, we're talking about victims and perpetrators
my view is,
attempting to use
my view is
bathrooms
we have
and
to,
being in the foyer.
My view is that we have to make sure that as quickly as we can, we make sure that those spaces are appropriate.
And do you think they are currently appropriate?
Well, Mr. Deeth can tell you about the progress in that regard.
But I'm asking, have you been to Campbelltown Courthouse?
Campbelltown, not for a while, but no.
In your opinion, and from when you last went, do you think it's currently adequate and providing a safe environment for perpetrators
I can't answer
to be
that.
with victims?
I can't answer that. I don't know what's there. That's why I was referring the question to Mr. Deeth, who is in charge of the courts, court services.
Well, I'm happy to discuss the details of the court this afternoon, but what I'm interested in, Attorney General, is whether or not you intend to upgrade the courts.
Well, we'd love to upgrade all of the courts as much as we can, but like all other considerations, they are all subject to funding.
Have you put in a funding bid for that, or is it even in consideration?
I'd have to go and have a look at the funding bids that are in, but that'd be cabinet in confidence because they're budget considerations.
The Macarthur region has had a population increase of 21% in the last 5 years, which is now over 300,000, and that covers the 3 LGAs, Camden, Campbelltown and also Wallandilly. It's expected to double in the next 15 years. The latest Bosca results show that that region has had one of the highest increases in assaults, particularly over the last 2 years, 25% increase in assaults in Campbelltown and 13% in Wallandilly, and 50% increase in domestic violence cases in Camden. Will you commit to funding a community and justice precinct for the Macarthur area?
I can't make any commitments about that, but what I can say is they've had many good and productive meetings about that, particularly with Campbelltown Council and Greg Warren, the member for Campbelltown, has brought the mayors of the day to come and see me. So we are looking at on that, but I don't have any announcements to make at this time. But it is something we're looking at.
Okay.
And I do recognise the need for it.
All right, good. The other question is just following up from last year. I asked about the 13 billion in savings, I think it was, in regards to Crime Prevention Fund and also the Graffiti Initiative Fund. Now, we've seen an increase in graffiti across the state, particularly with anti-Semitic tax, but more broadly, a number of shires have seen an increase in graffiti. Will you now reverse your decision to cut the graffiti fund?
I'll take that on notice, but it's probably unlikely.
Okay.
Thank you. A general question, if you don't mind, Attorney. I'm just, I suppose, curious to find out what your top priorities are for your portfolio, because understandably you haven't had time to read the ODPP audit report. You were working late, so you weren't able to be across the details of the fracas on the steps of the Opera House the morning after that occurred.
No, that's not true. You've mischaracterised that. Thank you.
I believe that was what you told the morning breakfast reporter, Minister.
I've been over that.
You haven't had a chance to finalise the 93Z statutory review yet. So I'm just curious to know what is taking the focus of your energies, what your top 3 priorities are that you're working on.
I'm not going to sit here and enumerate my priorities for you, particularly in order of importance. You can have a look at the work that we've done in the past 2 years, and you'll see that all the legislation that we've brought to Parliament represents some of the important issues that we have addressed and continue to address. But as I just indicated to Ms Higginson, one of the top priorities for me is youth crime, not just in the regions but across New South Wales as a whole. So you can have regard to the work that we've done, and we'll continue to do that work in the next few years.
I agree with your characterisation that youth crime is a difficult and a challenging area, and I am reflecting very much on the very sad events of this morning. It is difficult to say that the current initiatives have been successful on any metric of reducing youth crime. What are the urgent priorities in your portfolio that are taking up your time?
How about you ask me a question about something that might be related to estimates and not a hypothetical about what might be forthcoming in the future?
Frankly, Minister, I am perplexed that you cannot identify your priorities
you've run out of questions.
That's
the problem. You've run out of questions. You've run out of questions, so now you just...
And you've run out of answers,
hypothesise.
frankly, that you can't answer a very simple, straightforward question
If you
like
can't
that.
ask me a better question than that with 20 minutes to go...
Minister, with respect, I don't intend to be
you've run out
schooled
of
by
questions.
you on rudely, frankly, on questions. So thank you very much for your time.
You're welcome.
Yeah, you can
Thank you.
finish,
Thank you. I just want to go back to the youth incarceration and what we're doing. In terms of the overall numbers and this time period, I am really concerned about we're going to have a bill before us in the next session of Parliament extending these laws for another 3 years. And the advice that you've received about that 3 years. Why was it that we introduced them for 12 months? If now we're saying 12 months is not long enough, what is the thinking then to now, and what is that logic? Given we know that what we'll achieve in this period of time is more kids.
I think I've just gone over that with you, Ms. Higginson. Really.
I'm honestly, I've
answered the question. You might not like the answer, with respect, but I've answered that question.
Okay. So how did we decide that 12 months was appropriate when we introduced we were dragged to introduce those laws this time last year, but now we're saying 3 months. Why not another 12 months? This is honestly the question. I don't know what the metrics is.
I don't want to come back and keep extending them every 12 months, and the likelihood is that we're still going to be facing the sort of problems that we are now in 12 months' time. If the problem disappears and we need to revisit it earlier, that's always open to us.
So you're saying these measures won't work, is what you're saying. I'm trying to grapple with the logic of what your actions you're taking. You're saying in 12 months we won't have seen an improvement. Are you saying in 3 years we will have seen?
I don't want to make. You're asking me completely hypothetical questions.
No. I'm asking you a justification for the laws you're asking me and my party to vote on in the next session of Parliament. That's what I'm asking for. That evidence-based justification, Attorney General. I promise I'm not asking for anything more abstract.
You'll get all that information, but I don't know that I can answer that question in a different way for you than I already have. I don't want to come back every 12 months.
So what is your measure? What is
this.
your matrix of success then? Because all I've heard so far from the Premier, not you, is more kids behind bars is a measure that we are achieving something. I'm failing to grapple with that logic.
We have been over this time and time again. If you have specific regard to the provisions of 22C, it deals with a problem of recidivist behaviour with two serious and emerging crimes in relation to serious motor vehicle theft offences and serious break and enter offences. We know that if those children who repeatedly commit those offences are left on the street, they'll keep committing them again and again. That is the immediate issue we are trying to address with these provisions. And I don't know how many ways I can explain that to you. That is the problem before us, and that is what this measure is intended to address. If you leave them alone and to their own devices, they'll keep committing these offences.
So I don't think anybody suggests that you leave young people who have offended the law alone. The idea of releasing young people on bail and requiring that they are properly managed in their community is the alternative.
That's right, and at the moment there are not the facilities to properly manage them in the community. So the only alternative is to not allow them to be in the community, being misled in the way they are and misbehaving in the violent way that they sometimes do.
So how many
This is a measure designed to protect people in the community who are scared. And the Premier and I have been to Maureen, we've spoken to people who've had homes
But the children
broken
you're
into.
locking up are not in Moree. You've just said that.
They're all over the place, some
That's
of them,
right.
but there's a very high incidence in Moree and in other places in New South Wales.
Okay, so let's just focus on Moree. What has your police surge response been? What is the police surge?
You have to ask the Minister for Police that next week.
So you don't know?
I'm not here to. I want to be accurate in my responses to you.
So,
and
okay,
I'm
sorry,
not
I'll reframe
responsible
the
for
question.
police.
Is it your understanding that we have, as one of your measures, responded through a police surge to address and try to prevent the crimes from happening in the first place?
an actual
No,
reduction
really,
of crime
really
measure
sorry
strategy.
for asking me about police surges and things like that. That's a matter for the Minister for Police.
So, sorry, my question was: Are you aware or are you satisfied with the police surge, with anything, with any crime prevention methods, mechanisms, strategies, as the Attorney General? I am sincerely just trying to find the justification that I am meant to have to be able to understand the next tranche of extending these laws.
I went through all of that in my second reading speech, Ms Higginson.
I heard nothing about whether you're satisfied.
And you're talking about the rationale for extending it. That's embodied in my second reading speech.
Okay,
Thanks,
we're now
Attorney.
into extensive questioning from the government.
I'm still banking my questions.
For next
Thank you.
estimates.
There being no questions from the government, thank you very much for coming today,
Thank you all.
Mr Attorney
Thank you,
General. I note you took a number of questions on notice, and the Secretariat will be in contact with you or your office for your responses in due course.
Thank you, Mr Chairman. Could I just leave with a comment in the same vein as I did on the last occasion, and that is that this afternoon you'll have sitting around this table the various people that you do now. They are excellent servants of the government of the day. They deserve to be treated with respect. In my time as Attorney General, there have been occasions, particularly with one statutory office holder that was treated with complete disrespect. Could I just ask, most respectfully, Mr Chair, that you and the committee members ensure that these good people are treated with the respect that they deserve?
Your comments noted. Thank you very much.
Thank you.
All right, we'll now break and return at 2 o'clock. Thank you very much. And we'll commence with opposition questioning. Thank
Afternoon,
you.
everyone. Thank you for being here. Mr. Deeth, perhaps we could start with you, if that's okay. I hope these are allocated correctly, but I'm sure you'll direct them to whoever can answer if they're not. I'm curious about forensic mental health services and the impact on the court system of resignation by psychiatrists, and I'm wondering if you're monitoring the impact on 19B orders.
At high level, Ms.
Yes.
Carter, can I respond and say we, until very recently, allocated a staff member full-time to be the DCJ, entire DCJ system, including courts interface with health.
Yes.
We have been daily receiving reports, and I've had a particular focus on corrections, youth justice and other interfaces. In terms of the specific 19B question,
yes,
I would need to take that on notice. I will say that what I've been particularly seeking to do, and I had discussions with heads of jurisdiction when the dispute emerged, on the basis that if there were any blockages in the system, that I would be alerted. I've not heard of any disjunction arising, but I could give you a more considered and thorough response if we took it on notice.
Yeah, look, if you wouldn't mind, and perhaps as part of that, unless you feel comfortable answering it now, I'm also curious about, because one hears things and one likes to test them. The availability of beds for any accused is subject of a 19A order, and whether there's any difficulties there.
I should, I just need to be disciplined. I should take that on notice.
Yeah, okay.
Thanks.
Thank you. I'd be grateful. Thank you very much. And I think this is you, Mr. Deeth, but we'll find out. Because you're responsible for all of the courts, including Children's Court, matters pursuant to the Children Criminal Proceedings Act. That's all you?
Well, certainly responsible for the court, yes.
Yes,
Administration
okay.
of the court.
And Section 10 of the Children Criminal Proceedings Act, the general public is excluded from the hearing of children's court matters, correct?
Correct.
What's the purpose of excluding the public from those hearings?
From children's court matters, without going into treaties about open justice at this stage, obviously the initial tenet
the Friday afternoon purpose
is open justice is an important tenet of justice, but in the particular case of children's court matters, it's for the protection of the young people.
Yes, thank you. And you would be aware that details of a matter heard under the Children Criminal Proceedings Act were provided to and discussed on air on the 2GB breakfast show on the 25th of October last year?
I'm not sure I am familiar with that particular matter.
Oh, okay. Well, there were the presenter, Ben Fordham, discussed in some detail with clearly considerable knowledge of what had happened in a particular matter dealing with a young Indigenous boy and on air on the 25th of October. And so you weren't aware of that? That hadn't been brought to your attention at all?
I'd have to go back and check my notes, but I'm
Oh, okay.
Okay,
because I was wondering what investigations were ongoing in relation to that clearly authoritative covering of sensitive children's court matters.
I'm happy to take that on notice.
Yeah, no, thank you. If you could. Yeah, so, I mean, there's limited sources of that information. If it had come from, for example, DCJ, I assume that would be a breach of employment conditions.
I assume so too, but again, just in the absence of the full information, I don't want to. I don't wish to speculate.
Yeah, no, absolutely. So, I suppose you did not cause this matter to be reported to the police.
I'll take that on notice. I haven't made any referral to the police.
All right. No, thank you very much. Okay. Perhaps you could also take on notice, once you're aware of it, what the appropriate steps are to ensure that this breach does not happen again.
Happy to take that on notice.
Yeah, okay. Thank you very much.
I might actually cover off a couple of questions around CJCs. And first of all, could I get an idea or find out who are the stakeholders that were consulted about the closure? And I understand it was October last year, but interested to know who was formally advised.
Me too.
Stakeholders were advised. Stakeholders were not consulted, so the decision had already been taken, and we were advising stakeholders of the decision of the government.
Sorry, are you able to speak into the microphone a little bit more?
Sorry,
Thank you.
apologies for that, and I'll repeat what I just said. The notice on the 17th of October was notice of the government decision. It wasn't consultation prior to the government decision.
So who was advised of the decision?
I can give you the full list of the people, but obviously the staff and the mediators and Office of Local Government, New South Wales Bar Association and Law Society. But I'll give you, happy to take that on notice and give you the full list.
Okay. And then, was anyone consulted on the decision?
I'll take that on notice.
Is it usual practice, I suppose, to make a decision like that or provide advice to Attorney General or a Minister without without consulting more broadly about the impact it could have?
I'm not advised.
Yep.
Can I answer it this way? You would advise on impact if it were a budget decision, given the nature of the budget process. You may not consult.
Do you know how much it currently costs for the CJCs?
It's about two.
Yeah. The cost of CJCs in financial year 24 was 3.029 million.
3.2. And do you have a breakdown of some of that would be administrative costs, like obviously the physical buildings and staff and things? Do you have that breakdown?
I don't have those figures.
Are you able to take that on notice?
I'll take that on notice.
Yeah. So how many staff will be impacted by the decision?
I believe 15 staff members within community justice centres, CJCs.
15.
That's not including the mediators who are contractors.
So 15 full-time, and then there's contractors as well?
The mediators are contractors, the staff, the 15 staff members. Not all of whom are, I think, full-time, but 15 staff members.
And so the 15 staff, will they be taken into DCJ?
So there's actions underway at the moment to try and assist each of those impacted individuals, correct, yes.
And are there any volunteers involved that assist with CJCs?
I might take that on notice, I'm not sure.
And if so, if you could also find out the number of volunteers that assist.
Happy to do so.
Yeah.
So I understand that there has been an investment in the order of millions of dollars into a new CRM for the Community Justice Centre. What happens to that investment?
I think you're referring to Resolve, the new system taking over from the old Lotus Note system.
Yes.
The intention is to continue to use that with the new service that will be running from the 1st of July.
So that can be repurposed?
I understand that's the case,
right.
Yes.
Okay, thank you.
Could I just get a better understanding of who will be able to use the new in-house system? Basically go to DCJ for support, and then those that will need to look at private mediation.
Of course. So the new in-house service will deal with disputes currently required under legislation to be referred to CJCs for mediation.
Yep.
This will primarily be those under the Crimes, Domestic and Personal Violence Act 2007 and disputes involving associations, as we referred to this morning. And the new service will be operational from 1 July.
And then what's the communication plan for that? It might be, I'm not sure if it's you or someone else, but how do you intend to actually notify all stakeholders that are impacted that they will be able to use a new system or not at all?
I understand that conversations, as I said, in 17th of October there was communications with impacted stakeholders, and I understand that there was some further communication with New South Wales Fair Trading in November of last year, which is responsible for associations as well.
And do you know if Fair Trading has made any reach out to organisations or associated? Because the reason my concern is that you are dealing with quite often voluntary organisations, and those are they're stretched as it is, as all volunteers are, and if they're not being told, they suddenly find out 29th of June, and then there's panic. So I'm just finding ultimately who's following it up and ensuring that it's common knowledge, because it seems as though this announcement was, or this decision was made, but it's been quietly disseminated.
Well, we'll certainly be making sure that people are aware of it through the use of the CJC website and in other forums as well. I think Mr. Tibble in the morning spoke about the ongoing communication plan that will be occurring in this space.
I mean, I imagine that if you take the referrals that come now, that the referrals would flow through to, and we need to clearly communicate and provide public information on how it would be. The referrals would flow through, and at that point, the nature of the service would be explained.
Mm-hmm. Okay. In relation to the actual the cost, 3.29 million over that last financial year, what are the cost savings you're expecting by making this change?
I'll take that on notice.
Perhaps I could ask some questions of you, Dr. Cockayne.
Yes.
So in relation to the matter that was discussed this morning of the supply chains of the companies contracted to supply electric buses to the New South Wales Government, I understand that of your own volition you've commenced an investigation into that?
That's not quite correct.
Right.
The legislation specifically prevents me from investigating specific cases, Section 10.1 of the Modern Slavery Act.
Mm-hmm.
My functions are laid out in Section 9 of the Act, and they do include monitoring
Mm-hmm.
of government actions in relation to supply chains and more broadly. I received a letter from the Shadow Treasurer, Mr. Tudor Hope, on Monday.
Mm-hmm.
On Tuesday and Wednesday I was actually on scheduled medical leave, so I've examined the letter very closely yesterday and I'm in the process of formulating a response. So we will be looking at the facts as alleged and
Mm-hmm.
the implications, and hope to respond in the next couple of days, couple of business days.
Right. Thank you. So if I have this correctly, you're engaged in a monitoring function under Section 9 but not an investigation function under Section 10 subsection 1?
Section 10.1 says that in exercising my functions under Section 9,
Mm-hmm.
I'm specifically prohibited from carrying out investigation of individual cases of modern slavery. However, I am entitled to take them into account in considering a general issue.
Right. So if you were directed by the Premier or the Attorney General, are you able to investigate specific cases then, or you're prohibited altogether?
My understanding is Section 10 applies to the exercise of my functions in all cases.
Right. Okay. So if there was a particular issue that is identified in your monitoring function, how then is that meant to be progressed?
I have powers under the Act to gather information,
Mm-hmm.
including under Section 14 with the
Mhm.
duty of cooperation of various government agencies.
Mm-hmm.
And I have the ability to report through the Attorney General to Parliament.
Right. And then it's up to Parliament to direct further or take further action.
Yes, there are other vectors, if we
Mhm.
can call it that way, put it
Mhm.
that way. For example, under Section 31 of the Modern Slavery Act, government sector finance agencies, of which Transport for New South Wales would be one,
Mm-hmm.
have an obligation to include in their annual reporting information an indication on a couple of things: the reasonable steps, the steps they have taken to essentially tackle modern
Yes.
slavery risks in their supply chains, and anything they've done in response to me raising a quote-unquote significant issue relating to their operations. And
Right.
that would then appear in their annual report at the end of the fiscal or after the fiscal year's end.
And so if you raise a report, let's say within by the end of March, when's the next annual reporting period? Are you aware?
It would depend on the agency.
Right.
I would hazard a guess that Transport for New South Wales may be on the normal reporting cycle, which would probably require them to report by roughly October.
Right.
But that would be a guess, and that would be a question probably for that department.
Yeah, no, I understand that. It's quite a long lead time, isn't it? When you think about, in terms of a response to, if you do raise an issue that there is slavery in the supply chain, it's looking like quite a long response time. Do you have sufficient resources in your office to monitor these issues and undertake responses to the monitoring adequately?
We have been developing our monitoring and reporting function.
Mm-hmm.
The legislation covers some 420 or more agencies,
Mm-hmm. Yes.
and requires all of them to report annually in different ways, and also expects my office to help them develop their capabilities. We have been in conversation with government for some time now about what level of reporting and monitoring bench strength is necessary. This is a brand new office, brand new government function, so it's probably going to take some time to identify exactly what level of resourcing is suitable.
But you have the resources to respond to the letter from the Honourable Damien Tudhope in relation to this concern in relation to the electric buses?
We'll certainly be doing our best with the resources available.
Okay, thank you. And how do we go about, I mean, obviously there are questions, importation, but how do we go about detecting slavery in overseas supply chains? What's available to us so that we can test these allegations?
So I think one of the central questions here is what is a reasonable step? The obligation on government agencies in these kinds of circumstances is to take reasonable steps to ensure that they do not procure goods and services made with modern slavery. At the moment, the guidance they have on what reasonable steps are in different circumstances comes from my office. We issued a 200-page document, Guidance on Reasonable Steps, at the end of 2023. And it goes partly, amongst other things, to the question that you've just put, Mrs. Carter, the question of how can a government buyer, understand where risk arises throughout its supply chain. We have made their life a little bit easier by providing them an inherent risk identification tool that for every New South Wales government procurement category sets out a level of risk. Heavy vehicles, procurement of heavy vehicles is high risk under that inherent risk identification tool. In fact, procurement of all vehicles is high risk. Something like 27 out of the 374 procurement categories in the government taxonomy are high risk. So that covers everything from from vehicle purchasing to inmate wages, to uniforms, cleaning and cleaning supplies, flooring and carpeting. And this tool that I've mentioned sets out the methodology by which we make that assessment, and all our sources. They're all public. That's all in the public domain. It's available on our website. So what this allows the government buyer to do is to understand, if I'm purchasing in this particular procurement category, if I'm purchasing this type of good, how risky is it from an inherent perspective? And then supplier due diligence is necessary. And additionally, we provide them with tools to engage suppliers to manage risks further down the supply chain, which is often, as you've pointed out, offshore. What we discourage is what is sometimes called contractual cascading and relying on that as the sole solution. That is not best practice. To rely only on your tier one supplier to undertake all of the work and monitor risks elsewhere on their own with no active engagement from you as a buyer is not accepted best practice and not what we propose under the Guidance on Reasonable Steps. So I suspect that will be a matter we may be looking at in this particular issue.
I'm aware that the American government has essentially, I suppose, blacklisted certain areas, especially because of the very high risk of goods being produced by Uyghur slaves, for example. Do we follow that in the same way that we pretty much follow the TGA? Do we follow that same approach in New South Wales, or we always make independent inquiries?
We take their assessments into consideration when we identify the risk level of specific procurement categories that is reflected in the inherent risk identification tool.
Okay, thank you very much.
Ms Mahaley.
Thank you, Madam Chair. Just my questions are just to Ms Dowling. If we can just, is there a response to the questions that I asked earlier today in relation to the stipends? Sorry,
just to clarify, there's no stipend, there's no regular ongoing payment.
Okay, so it's a one-off fee?
It's a fee, yes, and I don't have the final details of the amounts that were charged. They haven't yet been paid, but I will take that on notice and provide it to the committee in due course.
So what was the arrangement that, are you aware of, what was the arrangement that you made with Sir Max Hill then in that case?
I would need to look at the documentation to answer that question accurately.
So you'll take that on notice?
I will.
So the financial arrangement made and the amount of money that either has or will be paid to Mr Hill?
Mm-hmm.
Is that the same for Professor Julia Quilter? You don't have the arrangements?
That's right.
Okay. So if you could take on notice what the arrangement was or is still with Professor Quilter and the amount of money that either has been or will be paid for her services. And I assume their services are not ongoing in that case?
That's correct.
Okay. How did we come to how did it come about to actually take the services of Sir Max Hill? I'm just wondering where that came about.
I know Sir Max Hill through my involvement in the heads of prosecuting agencies of the Commonwealth and also the International Association of Prosecutors. He, as you probably know, led the Office of the
Yes.
Crown Prosecution Service of England and Wales, which is a service that is very similar to the ODPP but much, much bigger. He also was involved in a very detailed review of sexual assault prosecutions conducted in England and Wales during his tenure.
Right.
And he recently finished his tenure as the DPP of England and Wales and is now in private practice. And
Yes.
he seemed to me to be an extremely appropriate choice of a person with detailed understanding of the issues and an appropriate choice to review this important document.
And just as an aside issue, does he still have to notify ACOBA, the Advisory Committee on Business Appointments in England, if he does undertake that work? You're not aware of that?
I'm not aware of that.
Oh, okay. There's an article where former top prosecutor Max Hill admonished for unambiguous breach of revolving door rules. And the chair of that ACOBA stated that Mr Hill chose to blatantly disregard the processes detailed to him in regards to taking on work post his time as a DPP in the UK. All right. Can I also ask you then just a couple of issues in relation to the sort of opportunities that you found in progressing this report?
Mm-hmm.
And one, do you think there's sufficient funds then to be able to actually progress with your findings? Do you have the funds? I think one of the points there, I think you do talk about subject to funding, I think number 6. So
Yes.
Is there sufficient funds already within your office?
Currently, no. We would need more funding for that.
Sorry, I can't hear you, Ms Dowling.
Currently, there is not sufficient funding.
Right, there's not sufficient funding. So will you be putting making an application to the AG or Parliament or however you seek further funding? Is that where you tend to progress, sort of putting in a detailed report as to how much money you may need? I'm not sure whether there's been some costings to your report in terms of what you'd like to progress with.
We have a lot of competing funding pressures, as you would imagine. In particular, we are struggling to meet the needs of the Child Sexual Offence Evidence Program, which has been rolled out across the state. So funding, allocation of resources within my office needs to be done on a priority basis. As you will have seen from reading this report, the preparation and screening of briefs is very detailed, and a lot of lawyers look at each brief. And it may be that rather than have a fourth tier of review at that point of arraignment, that we can better bolster the decision making at the earlier stages of review.
Yes, so you're just saying you're considering the fourth tier. It's
That's
not something
right.
that you're not actually definitely committing to it.
Correct.
Because of this funding issue, right?
More detailed analysis needs to go into the decision of whether that is the best allocation of resources at this point in time.
So has there been any costings, even to establishing, I think you recommended number 4 and 5 in the opportunities for improvement, establishing working groups?
Yep.
Would that also be
No, they've already
subject
been
to funding?
They've already been established.
Okay, they've already been established, right. Okay, sorry, because it still says establishing. So they've now established prior to the completion of the report, is that right?
Yeah.
Okay. And who do you, apart from internal stakeholders, for example, number 5, in establishing a trauma and memory working group, you seek assistance from, is it academic experts?
The external stakeholders, my understanding is the external stakeholders have not yet been appointed to either of those working groups, but internal stakeholders have been identified and approached.
And will they be also given some sort of fee to assist with the working group, the external, or has that not been considered yet?
Stage.
Okay, we can take that on notice if you intend to do that. Well, I'm just trying to think, is there a ballpark figure then of any of the costings that you propose, for any of these recommendations being proposed coming out of the report? Is there some sort of figure that you've already considered that it'll cost?
Most of the further opportunities for improvement can be funded internally. We already do a great deal of training within our office. So improving the training is something that we would absorb within our internal budget. And as I've said before, external stakeholders, whether or not they are paid, they haven't been identified, and that issue hasn't been considered yet. And I've already answered the question in relation to the possible arraignment prosecutor.
And what about the number 9, changing the memorandum of understanding with New South Wales Police? Have you already undertaken the briefing with the police in relation to that?
That's underway. Those discussions are underway.
They're on their way, okay. And I'm just conscious also, was there any need to manage perhaps some staff fallout over some of the issues that we've from time to time read about? Was there anything in the context of providing an opportunity for more junior staff to be able to voice some of their concerns within the process, or is that something that's already...
I'm not sure what you mean by that
question.
Well,
if there are concerns... So you've got a 3-stage process, and perhaps at some stage somebody may not agree with a decision made at an earlier stage. What's the process for dealing with that?
That regularly happens, and that's the whole point of the multiple reviews.
Does it then finally come before you, Ms. Darling, or is there another?
It depends on the delegation at what decision and what stage. But I can assure you that there are regular disagreements within lawyers as to particular matters, charges, and the system is designed to tease out that
And then there's a
disagreement.
process of review afterwards.
Yeah.
Yes, okay, or debrief, whatever you may call it.
Or it's review.
Post the case. All right, I think that's really. Oh, I do actually know. I've got some time. Yes, I do want to quickly. Oh, what have I got left?
1 minute.
1 minute. No, I'll come back for mine because it's the next. Yeah, I'll come back.
Please.
Thank you. I would love to just start again with the community justice centres. Just following on from what we talked about earlier, Are you, and I think the Attorney General may have taken it on notice, I don't know, but will the cost benefit analysis be a document or something that can be made public? Or is that something that you'll consider?
Look, I have heard the Attorney's response today and I've heard your questions. If I can take that on notice,
thank you,
and try to provide something to the committee that may be of assistance.
Thank you. And I say it in all openness. I think there's an appetite to try to persuade the government to not make the decision they're making, and I just think that that's a fair thing. For if people want to make that case, then they should be able to make that case. Thank you. In terms of the Mr. Tipple, if it's okay, if we could carry on with where things are at with Moree and the building or the location of the long-promised facility, or what do we call it? What is it if it's not
well, I'm calling it, I don't know what its formal title is, but I think we refer it to this as the Moree Bail Accommodation Service.
Right.
And look, can I just say, it's always a difficult balance. The court system and legislation and legal policy clearly of the attorneys clearly fits within the remit of these estimates. I'm also mindful that Minister Dibb is up next week on youth justice. Equally, I'm not, how can I put it, I am not using that to block responding to questions. I am mindful though that a lot of this does fall within Minister Dibb's responsibilities next week. I'm fine for the questions to come to me either way. I'm to a certain level, I'm certainly happy to speak further to the evidence which I gave this morning, but in terms of other detail, just mindful that the Minister will be here next week.
Thank you.
And Paul O'Reilly will as well.
Yes.
And I think of Mr. O'Reilly's work with youth justice. He, in terms of a lot of the detail, will be able to, I think, speak in a much more effective way about the implementation than have I, but at a high level, happy to keep going now.
Thank you. I really appreciate that, but I would just love to know where we're at with the Bail Accommodation Centre.
So the intent was always that it was going to be a leased service, as I understand it, and I'm just trying to remember. It's Marine is the name of the service.
Who's
Yes, as an auspice service is, so the first task was to appoint an ACO to be appointed to commission an ACO to run that service. That ACO that has been commissioned happens to be the same ACO that runs the service whereby young people who are in need of there's a service that runs in the evenings. It's the same for youth in Moree. It's actually the same service. So the thought was if you had an ACO doing both of those, that there'd be more of a connection between the two. But just in relation to the service itself, the tender was finalised in early February, and the consortium of Marine Beret Youth Service and the Aboriginal Medical Service and Shea Academy have been selected to run the new Moree Bail Accommodation program, and it fits within that $26.2 million package in the last budget. The intent the plan is certainly for the service to be running mid-year, mid-2025. Can I stress though that we are being very careful to to have the ACO lead that process.
Which is great and good for Moree. Can I just ask, and look, maybe Ms. Dowling might have some input to here, but you too, Mr. Tibble, I read, the decisions of Lonergan and Rothman in the Supreme Court cases with a great degree of concern, possibly fear. It's all right, Ms. Dowling. I will tell you about them. It's okay. I'm not trying to catch you in any way. Just about these, the application of Section 22C and the correlation with, or the incoherence with Section 4 and Section 6 of the Children's Criminal Proceedings Act. And these are matters that have now been before those Supreme Court justices. And their comments are, like Lonergan actually says, a lack of coherence between the bail court's obligations to comply with Sections 4 and 6 of the Children's Criminal Proceedings Act and the requirements of Section 22C, which treats a relevantly charged child's freedom in a less favourable way than an adult's freedom in exactly the same circumstances. I'm just curious about whether that is something that is being received with the concern that I strongly suspect those judges are speaking it, and whether or not there's, inside the machinery of the Attorney General's Department, the public prosecutions, and whether this is something of concern to internally.
I am reluctant to, and I don't think it's my place to comment on policy or to critique policy. What I would say is that in the advice that the department provides to government, we are always very careful using the facility of Boxar and in other matters Faxiar to ensure that that we have a high quality evidence base in all of the work that we do, and we provide advice to the government. Beyond that, I think the duty that as Secretary I consider that I have is clearly to ensure that we uphold and comply with the totality of all legislation. In the case of the particular sorrow that we observe out of events like this morning, and knowing something of the causation of those things, ensuring that the entire list of programs and supports that we have, so the statewide bail accommodation service, Youth on Track, some of the work around short-term remand, ensuring that those services are tightly coordinated with all of the liaison between the police, the youth justice people, and the other service delivery arms of DCJ, ensuring that they are tightly coordinated. But in terms of the policy itself, there's not much I can add to that.
Can I ask then, are we still spending $2,814 per day to incarcerate a young person, or is it more if they're on remand?
That for youth would be, I would need to check the number. That sounds about right.
I think it's about right. Because does anybody in terms of making sure that the policy is being implemented is credible and that the government is not falling into a state of a complete breach of the rights of children or young people, is there anybody inside of government considering whether there would be a case to literally just provide $2,814 per day to the children directly, or the young people? Has that ever been considered? To change their lives, actually? I'm not trying to be... So I'm actually honestly considering, is that anywhere in a matrix? If the government was to provide $2,814 per day to each of these young people who are potentially the ones who are making the bail applications, if we said, is that an option?
So specifically to that proposition, I have not been aware of a piece of work being done specifically on that. So,
and if that work, if somebody was to suggest that that could be a piece of work that should be looked at, who would they talk to? How would they say, hey, how about we go to wherever it is in Western Sydney and the bail court, and we stand there and we say to the kid, hey, how would you feel if you got $2,814 every day for this week? Do you think you'd go out and commit more crime? Do you want to, like, I'm serious. Instead, we're going to say, no, look, we'll spend this money and we'll lock you up. You'll get 3 meals a day. That's what the Premier told me. He's happy about 2 days ago. He feels good that he can feed them for 3 meals a day. I'm just wondering if we gave them an allowance of $2,814, whether we would see those people not have a criminal tendency the next day. Is it a bona fide exercise to look at whether that is something the state could be doing right now?
the department would respond to whatever we were directed to inquire into. It, with policy work and ledge work, consults with stakeholders. I don't know that there's a lot I can add
No,
to
thank
that.
you. I'm really enlightened to know that work hasn't been done or isn't, that you're not aware of that work. Thank you. Opposition.
Thank you. Dr. Cocaine, if I could just come back to you. I understand that you express concerns about slavery risks inherent in overseas commercial surrogacy arrangements. I'm wondering if you've had any opportunity to discuss this with the Attorney General and develop any mechanisms or policies or legislative changes which would mitigate as much as is possible the risk of anybody in New South Wales using an overseas surrogate who has in fact been coerced into surrogacy.
To my knowledge, that has not been discussed between myself or my office and the attorney or his office.
Were you asked to contribute to the current review of the New South Wales Surrogacy Act?
I'd have to take that on notice.
Okay, if you would, I would appreciate that. Do you have any ideas, have you given any thought to what measures we could take to protect the use of overseas commercial surrogates who are in fact involved in modern slavery, and also bearing in mind that is this something we could do as New South Wales alone, or would we have to be part of a coordinated Commonwealth action? If you had any thoughts about that.
So, Mrs. Carter, my thoughts are probably best summarised in the letter that I think you referenced earlier in the day in your conversation with the Attorney General. The central challenge, I think, here is that the central risk for a woman carrying a child to term from a modern slavery perspective is one of informed consent. It's very difficult for the New South Wales government, as a matter of policy and policy design, to effectively regulate the consent of someone overseas in a commercial setting. Often there are risks of manipulation, coercion, or even fraud that might taint that consent. There are challenges from any regulatory design perspective for a state government in Australia to effectively regulate such a transaction. There are also challenges in relation to how this interfaces with foreign affairs powers and functions, and indeed other aspects of governmental power that are under the federal constitution, the Commonwealth Constitution, that are vested to the Commonwealth. So while there are certain safeguards that could be imagined, for example, the creation of a whitelist of jurisdictions which a government felt adequately regulated surrogacy arrangements to the extent that it was safe for New South Wales clients to essentially be purchasing surrogacy services in those jurisdictions. Something like that would be difficult is my view, for an individual state to organise and implement effectively, and would have complex legal and political implications in which Canberra would need to be consulted.
With respect to the development of a whitelist, what sort of resources would that take in order to maintain the accuracy of any whitelist?
I think I would be entirely speculating if I offered an answer on that. That would be a matter for government in developing a policy proposal.
Would your office, for example, have the resources to annually monitor compliance of any surrogacy services that were on such a whitelist should it be formed?
If we were tasked to do that, we would, given our very limited resources, certainly be reorienting resources from one of the other functions that exist under the Act.
I don't know whether you've had occasion to look at the Surrogacy Act, but a requirement for a parentage order is a certificate from a counsellor who is required to be independent, and one of the things that that counsellor is meant to do is provide information or provide a decision as to the free informed consent of the surrogate. That was, of course, drafted in the context of altruistic surrogacy, and it was drafted in the context of altruistic surrogacy occurring in New South Wales. What issues do you see with being able to assess the free consent of women who are located overseas within surrogacy clinics?
Well, I think fairly self-evidently there are logistical access to information, language, privacy, health data access barriers, and resourcing issues also for any counsellor in Australia or New South Wales expected to undertake that inquiry.
You may be aware of the report of the UN Special Rapporteur who warned about multiple pregnancies in a surrogacy situation and the high apparent likelihood of surplus children effectively being sold. Is that another slavery risk in commercial surrogacy?
I would be cautious to... in theory, yes, it could be. Most of the cases of which I'm aware, in fact, as opposed to theory, the modern slavery risk tends to arise primarily in relation to the consent of the mother carrying the fetus. Difficult questions arise around parentage in some of these contexts, but they fall outside my mandate.
Okay, thank you very much. Thank you.
Thank you. I actually have a couple of questions for Miss Hitter in relation to panel lawyer work and community legal centres. I understand that community legal centres wrote to the Attorney General in May 2023, and a response was provided the 7th of December 2023. And in that response said, and I quote, "A thorough review of the relevant policies and business arrangements regarding panel lawyers would be undertaken." I just want to know if that has occurred.
It's still in progress. It's still under review. That arrangement is still under review.
And what's the time frame?
I'm hoping before the middle of the year, around June, July, we should have a result on that and communicate that to the community legal centres. So it's my hope.
Yep, and it will be made public?
Yeah, yeah.
Is there any reason why, because I understand that these the restrictions don't exist in Victoria, but any reason why we haven't sort of pursued it earlier?
It's a different arrangement in New South Wales. And I might just say that our policies historically have been that community legal centres, all community legal centres, can apply for a grant of legal aid and get disbursements for their matters if their matters are within our policies. Only a select few, and it's been a historical
list, and I think there's up to, I think, 6 legal centres, but I'm not quite sure of the number. But it is only a select few that can get solicitor costs as well as disbursements. And that, of course, is on top of the funding that they receive in order to do these matters. And historically, that's been the arrangement where legal aid has not been able to provide a service. And so to fill that gap, we've paid legal centres to do the work. Now, because this is a historical arrangement and things have moved on quite a lot, that arrangement needs to be reviewed very carefully so that we're not duplicating a resource that is obviously a scarce resource. So that is one issue. The second issue is that most of the panel work that is done is a duty lawyering, either in the criminal courts or in the family and federal circuit court. Historically, and I think it's the case now, that most legal centres do not do that work. They do not do local court work. They don't do duty work in the family and federal courts either. And so those panel arrangements are very much about that kind of work. So there is a question about whether or not, even if they were on the panel, whether or not they would be able to do that work in any event, because that's not their core work. So all of these issues need to be really carefully considered, and we need to consult with the sector as well on it. And that's what we're doing right now. And it is coinciding with us developing a new legal aid application system, which we're only sort of midway through, really, and we hope to go live with that new system toward the end of the year.
Okay. And do you have a breakdown of the cost that has been paid to Legal Aid New South Wales in relation to that for the additional private practitioners?
The legal aid application system, yes, I do. I don't have it with me, so can I provide that on notice?
Yeah, that's fine.
Please?
And just for the last 12 months is fine.
Yep,
yeah.
sure.
So I'm also interested to know about the work that's been undertaken to develop a needs-based funding methodology for the community legal centres.
I might refer that one to Mr. McKnight.
I'm not sure the context of your question. Perhaps you could give me a little more context.
Do you have an elaboration?
Yeah, look, I think the context is, has work been undertaken to develop a needs-based funding model for the community legal centres? Because the funding model doesn't seem to have changed in quite some time, and yes. Is there also an assessment of which community legal centres are serving bigger populations, smaller populations, which ones are serving them efficiently and effectively, which ones perhaps are not as efficient and as effective, and is the funding going to follow need and success, or is it going to continue along existing paths?
That's a lot of question.
Context.
Very helpful. Yeah. So I think the beginning point to your question is probably the review of the National Legal Assistance Partnership, which was conducted by Mr. Mundy in the context of the NLAB, as required by the NLAB. I think it is fair to say that...
Can I just stop you? Is that publicly available?
Yes, that's a review that was commissioned principally by the Commonwealth, but by all the parties to the NLAB. It's publicly available on the Commonwealth AGD website. And
I understand that Legal Aid's responsible, so the funding goes to Legal Aid and then Legal Aid passes that out to the CLCs?
That's right. In New South Wales, the funding under the NLAP and the state funding and the funding under the PPF that goes to CLCs is all wrapped up into a pot that is distributed and administered by Legal Aid. However, the decisions about which community legal centres get that funding are decisions taken by the Attorney General himself on, depending on at various points the process has been a little bit different.
And what's the methodology for that decision making?
So at various points the methodology has been different. I guess it's not a needs-based it is not the approach recommended in the Mundy review at present. The recommendations of that review, I think, remain to be further considered by
Are we bound by those
governments.
recommendations, or we're free to develop our own methodology?
Sorry, so what happened in that process was that the Commonwealth, after receiving the Mundy review, embarked on negotiations with the states and territories to develop a new national access to justice partnership that was entered into late last year by the Attorneys General. I think it's fair to say that the Commonwealth in those negotiations took a stance that effectively replicated the funding distribution model in the former NLAP. So what the Commonwealth did in that was create pools of funding that were targeted at particular sectors. So there is a pool for legal aid, a pool for CLCs, a new pool for women's legal services, which are kind of a subset of the CLC sector, a specific funding pool for Aboriginal legal services, and a new
Thank you
funding
for that context, but with respect to the allocation of the CLC pool,
so
how is that going to be done in New South Wales? What methodology will we see by June?
So the AG has, as he mentioned this morning, has now written to the CLCs. In that letter, he proposes that the existing funding pool for CLCs will be rolled over at their existing levels with an allowance for escalation and an allowance for pay parity on top of their existing pool. So essentially we're maintaining the status quo, and on top of that, as I was explaining this morning to Dr. Cohn, there is a small uplift from the NGAP funds that is yet to be determined.
There is a significant uplift, I think I'm correct, in the amount of funds in the CLC pool with this new agreement. So isn't this the time that we actually are able to look at a new methodology that responds to the volume of work being done by the CLC rather than the historic allocation?
I think in our that is always an option.
Is it an option that's under active consideration?
It is not.
Why is that?
The sector has been seeking, I think, funding clarity going forward, as you would appreciate for many CLCs.
Does the sector speak with one voice about methodology?
I don't think any sector speaks with one voice about anything, but we have been deeply engaged with the peak on this. And I think it's fair to say that the CLCs are really looking to ensure that they have some certainty about how much money they've got going forward, what that looks like for them in terms of their service delivery, how they might proceed. I think in relation to the process of kind of reallocating funds, if you like, that a process around that was undertaken in 2018 when a new application process was implemented. I think it's fair to say out of that there was not a huge change in the allocations that occurred.
And this time round? Is there
potential
for change to a more needs-based approach?
This time around, as I say, the proposal is to roll over existing funding levels for CLCs to provide them with that certainty of funding going forward so that they can maintain their services.
So roll over even if their activities or the populations they serve have changed significantly since the 2018 funding was set?
So rollover, yes. I'm not sure there are CLCs.
Can I just ask you, Mr. McKnight, how much was provided to each CLC for its general legal services in the last financial year?
That sits, I think, as a schedule in the legal aid space. So
okay, where can you provide that on
us.
notice, and also where it can be publicly accessed?
Absolutely.
Thank you very much.
Perhaps Ms. Hedda could take that one.
Yep, I could
Thank you.
take that one.
How do you measure the productivity of each CLC?
Yes, this is a really interesting...
Do you measure the productivity of each CLC? Yes, no, do you?
I'm just taking a step back because this has been the subject of a great deal of interjurisdictional debate.
So do we, in New South Wales, measure the productivity of each CLC?
I think the answer to that question is what we measure and what we
do
report
we,
on.
in New South Wales, measure
Well,
the productivity of each
so can I ask
CLC?
you,
Chair.
Point of order.
Chair, the Mr. Paul Knight, I was about to call you the Honourable. Sorry, I won't do that to you. Won't do that to you on Friday afternoon. Mr. Paul Knight is attempting to answer the question. I'll just pay respect to the Attorney General's sage words as he left us from his hearing, and for the witness and procedural fairness as under paragraph 19 of the procedural fairness resolution.
I think
To the point of order, I believe Mr. McKnight was trying to rephrase the question. I really just want a simple answer, yes or no.
He was trying to answer it. We've only got 50 seconds. He's trying to answer the question.
So under the NLAP agreement, CLCs are required to provide a high level of information about the services they provide to their community. Those reports are received by New South Wales and they're passed on to the Commonwealth. It's comprehensive reporting. What is missing, and I think what everybody recognises is missing, the sector, Commonwealth, us, is an outcomes framework that would tell us whether those services are actually achieving an outcome in the world. And there are commitments under the National Access to Justice Partnership to develop that outcomes framework at a national level. It's a commitment I particularly care about, and I think it's something that has been missing from
And
our
time
framework.
frame for those being developed?
My recollection is that is to be developed in the first 2 years of the NJAP. I could be wrong about that. It might be the first 12 months. Can I take that on?
Please. Thank you very much.
Ms. Mihaly.
I might just go back to Ms. Dowling. Just a couple of more questions in relation to. Let's go back to. Can I just ask? Actually, I'm interested just very quickly. Just the organisational graph on that report, page 41. You've got the 3 deputy directors and one's acting. Is that? There's a vacancy at the moment. Is that what that means?
No, my predecessor had 2 permanent deputy directors and 1 acting deputy director, and I've retained that structure. So at the moment we've got various senior prosecutors rotating through that position.
Oh, that's what that means. Okay, all right, thank you. I just wanted to clarify that. All right, I also want to just ask very briefly, if I may, about, I note on page 11 of the report, if I could just turn you to the report. And this is where you refer to discontinuation of proceedings, and you actually then elaborate, I think it's at 17 that were discontinued out of the total, 327 and 17.
That's right.
And they were for discretionary and evidentiary grounds, and I think you elaborate on one of those, one example. So you actually give an example on page 11, and that example is about a complainant's mental health deteriorating. Why did you choose to give one example? Why would you not give all of the examples? Why couldn't we list the 17 without perhaps providing the detail, but actually giving a little bit more clarity as to why those matters were discontinued?
No particular reason, just space, and because it's an example. It wouldn't be an example if all of them were listed out.
Well, you specifically use that. I'm just wondering why not be more clearer as to what the other reasons are. I mean,
there seems to be a lack of understanding across the community as to why matters are discontinued on discretionary grounds. And this is a really good example of what, an almost typical example of what can happen and why we discontinue matters, often quite...
So out of the
I'm just trying to answer your question, if you'd let me finish,
Well,
please.
you said that we didn't have an understandings first, so elaborate on that.
There is a great deal of curiosity in the community as to why matters might be discontinued relatively close to trial. And this is a really good example of a real life case that required the discontinuation of a matter, in this case, mid-trial.
Okay. Would any of the other 16, in total there were 17, any of the other 16 be similar reasons?
I can't answer that without going back to look at them.
So will you commit to actually providing some more detail as to the other 16 cases?
I'm not planning
If you're
to at
prepared to
this
give
moment.
one example here, I don't understand why not others. I think this is probably, out of the 17, probably the only example that's got the mental health issues.
What's your basis
In the
for
way that
saying
you've
that?
elaborated it there. But it would have been interesting to, if you're going to give one example, why not give more? I'm not sure. I think that's what we were sort of thinking would be in the report, but there's only one such example. So why not give more? I don't understand. What's your reason for not elaborating on the other 16 cases?
As I just said, this is an example. I gave it for an educational reason, and I haven't given any other examples.
Well, if you want, I mean, you said this is an educational report. Why not provide that level of information? I mean, you can redact anything that's private. Nobody needs to know the specifics, but it would have been of great interest, I think, to this committee, to the public. As you say, there's a lot of misunderstanding and people don't understand the processes. Well, this was a wonderful opportunity perhaps to actually list out the 17 examples and be a bit more clear as to what these discretionary grounds are, or evidentiary grounds. I think that's been very specifically put in there, Ms. Dowling, to suggest that perhaps is what really is the crux of the issue, but it may be just a one-off in this particular example as opposed to all the examples. Can I just refer also very quickly, if I may, to the article? I just want to touch base on the article that appeared in The Australian. So on a separate matter, I just wanted to The Australian yesterday. That's the Why Are We Here article, which I understand my colleague asked the Attorney General earlier about. In there it says that I think there was a the lawyer in question there filed a no bill application prior to the trial calling for the prosecution to drop the case, and that was then rejected. Is there a process for how that, it was rejected by the Director's Chambers, that's what's quoted in here, so assuming the DPP then has rejected it. Is there a process for review for that? How do you deal with a matter, an application? Is that just a matter that's determined at that point, or?
The process is the same one that's actually described in the sexual assault review, even though that's not a sexual assault matter. An application is made by an accused person that there be no further proceedings. The solicitor with carriage, the prosecution team, then prepares a report. Obviously, as you will know from reading the report, from reading the review, only the director or a deputy director can discontinue proceedings once they've been committed for trial. So the prosecution team will prepare a report. It will come to Director's Chambers. A senior legal advisor will then do a second report, and it will go to either myself or to a deputy director for consideration.
In that case, that would have as well, that particular trial that they're referring to yesterday? It's the same process?
It's the same process in every matter.
All right. Do you think that warrants any review of that process?
No.
In light of what happened in this particular case, or?
What I'd like to say about that matter, under the Crown Prosecutors Act, Section 5, Crown Prosecutors conduct and appear as counsel in proceedings on behalf of the Director. Crown Prosecutors are obliged to act on instructions of the Director, and they have no power to discontinue or not proceed with a prosecution that has been committed for trial to a higher court. And that's Section 5, Subsection 3 of the Crown Prosecutors Act. Subsection 3 explicitly provides that a Crown Prosecutor does not have the function of determining that no bill of indictment be found or directing that no further proceedings be taken against a person. Only the Director has that function under Sections 7(2)A and B of the DPP Act, and under Section 33 of the DPP Act, that can only be delegated to a Deputy Director, hence the process that I have already explained to you. An individual Crown Prosecutor who feels or considers that they have an ethical conflict arising from a direction to proceed should raise that conflict with the Senior Crown Prosecutor or with Director's Chambers, and if it can't be resolved, then the matter will be rebriefed to another Crown Prosecutor.
What, if they have an issue with it and it's in conflict with what the Deputy Director is
it'll be rebriefed.
It'll be rebriefed. Okay. Can I? Yeah. Okay. That's interesting. Do you think that there's room for any legislative change in that regard then, or not? I mean,
No,
you're citing parts of the Act and saying that they're constricted by that, or constrained by that, I should say.
No lawyer in this state.
Point of order?
Just asking. It's nothing.
What's the
No,
point of
debate.
order?
sorry, Chair, but I think the Honourable Tanya Mihalik is asking for
Sorry,
an opinion.
I can't hear you.
I think an opinion is being solicited from the witness, which is not in accordance with the procedural fairness resolution.
You want to rephrase
Miss
the
Dowling is
you want
fine
to
to answer
rephrase
it.
the
It's
question?
just an opinion. I don't think there's anything in there that's very controversial.
Well, it's not appropriate to
Dowling?
ask for opinions. You want to rephrase the question, perhaps?
Well, I think Miss Dowling was happy to answer that. I'm just interested to know what's the process of review and the process that happens at that point. Miss Dowling's explained it. That's fine. I'm happy to leave that that level of questioning at that point. But and I'm not going to. Well, I actually have a couple more questions in relation to that. But well, Ms Dowling, can you maybe tell me why your office actually opposed the no bill application, but later admitted in opening that the matter had no reasonable prospects?
The reasons for decision making are privileged, and I don't propose to waive that privilege.
I might leave that.
Okay, thank you.
Thank you. I'll start a bit early. Can I just ask, we're just heading back to the bail youth laws and the Attorney General's legislation. What is the department recommending in terms of any matrix? Is there any matrix to measure the effectiveness from a crime reduction perspective? I'm looking for just any mechanics that might have been.
It would be the only mechanism akin to a matrix would be the Boxar
reporting. So what do you, in terms of what would the department normally look for measuring success, failure, concern, or does it look? Is it looking for that, or I suppose what the counter to what I'm saying is, I'm looking for some understanding of. Is it the fact that maybe the government has said this is what it's doing, and then that's it, or does the Department of the Attorney General have a follow-up role in relation to what the Attorney General has done through passing the legislation and amendments to the bail laws?
We would rely always on the evidence forthcoming from Boxar. Boxar, although a part of the department, has as you'd be aware from over the years, a degree of empirical independence. It's the empirical integrity of its work is highly respected.
Absolutely, we'd be lost without them.
But we do rely on Boxar. If I think across key areas, I think of, for example, DV, reform, coercive control. There is a conversation that happens with Boxar, not just with a view to instructing Boxar to do particular work, but there's constantly a dialogue about the most effective way that they can report and provide evidence to inform policy processes and the impact of lead reform.
So on that basis, has Boxar provided any advice about what it's doing in terms of measuring, or has it been asked to measuring any reduction in crime and the effectiveness of locking up kids on remand? And I'm asking this because clearly Boxar has reported, a 34.4% increase in young people on remand is in 1 year's time.
is, I would suggest, is unprecedented. I could be wrong, but I would suggest that's unprecedented. Have we ever had an entire 1/3 increase in the incarcerated figure, i.e. young people being placed on remand? Have we ever seen an increase in such a short period of time ever before? Are you aware?
Look, Ms. Hickinson, I'm very happy to take that on notice.
Okay.
I'm reluctant to speculate, which is what
Thank you.
I would
I think it is something that if we haven't considered that question, Boxer put this report on the table in December, or maybe perhaps it only surfaced in last month or this month, but a remand population increase of 34.4% in 12 months seems astronomical to me. It would seem astronomical, would it not?
Yeah.
Or are we all sitting around going, oh yeah, that's pretty normal?
I mean, just if I can just supplement that answer slightly.
Yes.
The other mechanism that there is the Bail Act monitoring group, which operates within Mr. McKnight's area. It also has a responsibility to monitor the operation of the bail system and the enabling legislation.
And so in that system right now, is anybody ringing alarms or flashing buttons or squealing, or is everyone just going, oh gosh, yes, this is precisely what we expected, here it is, we've got a 34.4% of young people behind bars, or refuse bail, which means they're behind in remand? Is the bail monitoring group expressing any concerns, or do they have a reporting channel?
Perhaps I can help a little bit. I guess if I can speak generally about policy development and what goes into that process from a departmental perspective, obviously we look at all the points of evidence that are available. So for in relation to Boxer evidence, Boxer are monitoring remand rates, general detention rates, they are monitoring court appearances, they are monitoring police activity in terms of warnings and cautions and the like, and all of that is publicly available, as you note.
I can see
indeed.
it. Yeah.
They are also looking at crime rates overall and monitoring crime levels. When we look at policy development in the round, we're looking at all of those figures and we're monitoring them. And when an issue like youth crime is on the agenda, you might imagine that we're looking at those figures
So
carefully over time.
Can I
We're
ask
also
what that
looking
looks
at
like? What do you mean we're looking at it? What does that, like, do you meet internally? I'm honestly really perplexed, and I think the world would like to know, because we are talking about young people, and let's be realistic, we are talking about Aboriginal young people in really high numbers here. And we've got, I know there are some members of the community saying some things, but the overwhelming most of the community are just alarmed this is happening on our watch. So what does it mean when you say we're looking at this? So when Boxer, so what happens? Do they say, Attorney General's Department, Mr. McKnight, here's our latest Boxer report? And then do you get a briefing from them, or do you just look at it? And then what do you do?
Well, our principal function, well, one of the principal functions in my area is the provision of policy advice to government. So at government's request, or sometimes at our initiative, we provide policy advice. So that can include a kind of diagnosis of what the world looks like from a particular perspective. And I'm speaking generally here, I'm not speaking about this particular issue.
I mean, if it's possible to speak to this issue without doing anything wrong in your role, and would never want you to do anything wrong, but I'm interested in this issue and this policy.
I understand. But you'll also understand I can't canvass the kind of advice that we give to government. That is something that we provide to government, and I can't express views about policy in this context. I'm constrained by the Premier's memorandum. We're pretty diligent about the advice that we provide to government to try and give a true picture of what's happening in the world and to provide them with a range of options for what they might do about that in the round. And it's obviously a matter for government to determine what its policy positions are.
So it's
But
fair.
we're
It's fair
pretty
then to
active
assume. So
in
it's
these
fair to
spaces.
assume that when the Boxar, you saw the Boxar data and went, gosh, 34.4% increase in young people behind bars in New South Wales. It's fair to assume you would have thought that that was something the Attorney General needed to know of a matter of priority and to understand what his policy has done.
I think the Attorney General this morning was pretty clear about how much time and energy he puts into this policy issue.
So then, as an advisor on such matters, where do we look for? When do you think we might see what I suspect the government wants to see, namely this massive figure on the scales weighing everything down, justifies somehow? I suspect it never will, but the crime rate. Where that's happening? Is that the matrix you're looking for, or the Attorney General's looking for, or?
I'm not sure I understand the question
Crime
entirely.
rate. Crime rate comes down. Youth crime, offending stops.
I think the
or
government's
comes down.
made it clear that it's looking for reductions in.
But it hasn't seen any yet. Is that the evidence that I couldn't quite get what the attorney was saying.
I haven't got the crime figures in front of me, but I think the attorney took some of that on notice this morning. So
okay, so just to be certain and clear that information is coming to the committee, is that something that you can provide to the committee? Some understanding of what we're all staying up at night over and biting our nails to the quicks over, and understanding we're locking more kids up for what are we looking for in terms of crime rate?
I think I can take that on notice.
Thank you.
Position?
Ms Dowling, if I can just follow up some answers you were giving to Ms Mihalik before. You were discussing Section 5 and also the ability for a Crown prosecutor who felt that their ethical duty was that they can't bring a matter that they don't believe has reasonable prospects of success, could discuss that with Directors' Chambers or a senior Crown. How often does that occur?
My answer was who feel they have an ethical conflict.
Yes.
How often has it occurred?
Yeah,
since I've been the director, it has not occurred.
So in this matter, the Crown who said to the judge that there was no way that the case could be made, there was no prospect of success, hadn't raised that previously with somebody in the ODPP?
The Crown prosecutor had not sought to return the brief.
Okay. Are you concerned then that there may be some cultural issues that meant that the barrister felt that he was unable to have that discussion, even though you acknowledge that it is perfectly appropriate?
No, I'm not concerned.
So what do you think happened in this case, that you had somebody who didn't have that discussion with you, but yet is in court saying, we can't make the case, Your Honour?
I don't want to speculate about what was going on in that Crown prosecutor's head.
And what steps have you taken since that matter to make sure this situation doesn't recur?
The obligations upon Crown prosecutors under the Crown Prosecutors Act are well understood, I think, across the organisation. So this is not a common occurrence.
No, but it has occurred, and so what steps, what training, what meetings, what have you put in place to make sure that whatever happened here doesn't recur?
I have asked the Senior Crown Prosecutor to remind the Crown Prosecutors of their obligations and the limitations on their functions under the Crown Prosecutors Act.
Okay. And you've had any communication following that reminder?
I'd have to check that.
Okay, thank you. And then I understand that in that matter there was an application for a no bill, and it was the decision of the ODPP not to no bill that matter. and you indicated that you couldn't provide reasons because it was privilege. What's the privilege you're relying on?
It's legal professional privilege that vests in me as the client.
So I guess what I'm trying to understand is you're asserting what solicitor client, barrister client professional privilege, but aren't you also the decision maker in this matter? Who decides whether to no bill or not?
In this case, I believe it was a deputy director, and I think at last budget estimates I explained to you how client legal privilege works.
Yeah, and I'm trying to explore this because there are a lot of questions about this. So frankly, I don't see what the privilege is, and now that the matter is closed, why the privilege would continue.
Well, privilege doesn't abate because a matter has finalised.
Isn't there significant public interest in use by a statutory office of taxpayer funds in this matter? And isn't there significant public interest in why the decisions were made that led to this? Because it's not only the money to prepare the matter for trial, it's now also the money to pay for the defence costs as well.
Is that a question?
Yes, it is. Isn't there significant public interest?
That's a matter for you to assess that. I can't answer that question.
So you don't believe that the public is interested in how money is spent in the preparation of cases, and when a matter gets to court, the Crown, who has responsibility for running it, says, we can't prove the case, Your Honour. I mean, what's happened in the decision-making process along the way that a matter like that even gets to court in the first place?
I'm not sure what your question is.
What has happened in the decision-making process in your office along the way that a matter like that gets to the court in the first place?
Well, I'm not prepared to give any more information about the decision-making in my office in relation to this particular matter. And I think
why not?
Because it is privileged. And it's also the conventions of this committee, as I understand them, that particular decisions made internally within my office in particular matters won't be the subject of questions under privilege.
I'm not aware of that convention, but so the privilege you're relying on is what? Client legal representative. Who's the legal representative?
The lawyers involved in the prosecution who are giving me
And you're the
advice.
client?
Correct.
And so the Crown prosecutor, who thought the case couldn't be made, and you the client, but you're also the decision maker in this case, aren't you? So does the privilege analysis fit in that situation?
Yes.
Do you have anything, like why are you asserting that when you're the client and the decision maker? Because in a typical matter, Mrs. Smith can't say to the barrister, do run this matter, don't run this matter. You're not the typical client, are you?
I disagree entirely with that proposition. In the typical matter, a client does instruct their lawyer as to whether a matter proceeds or doesn't proceed. And those instructions are privileged.
Okay. Well, I think we will have to agree to disagree, and I think that there is also an interest as a statutory office holder and the public interest in how money is being allocated and allocation of resources. Yeah, John.
Thank you. Ms. Carter just allowed me to have a couple of minutes because I need to get going. Ms. Dowling, just on the same sort of similar matter, but back onto this report, I think I asked you earlier to provide, to take on notice the full costs and fee that will be associated with both Sir Hill and the professor that are reviewing it. Could you also provide what the hourly rate was agreed to, and whether any payment has been made to date, and what you expect will be the final payment, and whether there was an agreed cap? I just want to get the parameters of what both Sir Hill and for the professor in question. So that's all I want to add.
Oh,
thanks.
Sorry. Ms. Dowling, at the time of the circumstances becoming public that gave rise to the audit of sexual assault matters and the completion of the audit, were there any sexual assault matters in addition to those 17 that were discontinued that were no-billed?
As stated in the report, report, there were some matters that had already been referred for consideration prior to the report.
And how many of those were there?
I'd have to check that.
Could you please? Thank you. Do you have it available to you now?
I
or-
don't. I'll have to ask.
All right, and you'll provide it before the end of the day, or?
I don't know. I'm sure it's in there, but...
Okay, well then perhaps you can provide it before the end of the day. Is that possible?
The witness has taken the question on notice, as she's entitled to do under the procedural fairness
Okay,
resolution. I just asked the member move on.
These matters were no billed, and they
Noted.
were in addition to the 17 matters that were discontinued?
I'll come back to you with a correct and detailed answer.
Okay, well, could the answer include if they were in addition, and could the answer also include whether they were no billed at the request of the defendants, or whether they were no billed as a result of the exercise of your discretion and without the request of the
I
defendants?
won't be able to answer that last
Why
part.
not?
Because I don't have that readily available.
But if you're taking it on notice, you don't have to, you can provide
I'm so
it after
sorry.
you've
I
looked at
thought
it.
you wanted it today.
I would like it today, but if I can only get that at a later date, I'll happily get that at a later date, Ms. Darling. As you said, we want accurate information. In terms of the matters that were discontinued as a result of the audit, were there any special, was there any pattern where there were perhaps certain areas, certain offices, certain courts where there were more matters no billed than others, no matters discontinued than others?
No, we didn't find that.
Okay, so you wouldn't say, for example, Campbelltown Court, there were more matters discontinued than anywhere else?
No.
Okay. And was that something that you were looking for in the audit?
We were looking for systemic patterns and trends.
Right. Okay, thank you.
Okay, we might have a break now and come back in 15 minutes
I'm sure Bob has searching
for
government
afternoon
questions.
tea.
Holding till like 5 o'clock.
Yeah.
I don't really follow.
We're back. Okay.
Over to you.
Right, thank you. Ms Dowling, if we could just finish off the questions that I had before. The audit, are there any plans to have an ongoing system of audit and review?
No,
Because?
because there aren't any.
Okay. Any thought being given to that?
The system seems, our conclusions are that the system is operating effectively. As you will have noticed, the rate of discontinuation of matters hasn't changed over the last 5 years and probably for longer. So we are constantly striving to improve our processes and to minimise the number of matters that are discontinued after certification. But a review of this kind is extremely resource intensive and is not the best use of the limited resources that we have. We would be better off spending that money attending to the matters that we have to run.
What was the total cost of the review?
It hasn't been costed, but you can see that there is a list of the resources that were allocated, the number of prosecutors, deputy senior Crown prosecutors and solicitors, and the number of documents that were reviewed, and it was considerable.
And you just said then, I believe, that you were working to reduce the number of matters discontinued after they've been charged certified. On average, how many matters get to charge certification and are then discontinued?
In sexual assault matters or all matters?
Well, perhaps sexual assault and then others.
Well, that's the subject of the review. This looked at matters that had been certified. So it's about
You seem
18
to indicate that you could provide both answers, so I was keen to get both.
I'll answer it now.
Thank you.
18% of matters on average over the last 5 years are discontinued after certification.
Because that seems quite a lot, because when you think about how far down preparation a matter is for charge certification to occur, or you think you're comfortable with that?
The whole of this report is directed to a discussion of the processes of our organisation to ensure that the prosecution guidelines are complied with, and the 75% of matters that are discontinued for discretionary reasons rather than evidentiary reasons.
So 75% of the 18% are discontinued for discretionary reasons.
Correct.
Could you help me understand what is meant by discretionary reasons?
Yes, it's explained in the report in detail at page 11. Discretionary reasons may include where a complainant is no longer willing or able, either mentally or physically, to participate or cope with the stressors of the criminal justice system, where the continuation of proceedings would be unfair, where two juries have been unable to agree on a verdict and there are not exceptional circumstances that would warrant proceeding with a third trial, or otherwise proceeding would further be oppressive, where, although there are reasonable prospects of conviction, a trial may be unfair, for example, because disclosure obligations are unable to be met, or where there's a combination of matters relevant to the question of whether proceeding with the prosecution is in the public interest, including the matters that are set out in chapters 1.4 and 1.6 of the prosecution guidelines.
And so concern about whether or not consent or lack thereof could be proved, that would be evidentiary?
That's correct.
Right, okay. When multiple charges had been laid subject to the audit, were they all withdrawn, or were there cases where matters were discontinued? So some of the charges were discontinued but other charges proceeded?
That's the latter.
Okay. And do you have any figures on how many proceeded with some of the charges being withdrawn?
I'll have to come back to you on that. It is contained in the report.
Thank you. That would be very helpful. And the response of the victims whose matters were not proceeded with as a result of the audit, have you had any conversations with any of those victims?
So, again, as outlined in the review, the obligations of the ODPP's staff to victims, which is set out in Chapter 5 of the prosecution guidelines, were complied with. And in particular, the obligation to consult any complainants whose matters we were considering discontinuing was
So
complied with.
does consultation mean inform, or does consultation mean have a conversation or have correspondence with prior to the decision being made?
It's set out in detail in Chapter 5.6 of the prosecution guidelines. The victim must be consulted prior to making any of the following decisions unless they've expressed a desire not to be consulted, and that included in those decisions are to not proceed with some or all of the charges. Consultation with the victim regarding charge resolution requires an explanation of the full implications of proceeding on fewer or lesser charges. In advising a victim of possible discontinuance of charges, a summary of the reasons why discontinuance is being considered should be provided.
And
Victims
you're
must
confident that every victim whose matter was not proceeded with has received that summary?
I am confident, yes.
Because I have received correspondence from some who believe they have not received that.
Is that a question?
I suppose I'm asking you to check your recollection and check your understanding.
I can't respond to that without any further details.
Well, perhaps you could take it. Well, I will inquire whether my correspondents are happy to have their details shared, and perhaps you could check on notice that has been provided to everybody in that category. In terms of the victim's right of review policy, what's the time frame for a review conducted in accordance with that policy?
I believe it's 28 days.
Sorry, what was that?
I believe that it's 28 days. Let me check.
I thought it might be 20 working days.
You may be right. 20 working days.
20 working days. And how often is the time frame for that victim's right of review policy not met?
I'd have to take that on notice.
Could you take that on notice and provide details? Thank you. And so just confirming again, subject to you checking, you believe that all victims have received a full statement of facts and reasons for the discontinuation of any of their matters?
I'm sorry, could you repeat the question?
Okay. I was just really confirming your earlier advice that subject to you checking your records, you believe that all victims have received a full statement of facts and reasons for the discontinuation of their matters.
The Chapter 5.6 of the prosecution guidelines provides that a summary of reasons as to why a charge will be discontinued, why a discontinuation is being considered will be provided.
And you're confident that they have all received that summary of reasons for discontinuation?
I am confident, yes.
Sorry, it's hard to
I
hear.
am.
Thank you very much.
Thank you very much. I actually might ask a couple of questions regarding the Morey response and the government's press release from March last year. So in it, one of the plans was actually a development of an action plan within 6 months to optimise the service delivery in Moree to ensure that services provide maximum benefits to the Moree community, including much better coordination, accountability, improve the availability of nighttime and out-of-hour services and youth places. I was wondering if that action plan has been produced. Would you like a copy of the release?
Yeah, that is being coordinated by the Premier's Department.
That's okay.
Yep.
I'll ask that. In relation to one of the other items that was listed, which was the first one, under initiatives, additional judicial resources for local children's courts jurisdictions, including associated legal aid, Office of the DPP, police, for 6 months and additional legal service funding. Interested to know how much funding has been allocated for that or for judicial resources.
I'm going to be way more accurate if I provide that on notice.
Yep, that's fine.
That's okay.
My final question before I hand back to my colleague is actually one for Ms. Campbell. Oh, yay. Well, you've been here all day. It's actually following up from questions from last year in relation to the Justice Reinvest sites, Kempsey and Nowra, and the Paul Ramsey Foundation. During questions, you mentioned that they had engaged Taylor Fry to undertake an experimental evaluation of both sites. Interested to know if that is commenced and the time frame, and I presume the department will be advised of that evaluation.
Yep, that's correct. So following the development of the Memorandum of Understanding, which is called the Monitoring, Evaluation and Learning Framework, they are looking at an economic evaluation will be carried out from this year through and report on in 2027 to look at the impacts.
Okay. Do you know when in 2027?
I'd need to take that on notice.
That's fine. Thank you. Thank you.
Mr. Tidwell, I wonder if we could go back to something we were discussing earlier with the attorney, and that's in relation to this issue that's being described as cell ramping.
Yep.
And the attorney seemed to have three possible reasons for it. One is clearly resourcing at the Metropolitan Remand Centre. The attorney seemed to suggest that one may be...
That's our time, you'll come back to
Oh, sorry. Yeah.
It'll come back to you.
Okay.
I know.
Yeah, a change in... And
If you
the-
want to, sorry.
If you want to answer it.
Do you, so look,
Yeah, go for
Sure.
it. Because
Yes.
So I had-
so
I had
the
very-
third bit I'm really interested in
So
is
I
the
have
bail.
very clear advice from the police that there is... What was the point? Sorry. Yeah, that the numbers of PBR matters from Metropolitan City have not spiked since November 24, since the whole state centralisation. I did, and I repeat what I said in my evidence this morning, I have had this matter raised with me directly by the police commissioner, and it was raised, and I followed up on it, as I indicated this morning, with corrective services. It was very much perceived to be not about the police end, but a corrective services, a challenge with corrective services. Corrective services are actively engaged, and I don't have up to the minute knowledge on that, but I took it on the evidence that, because I do have some knowledge of it, as very much being something that corrective services needed to work with the police on, as opposed to the PBR loading.
Yeah, I wonder, could I ask you to take on notice and perhaps inquire, because I understand that because of the centralisation of bail decisions, there are technical difficulties in getting all the absent a system that can digitise. We're talking about faxing paperwork through to courts, and that can take some time, and there are sometimes sort of cut-off windows being imposed, and if you're not arrested before the cut-off window closes, you're on the next day's list. And there's certainly reports of people spending 60 hours in police cells, and in some stations there are no cells, so you're spending all that time in the dock. The information that has been shared with me is that, as the attorney suggested, there are multiple causes, and bail magistrate delays is definitely one of those causes.
So people being held in cells, police cells unnecessarily, clearly that is a concern. I would also be open to, so I'm unaware of it from the briefing that I've had. If there are specifics that would assist my inquiry, I'd be very open to receiving those.
Perhaps we can talk later. Yeah.
Thanks.
Thank you.
Thank you. I just wanted to turn to the notion or the common law principle of Dolly incapax, and whether or not the department is currently preparing any advice on that, or has prepared advice on that, or has standing advice on that common law principle at the moment.
Dolly incapax comes up from time to time, and we provide advice to government when we're requested to do that.
And is it, in terms of, given the climate right now, and with the calls and
the very misguided calls to interfere with that common law principle in New South Wales, consistent with other states, the same thing, is in providing advice, is the department inclined to talk or consult or engage with other members of the community who are expert or on the front line of working with that, namely the Aboriginal Legal Service, the Law Society, the Bar Association, and some of the youth advocacy organisations? Is that what you would do? Or
we talk with those stakeholders and other stakeholders about criminal justice issues all the time.
Yes.
And should we be asked to consult stakeholders in the preparation of advice by government? We certainly would.
I think what I'm asking is, would there be an inclination or an appetite, given the misguided, heightened nature of the issue at the moment, that the department itself would... is there a process where the department themselves internally can say, this is something we should consult on? Is that the machinery, or?
This is we work as public servants in a Westminster system. We serve the government of the day.
But I think don't you have to be frank and fearless? Isn't that part of
the? And we are frank and fearless. You can believe that, but I'm not going to canvass policy advice that we provide government.
No, I accept that. I suppose what I'm saying, what I'm asking is, are there circumstances where there is such a heightened public interest, and we're talking about life and death, obviously, with the criminal justice system, particularly locking up young people, is that a circumstance that might drive, or it's happened in the past, where the department themselves, who are dealing with this incredibly important advice, would they provide a recommendation that, hey, in order for us to really advise the government, we should speak to these organisations on this particular thing? Does that happen?
We are often called upon by government to advise on the proper processes to follow and the right way to consult stakeholders, and we provide that advice. Yes.
And so, can I ask? I know, and I know I'm pushing it, but I'm trying to stay on safe. I'm honestly trying to stay in safe territory for everyone. But in terms of past advice, is it fair to assume that any advice on Dolly Incapax that might have been given from time to time that's a principle that's probably best left untouched, given the fact that it still exists and it's never been touched?
You're asking me there to canvass policy advice that we give to government, and I can't do that. I would just note, though, we take very seriously our obligation as policy advisors to provide government with the fullest picture we can of all the policy issues that we look at, and to provide frank advice based on the evidence. It's something that this department takes great pride in.
Are you aware of any advice at the moment that's available, or any studies, not advice, any data, any studies, any examination of discharging with the common law principle of Dolly Incapax?
There's a lot of evidence and views reported out there about Dolly Incapax. There is an evidence base, if that's what you're asking.
That's right. I vaguely remember reading stuff in law school millions of years ago. But is there any, is there any that you're aware of? Are there any kind of compelling research pieces at the moment that would say discharging or removing or lessening the current common law principle of Dolly Incapax? There's evidence to support that. Are you aware of
I'm not
anything?
aware of any studies that are published to that effect.
No, neither am I. It's interesting. None at all. and that. Thank you. In terms of
that doesn't, of course, mean that
it
there
do-
aren't any.
No,
but
I'm just curious.
I'm not.
Yeah. I mean, well, can I ask, have you actively sought out those, or at this point in time, or not necessarily? There hasn't been.
I can take on notice what research we've done in this space.
Thank you. That would be really helpful. Are you aware, is there any work that is happening at the moment in terms of measuring the impacts of the government's measures? And I recognise maybe I'm going to end up in a different budget estimates with you, Michael, Tibble, asking the same things, but do we have measures about ways of assessing the effectiveness of the other diversionary measures that we're investing in around the state with youth justice at the moment, and the specific new ones that the government announced over the last 12 months?
There will be, I believe, and particularly with the witnesses that are attending Minister Dibbs' estimates, I think, on Wednesday.
Yeah.
I think there will be there'll be a good opportunity for them to talk about.
I'll take it up with them.
Evidence, yeah.
And then any outcomes work that they generate, will that feed back into the advice that ultimately goes into looking at the continuation of the laws that the Attorney General's introduced and passed, the bail changes?
As a general proposition, in the criminal justice space, both adult and juvenile, the two things which I can say fairly confidently are that we look to Boxar to provide empirical integrity and rigour, the evidence that we need to inform future decisions. The second thing I would say is, both in Ms Campbell's area and in the youth justice and adult offending realms, when programs are funded and commissioned, we, as a general principle, look to evaluate them, particularly where they're new.
I think I get all of that. Okay. And so then, in terms of the impact of the youth bail, in terms of the bail laws, is there a process for, through the bail monitoring group, is there a process? Do the bail judges feed back into that? Is there a process? Is that a live process or not?
So the
magistrates and judges who are administering these new laws.
So as we assess the impact of you're talking here about 22C in particular.
Yeah.
I mean, we've been monitoring youth justice detention rates. We will be looking at crime rates. We're watching the courts and monitoring court decisions, and all of that is being fed into the process.
And so at the moment, when I know the attorney said the extra 145 kids there.
So just to be clear, that's 145 bail refusals of children who fit into 22C.
That's right.
That's not necessarily extra remands that would not have otherwise occurred. The children in that group before the advent of 22C had already been being remanded in custody at a higher rate than others. So it isn't the case that without 22C those 145 children would have got bail. It's because the situation of those children is they've been charged with serious offences and they are on bail for serious offences, so they're back in front of the court. A group of those children were being remanded prior to the 22C changes anyway. I think our assessment would generally be the 22C has increased that number, but it isn't the case that 145 children would have been on bail.
And so,
just to be clear.
No, I understand that, but now they're sorry. So do you actually have that breakdown? Do you know how many because of 22C?
There's not a counterfactual that you can measure it against because 22C passed.
How can you say with so much certainty they would not, but for 22C, they would still be on remand?
Because the remand rate for that group of children prior to 22C was very high.
But yet we've got I see. Okay, so
it's
the
33 point in time.
So the 33.4% is the year-on-year increase.
The
What was
the
it last
34% year-on-year increase isn't just 22C.
No, well, because 22C wasn't in December, so I get that.
But you'll see from the same fact sheet that the contribution of people to the contribution of people on 22C type offences is quite high. It's the unlawful entry burglary. It's 22 that accounts for 22 people in that change. I mean, we're coming off in the youth remand area. We are coming off a low base. We had got to very low numbers of people in detention, which was an achievement.
Can I ask all of you to read the article from the New York Times? Will you all read it, please? There's a podcast too. You can listen to it. It's one of those kind of mid-length reads. It's really. I could table it. I will happily table the article, but you can, if that's okay, I'll table the article. It's this idea now about, for some reason we did achieve some really good things in terms of getting the youth incarceration rates low. Even America did that, and now it's just coming back up because we've changed the approach for whatever reasons. Can I just ask as well, though, when the attorney said those young people are around the state, do you have a breakdown of the areas that the young people are held? Not so much the centres where those crimes were committed.
It's not in front of me.
Would you mind?
Yep.
And I'm really, really happy for it to be, this cohort we're talking about, that 145. I don't, just to try and get a snapshot of, the last 12 months where it's happened. That would be so helpful. Thank you. And then. In terms of, so one of the things that I think that we are hearing is this idea that, things have changed in the community, and I'm just wondering whether internally in the department you are, the justifications for the increase in crime, that you have some lens on that analysis, and whether that's something you can share with the committee. Because we read things in the media, and obviously that's an incredibly limited lens. We speak with people in communities, and obviously we all speak to different people, but I'm just curious about what the department, the informing principles of the increase of crime that the department is, the supposed increase in crime that the department is working with.
Are you asking for some analysis of the causation of the crime? I think we can definitely provide some richer picture from Boxhard data about the nature of crime levels and the contributors to the youth detention population and how that looks. So I can take that on notice.
Yeah, that would be really helpful. I suppose what I'm trying to prod as well is, because I mean I can look at those things and I can see those things, but I think what I'm trying to understand, the attorney came with an article today from 2014 that talked about all of the causes of crime. He made the case that those causes were there then, they've been there, and they will be continued, they're still there, and they're going to be there into the future. I'm still just looking for this kind of more material, objective, the inputs that have justified the response to changing the laws and justifying putting more kids into remand and incarceration. So I'm just curious if the department has information or inputs into that that justification base that we don't have, or that I don't have, or that others don't have. And if not, that's fine. If you're just working on those things alone and instructions, then I accept that. But I'm just, is there anything that we're missing in terms of
Look, it's certainly the case that our advice canvasses kind of individual and community influences on offending and reoffending, and what, generally speaking, our advice would have a much more solution focus to it. So not so much an unpicking of the etiology, but what works to solve the problem, and that's, I think, a different way of answering the question that you are. What would we do to reduce crime? It's sort of the same question that you're asking, but from a different angle. And our advice would canvass the evidence base about how you might address crime in the round. Including the criminal justice system responses and other responses to crime. So I think, I mean, I'm not in a position to provide you with the advice, obviously.
I get that. Yeah.
But I think that that's how we would look at the question you were asking. What would you do to reduce crime rates, and what options do you have in that space?
So
and
then,
that sort of necessarily goes to etiological questions, because you're looking at things like, mental health issues and victimisation.
But are we not? I'm just curious.
And the
then,
criminal justice system itself.
Yeah. So I'm curious then about, and clearly I've got some blockage in my mind, but I'm just curious about where we cut, what the time frame we cut when we're talking about criminal offending. So the evidence that placing a person in incarceration is criminogenic and therefore will make a person more criminal. What is the assumption that won't happen? What time frame are we looking in order to assess the effectiveness of reducing crime? I still just can't ascertain anything tangible that that we've put into the matrix to suggest that that this will reduce crime. I'm just still not quite hearing one. Is there something, like, is it a period of time frame? So we're saying, well, we'll reduce crime tomorrow if we change the bail law, but we will create more crime possibly in 3 years' time, or
I'm not sure I can respond to that.
I think, Ms. Higginson, I hear the messages and I hear the thinking. Clearly, we talk to the police, we talk to heads of jurisdiction. In the course of my work, I try to travel across the state. There are a number of observations. There is no shortage of perceptions and anecdotes. At the end of the day, though, we respond to the requirements of government when it comes to policy formulation, but we have a discipline and we have governance around that. We have a trove of empirical tools that we use and interrogate, and I can assure you that our advice, as it should be, is frank and fearless. There's not really a lot more. I'm unusually quiet, I know, but there's not much more that I can proffer at this point.
No, thank you. I feel like I've gone as far as I possibly can, and I'm very grateful to all of you. Thank you very, very much.
I've just got one question in relation to the place-based response to Moree, and it's to ask which minister's responsible for one of the dot points, which is the young Aboriginal people would be linked to Indigenous organisation, elders, cultural and family support with staff on site 24/7.
So of the the Bail Advocacy Service is actually run in partnership with the Aboriginal Legal Service, and the Aboriginal Through Care strategy is similarly with ALS, as is the Therapeutic Pathways for Children partnership.
It's the Bail Accommodation Service that she's reading.
Right. Yep. Okay.
And it all comes under the AG, or
Youth Justice.
Youth Justice.
Yep.
A couple of questions for you, Ms Dowling. Going back to the matter that I raised with Mr Death earlier in relation to the matter that was conducted in the Children's Court where details were made available to Ben Fordham on 2GB. The general public's not allowed into the Children's Court, so who would be the people who would have knowledge of the matters happening in the Children's Court?
Well, Section 10 of the Children's Criminal Proceedings Act provides that any reporter can be in the court. Family members are allowed to be in the court. The proceedings
and is it your understanding that there was a reporter in the court?
The proceedings are not suppressed. The proceedings are just the general public are excluded.
Is it your understanding that there was a reporter in the court that day? Does the ODPP keep a system similar to that used by the ATO and other places that can track everybody who accesses the records of the ODPP?
Yes.
And so if anybody had accessed the report of that case, you would be able to determine that?
Yes.
Is it your understanding that police have commenced an inquiry into the circumstances surrounding that information being given to Mr Fordham?
Yes.
Have you been asked to cooperate with the police in relation to that matter?
I don't propose to answer any more questions or questions in any detail because there is an ongoing police investigation. I don't think that would be appropriate.
I'm sorry, I don't understand. If we're just saying, did you cooperate with the police, how is that inappropriate question to answer?
Well, I've given you my answer. I don't propose to answer any more detailed questions because there's a current police investigation underway.
So, but why aren't you answering questions because there's an investigation? This isn't sub judice. It's not a matter before the courts. The police are simply trying to determine whether the leak came from the ODPP or not. Surely you would be interested in making sure that the reputation of the ODPP is upheld.
Is that a question for me?
Yes, it is.
I am interested in the reputation of the ODPP.
And so therefore you would be keen to make sure you and all your staff cooperated to clear the name of the ODPP.
I'm not... I don't think that requires an answer.
I'm the one asking the questions, Ms Dowling. I think it does require an answer.
I'm not proposing to answer any questions that may impinge on any of the investigation by the police. I don't have visibility over that investigation. I don't know where it is at.
Mm-hmm.
I don't want to say anything that could impact upon the proper investigation of that by police. And I suggest you ask the police commissioner about it.
Well, I wouldn't ask the police commissioner about this, and I'm here asking you. You're a sworn witness at this inquiry. Are you aware whether any members of your staff have declined to cooperate with the police?
I'm just going to, I know there's no point of order raised, but I am just going to, if it's all right, use my chair's privilege here and suggest that perhaps the line of questioning is heading into a slightly inappropriate place, because the witness has made it very clear there is an investigation, there is potential proceedings, and we don't want to prejudice, jeopardise or do anything to interfere with that. So I would just ask you, Honourable Ms Carter.
I accept your warning, Chair, but to that, should any proceedings arise, they would be judge only. There's no question of polluting a jury pool at all. And this is really simply to determine whether all the members of the ODPP have cooperated fully with the police, and I think there's considerable public interest in that. There's been considerable press reporting of this matter, and I think it's appropriate that I'm not asking what was said to the police, just whether everybody has actually cooperated.
I mean, I think there is a kind of there is a broader place in terms of not interfering with matters that are under investigation, would be my point to make at this point in time, and just remind you that there will be another budget estimates. There will be a period of time where some time has progressed, and there will be more opportunity for the witness to be able to answer with some more certainty, more confidence that proceedings or investigations are not being jeopardised. I think, you know, we're all legally trained. I think that exercise of caution is something that we really should hold dear in these matters. So, I mean, carry on, but with that said, please.
Well, perhaps just two more questions then. Has the ODPP conducted a search to see who had computer access to the file in relation to the matter reported by Mr. Fordham?
I believe that has happened.
And that has been shared with the police?
I believe that's correct.
And if anybody had provided that information to Mr. Fordham, would that be consistent with their employment duties?
Any internal disciplinary proceedings arising out of this will be conducted once the police investigation has...
I wasn't asking about disciplinary
I'm trying
proceedings.
to answer your question,
Yes.
Ms Carter. So until the police investigation is completed, I'm not going to speculate about internal disciplinary proceedings.
The question, with respect, was not about disciplinary proceedings, but whether it would be a breach of duties of employment.
Disciplinary proceedings follow any breach of codes of conduct. So those two questions are entwined.
So do I take it then that because you are talking about the possibility of disciplinary proceedings, that it would in fact be a breach of terms of employment?
No, I wouldn't. I'm not prepared to say that. The
Well, then could you
investigation
please
hasn't
answer my
happened.
question? Would it be a breach of their terms of employment?
I don't have visibility over this event. I haven't conducted my office has not conducted an internal investigation, and I'm not going to speculate about the outcome of that until it's happened.
I'm struggling to understand why it's difficult to answer a question if a member of the ODPP staff leaks information about a children's court matter to a journalist. Is that a breach of the terms of their employment?
Well, it depends on their role, and it depends. I mean, I don't want. I take issue with the use of the word leak. For example, members of our media team are employed to talk to the media about the matters that we are running. So I can't answer that question accurately the way it's framed. In relation to whether there has been a possible breach of a code of conduct or terms of employment, I can't answer that either, because no internal proceeding has taken place, and it won't take place until the the police investigation has been completed.
So, if the police investigation had not commenced, would there have been an internal inquiry to determine the source of the information?
I can't answer that.
If the situation occurred again, would you be concerned to find out if there was an internal source of that information provided to the media?
Ms. Carter, I don't know what happened, so I can't answer that question.
I am asking you, as the director of a very important organisation with critically important role in upholding understanding of the rule of law in New South Wales, what your attitude is and what steps you take to ensuring the reputation and the probity of the ODPP is maintained at all times.
Everything I do is directed towards that issue.
Mm-hmm. And so, if you had any reason to believe at all that a member of your staff had provided information about a closed matter concluded in the Children's Court, would you have sought to ascertain who was the source of that information?
The Children's Criminal Proceeding Act prohibits the publication of the name of a child to a member or section of the public.
Yes.
Now,
I believe it's name or any other details which could identify.
To the public or a section of the public. So if I was of the view that that had happened, then I would conduct an investigation. If there was no police investigation, then I would do that internal process, and I will do that internal process once this investigation has been resolved.
I think the question I was asking you was slightly different. I'm not asking you to undertake a criminal investigation in your office to see whether or not Section 15 of the Act was breached. I'm asking in terms of the importance of maintaining respect for the office and confidence in the office, whether you would have sought to determine if your office was the source of the leak and what the circumstances of that were.
Well, again, I take issue with the use of the word leak, because I don't know that there has been one. This question is hypothetical and asking me to speculate about things that I would or wouldn't do. I can't agree with the assumptions that are implicit in your question, so I can't respond.
So with respect to your concern about my use of the word leak, could you outline circumstances in which you think it would be entirely appropriate? I think you said someone from the media unit may have cause to talk to journalists, where somebody from your media unit may want to, within the bounds of appropriate employment conduct, discuss a matter with a member of the press that had been concluded some months before and dealt with a minor Indigenous child.
I'm sorry, what is your question?
My question is, under what circumstances would you believe that that was appropriate? If we're not talking about a leak, then obviously this is an appropriate disclosure of information. When would that disclosure be appropriate?
It would depend on what the media question was. We get a lot of media questions, and we try to respond to them in a helpful way.
If there was no question, if this was information that was volunteered, would that be appropriate action on part of your media person?
I can't answer that question.
Thank you very much. Okay. Mr. Tidball, perhaps I could come to you. The New South Wales People Matter survey, what happens to that when it's done?
It is, so I'm not going to look at my note. I may need to go to my note, but just off the top of my head, there is a compilation of the report. It is on an agency basis, obviously promulgated or distributed to each of the agencies. In my case, the Department of Communities and Justice. There is reflection, and there is quite some analysis and deep diving that can be done through the trove of data that is the PMES, which is both sector-wide, it is also agency-specific, and then within the agency by there are a number of ways it can be spliced and diced, and there is a time of reflection on that. The executive leadership team of my department has a very focused session where it spends quite some time looking at that data and the messages which it and the learnings and the evidence that may give us insights that require a response.
Because, I mean, look, I don't claim to have done the deep dive that it sounds like you have, and I'm encouraged by that. But when you see, for example, the Crown Solicitor's Office, 59% of staff believe their senior executives listen to them, well, that means 41% don't believe they do. Is that within what you would expect? Is that unsatisfactory?
I would not want to, without benchmarking that figure, comment in these proceedings this afternoon. We do, one of the great things about the PMS is that you are well able to benchmark against averages, and that's what we do.
And what's the process for driving change if when you benchmark, these areas are found to be unsatisfactory?
Well, I think the PMS is an annual survey, and we have briefing made available to us, and we, knowing that the PMS is back on, in another year, we are very keen to look at participation, engagement, and other indicators, because aside from the well-being of our staff and the performance of the agency, we right across the public sector are operating in a very competitive marketplace at the moment with supply chain issues. It is a very, whether we're talking prison officers or child protection workers or lawyers or IT staff, those areas are each competitive, and in a highly competitive market, the proposition of work climate and the overall offering of employment obviously extends way beyond remuneration, and the heart of the PMS speaks to a number of those features that really do help us tackle a range of things, from well-being through to workers' compensation costs, through to recruitment outcomes, through to vacancies in areas where we want to reduce our turnover and generally improve the quality of our workplaces.
Because if we look at the Department of Communities and Justice as a whole, 43% of staff believe that senior executives listen to their employees, which can't be encouraging to you, I would think.
Again, I think I am strongly guided by our performance from year to year and how we track relative to the rest of the sector.
Yeah. In terms of employee satisfaction, I note that when we look at the ODPP, 45% of staff feel that they are mentally exhausted by their work on most days. Does that then drive extra workplace supports, or how is that responded to?
So I am reluctant to comment. The ODP is an independent agency. I work closely with Ms. Daley, and when she believes that there may be, as with Ms. Hitter, with legal aid, we've had a lot of discussions over the last couple of years about wellbeing of staff. I think there is shared wisdom and shared experience. We collaborate and we work together. I never make incursions into the related entities. I also feel comfortable to talk to agency heads, but it's very much done on a basis of cooperation and collaboration. And in fact, just thinking about some of the discussions we've had, Ms. Hitter, the learnings that we've had in both of our cases, both specific to the agencies themselves, but also looking at the unique psychosocial settings around legal practice and what that means for the way we support practitioners who have their own set of needs.
Absolutely. And so you're aware of the work that the Law Society is doing in this area, and
I was in another life, which I said on
course,
the record,
of course,
and
Mr.
potential
Tupel,
conflict
yes,
was
yes,
very
very well
close to.
aware.
In fact,
Yes.
I could speak at length, but
Yeah.
it's late in the day.
Yeah,
I'm intimately
understand,
and
yeah.
intricately aware of it.
No, I was just sometimes with surveys one is not so sure that they are active tools for development, and it's good to see that that's the approach. So,
Are you finished?
I have finished.
Okay. I think that concludes this session of budget estimates. Thank you very much to all you
thank you
government
all.
officers for your attendance today. The committee secretariat, as always, will be in touch in the near future regarding questions taken on notice and any supplementary questions. I thank you very, very much for your time and your patience with all of the questions today. Thank you.
Thank you.
Thank you. Thank you.
Thank you.
I'll check it.
I'm so sorry. Hang on. Are we still? Oh, really?
For next time.
No, seriously, Mr. Don.
No. Listen, I know. I'm not offended. No, my questions remain banked and will be good for next time.
Okay. I am so sincerely sorry. I was just racing ahead to the finish mark.
No offence, Tom.
Okay, thank you, all of you. That concludes the session.
Have a lovely
Thank you.
weekend. Thank you for everything.
Thanks.